Day 29 of the Aurora Theater shooting trial will begin shortly with 21 jurors taking their seats in the jury box instead of 24. Good morning, I'm Marshall Zellinger with Erica Tinsley and Brian Hernandez on Scribble. Phil Tenser is hanging around the newsroom as well. A little after 8:30 on, is it June 10th, right? Something like that? I'm losing track of days. June 10th, day 29, week 7 of the Aurora Theater shooting trial. And today, the groundwork has been laid for email to be presented in court between the defendant and his ex-girlfriend, which possibly means that the ex-girlfriend will also take the stand, because these they're laying the foundation to introduce these as evidence, and she would be the likely person to take the stand to have this be evidence for. We'll get to that later today, likely. When court starts live again, we will hear from the CBI tech that was on the stand yesterday going through the weaponry. He was the one that demonstrated how the different weapons that the defendant had at the theater worked, and you could actually hear, like when he used the shotgun, he put some dummy shells in there and you could actually hear the sound of the shotgun loading, and he did the same thing with an AR-15 and with a handgun. What we want to do, though, the big news from yesterday, 3 jurors dismissed from the case, some impropriety from a phone call from a husband to his wife, the wife being the member of the jury pool, that then led to 2 others being dismissed as a result of that phone call. So we want to take you back to yesterday with how 3 jurors were dismissed, how they found out, and what happened with the juror that started this all off with a note to the judge.
Have you discussed some of this Twitter information that you received from your husband with other jurors?
No. I don't know what her juror number was, but she was sitting right next to me when my husband had called me, and then when I hung up the phone with him, it was just kind of like, oh, what was that about? And I was like, well, I don't know.
What you said, I don't know?
Yeah. I told her, I was like, well, apparently this is what happened on Twitter.
And what did you tell her happened on Twitter?
Just that one of the lawyers had tweeted about, I don't even know what the tweet was about. I just know that he tweeted about the case during a testimony. I didn't read the tweet. I don't know what the tweet was about.
And when was this?
I think it was sometime last week. I don't remember.
And did your husband provide any other information to you about?
No. I basically, that was it, and then I got off the phone with him.
Did he say anything else related to the attorney or the party, which side it was, or anything like that he was referring to?
No, he just asked. No, he asked me who George Brockler was, or who Brockler was, and I said, well, he's one of the lawyers. And he was like I said, he said, well, that idiot tweeted during the testimony, and that was it. I didn't ask what he tweeted or anything like that.
During the breaks, do you usually hang out in the patio downstairs, in the lounge area with a few of the jurors?
Occasionally.
Occasionally,
and if I don't, I'm out for lunch.
Okay. All right. And do you remember talking to the other jurors about any of this conversation you had with your husband?
I don't.
Right.
I mean, if this happened yesterday, maybe, but honestly, I don't remember. I don't think I did, because I didn't have a conversation with anybody about it specifically. We didn't sit down, we didn't talk about it in conversation. It was just more of a in passing kind of thing.
Why didn't you bring it up to my attention? I've been telling jurors throughout that even if, despite their best efforts, they inadvertently come upon any information related to the case, whether it's accurate or not, or whether it's directly from the media or not, if they inadvertently come up on, or hear or overhear any information about the case, they should tell my staff that they need to talk to me.
Right. I mean, there's no excuse for me not telling you. It was more so I just really don't pay attention to my husband most of the time. So it wasn't really that important at that time. I didn't expect, anything out of it. So it was just kind of pushed under the rug and forgot about.
Okay, let me have you step out for just a moment, please. Thank you. All right, the record should reflect that number 872 is now back in the courtroom. Thank you for your patience. A couple of follow-up questions. Was there a second incident where you discussed something related to the case, or someone discussed it with you?
No. The only one that I can think of is the Twitter.
And you said you had your husband on the speakerphone. Do you know whether there were other jurors within a close distance or a short distance who would have been in position to hear what was being said?
Well, there's usually 4 of us that all eat lunch in the same area, and I don't know of the other 2 that heard, but I'm sure the one sitting right next to me heard it.
And who was sitting next to you?
I don't know her juror number.
Where does she sit?
Right here.
Okay, so that would have been juror number 412.
Yeah.
You think she would have heard it?
Yeah, I don't know. I mean, if she heard it, she didn't say anything to me about it.
But she was sitting right next to you.
Yes.
Who are the other people who usually eat lunch with you? Who would have been there during that time when you had your husband on the speakerphone?
I don't know. But I know she sits up in the back corner, and then the other one, I don't know where she sits.
And the woman who sits in the back corner, it's the top row all the way at the end?
Yes.
And how close would she have been, was she to you?
Well, she was on the other side. I was sitting on the far end of the patio in the shade, and she was over walking in the sun.
Can you estimate for me how many steps she would have been away from you?
Maybe about 25 feet.
25,
she was pretty far.
25 feet?
Yeah.
So she was pretty far.
Yeah.
And so, but juror number, the other juror, juror number 412, was sitting right next to you.
Yeah.
So, okay. All right. All right. Give me just a second. I'm going to ask you to step out one more time.
Okay.
Thank you. Thanks for your patience. All right. The record should reflect that 872 has now stepped out of the courtroom. That confirms it for me that 412 was not being completely honest with us, or perhaps without the completely. And I think that's what all of us thought, the parties and I, the attorneys and I, all thought that, and that corroborates what I had concluded. So at this time, I'm going to bring 872 back, and I'm going to excuse her. Then I'm going to bring 412 back, and I'm going to excuse her. Neither one of them is going to be allowed to enter any of the jury rooms while the other jurors are in there. They're going to be taken downstairs, and then when the jurors are not around, they'll be escorted so that they can get their possessions, and they will be escorted out of the building. Okay. Okay. The record should reflect that juror number 872 is back in the courtroom. Ma'am, I'm going to go ahead and excuse you at this time. So you are discharged from jury service in this case. I want to advise you that you are prohibited from talking to any of the other jurors in the case. I know that you may have made acquaintanceships or friendships with some of the other jurors. You cannot talk to them while they remain on the jury. Do you understand that?
Yes.
And you also cannot talk to the members of the media. I'm prohibiting you from talking to the members of the media until the trial is completed.
Okay.
Do you understand?
Yes.
Okay. All right. Thank you. The record should reflect that juror number 412 is back in the courtroom at this time. Ma'am, I'm going to go ahead and excuse you at this time. You're excused and discharged from jury duty in this case. You are not allowed to talk to any of the other jurors as long as the trial is pending, as long as the trial is continuing. You also are prohibited from talking to any members of the media until the trial is completed. And when I say trial, I mean the entire thing, including any proceedings that may be had in this case. Do you understand?
I do.
All right, thank you. You're discharged. The record should reflect that juror number 495 is now present in the courtroom. Ma'am, I'm going to go ahead and excuse you.
And we're going to dump out of that and get right to court for the start of day 29 of the Aurora Theater shooting trial.
Eagan Holmes, case number 12CR 1522. The record should reflect that Mr. Holmes is present with his attorneys, Ms. Brady, Mr. King, Ms. Nelson, Ms. Higgs, and Ms. Spengler. The people are represented by Mr. Brockler, Ms. Pearson, Ms. Tish McGuire, and Mr. Edson. We are outside the presence of the jury. Are the parties ready for the jury at this time? Ms. Pearson, are you ready?
Yes, Your Honor.
All right, is the defense ready?
Yes, Judge.
Okay, great. Let's bring the jury in, please. Please be seated, everyone. The record should reflect that the jury is back in the courtroom. Good morning, everyone. How's everyone doing? Good. It's good to have you back. At the end of the day yesterday, Agent Higashi was on the witness stand, and Ms. Pearson was in the middle of her direct examination. And so, Agent, I will remind you that you're still under oath.
Yes, Your Honor.
And Ms. Pearson, you may resume your direct examination.
Good morning, Agent Higashi.
Good morning.
Yesterday, we talked about firearms, magazines, and ammunition and spent casings, and today I'd like to talk about fragments. Did you identify did you examine fragments that were collected in this case?
Yes, I did.
How did you examine them?
Those would be under my comparison microscope, set at about 15 power is my normal method to examine the surface of the bullets. And what I'm looking for are the general characteristics of the barrel that fired them, as well as the individual characteristics that might be found within each land impression.
Were you able to determine to a reasonable degree of scientific certainty that some of the fragments were fired from the rifle that was collected in this case?
Yes, I was.
And I'm going to hand you a number of exhibits that have previously been admitted. People's Exhibit 433, 440, 448, 104, 554, 562, 584, 587, 590, 109, 113, 122, 123, 291, 311, 600, 602, 610, 611, 998, 639, 644, 326, and 605. Are these items that you examined that were, these have previously been identified and collected in this case, and are these items that you examined?
Yes, as I'm going through these, I do see my initials and seals located. Looks like on all of the envelopes, big and small.
Are these items that you were able to determine to a reasonable degree of scientific certainty were fired from the rifle that was collected in this case?
Yes, these all appear to be the fragments or portions of the bullets that were fired by the Smith & Wesson M&P rifle.
And I'm going to have you, we're going to look at a few of them on the Elmo so that you can explain better how it is that you were able to identify them as to a reasonable degree of scientific certainty having been fired by the rifle. So if you could first look at exhibits 109 and 113.
Okay.
Are you able to tell who those were collected from, what person they were collected from?
Yes, on the outside envelopes as they were submitted, they have both have victim McQuinn.
And if I could have those, I will take them too, Ms. Hutzman. Can you point out to us on this exhibit what it is that you were able to observe that allowed you to make a comparison to the rifle?
Why don't you use the microphone, please? Yeah.
There should be a handheld one there.
Thank you.
Okay, this is pretty much an almost intact bullet. You can see some of the green tip up here at the top. We mark all of our items so we know where they came from to maintain the chain of custody. And right here you can see some of the land impressions that are cut into the surface of the bullet. Those are the areas where I'm going to look for the individual characteristics that I know that the rifle generates based on the exemplars, the test fires that I did. Those are my samples that went through the barrel. I test fired them, so I know that they were fired by the M&P rifle. And what I'm looking for are the individual scratches. Under the Elmo, we're unable to see that. Again, I use about 15 power. So in here I could see minute scratches and little details. And the whole idea with the test-fired bullets from the Smith & Wesson as well as the evidence bullets, there's 5 lands and grooves and there's a right direction to twist. So if I put the pointer there, you can see they're leaning or pointing to the right direction. So the general characteristics all lined up, and then I would look at, under the microscope, each of these land impressions, and basically what I'm doing is I'm looking for areas of agreement, and probably on the other side of the bullet, I'll also put index marks so I know where a good starting point is, and that's what I'll do to every fired 223 bullet that I have or a fragment that's consistent with having come from a 223. I'm going to look for these areas or these patterns of agreement, and I'll go around the circumference of the bullet to look for these areas. And that's how I make my determination to the best of my abilities and to a reasonable degree of scientific certainty to give it either an identity as having been fired in the Smith & Wesson rifle. I can be inconclusive because there's a lack of marks, typically due to damage because of the velocity that the bullets are traveling at. Sometimes there's not enough information left for me to draw an identification. And other times there are no parts of the bullet that actually touch the rifling. So basically from this area back, this is called the cannelure. That's where the case mouth generally crimps right below that. This is the part that actually touches the inside of the barrel. The cannelure and above generally does not, because it comes to a point. So this is the area of importance forensically that I look at under the microscope. So here you can see some of the land impressions that I would use for my identifications.
Thank you. If you could take a look at People's Exhibit 104, we don't need to put the other one up that I gave to you, Ms. Huntsman. At People's Exhibit 104, it was previously admitted.
Okay.
Are you, based on that exhibit, do you know who that was collected from?
Yes, this was from victim Gowie.
And if I could have that one, I'll give that to Ms. Huntsman. Now, this fragment looks quite different from the last one that we looked at. How were you able to determine to a reasonable degree of scientific certainty that this was fired from the rifle?
Again, the important part of the bullet, the part that comes into contact with the barrel, is what we have here. It's the lower half, so the cannelured section of the bullet would be up here and above. This is the base area down here. And this is just the bottom half of the bullet, basically, that was compressed, squeezed together, the top portion sheared off with the other components that are generally found on the inside of this M855 bullet. But this is the majority of the base that I would need for my comparison.
Thank you. You can take that down. If you could next look at Exhibits 122 and 123. And are you able to determine from the packaging who those were collected from?
Yes, both of these fragments are from victim Wingo.
If you could look at Exhibits 443, or look at Exhibit 443.
Seem to have 443.
Okay, then we'll come back to that one.
Oh, here, oh no, that's 433.
433 is what I meant to say. Did I say 443?
Okay, so I have 443 here, or
433?
433.
433, okay. And does that envelope indicate who that is from?
Yes, this is from victim Blunk, I'm sorry. Blunk.
If I could have that one, please. Now, on this one, did you separate this into several different fragments, giving them slightly different numbers?
Yes, that's correct. They would get what we call a sub-item because they are two separate pieces.
And they look different.
Yes, they do.
What are we looking at here? What part of a bullet are these?
Okay, the one off to the left with the green tip, that's just the nose portion. You can see on the bottom of that, the cantilever part. That's typically what these bullets do when they impact soft tissue, is they shear. They enter the victim. They basically yaw or turn. So if the microphone was heading in, after about 3 to 6 inches of travel in soft tissue, the bullets tend to deflect either up or down at high velocity. They will get squished sideways because of the velocity against the material it's traveling through.
Judge, I'm going to object as to relevance at this point.
Overruled.
You can continue.
Okay, and then because the cantilever section of the bullet is actually around the circumference of the bullet, that's where it first tends to fracture. So that's what we see here, the top half on the left and the bottom half of the bullet that I would use for my identification is also on the right-hand side. Sometimes we do get land impressions up around the cantilever, and on some of those particular bullets, I was able to also identify them back to the Smith & Wesson rifle with a reasonable degree of scientific certainty.
You can take that down, thank you. Would you look at Exhibit 440?
Okay,
Who is that bullet fragment from?
this is from victim Moser Sullivan.
If I could have that one, please. I believe the court needs to do something, Your Honor. And what are we looking at with this fragment?
This is a fully intact bullet. It has, again, been flattened because, again, it most likely went in to the victim, yawed, meaning turned sideways, and was forced and basically flattened out. So these start out as round cylindrical objects, and because of the velocity and the impact, they flatten out. This one didn't have a chance to come apart or fragment as some of the others did, but that's just what this particular bullet did. But you can see it's very flattened at the base. But again, it's an intact bullet, so it was very usable for my comparisons.
Would you take a look at Exhibit 448, and we can take this one down. Can you tell who this was taken from?
This is from victim medic.
And if I could have that one. What were you able to see in this particular fragment?
This is most of the base part of the standard M855 bullets that were used. The top half is sheared off, probably the part that has the penetrator in it. And you can see the base of it is somewhat flattened, so it's no longer round in profile. So again, it has the typical damage that is normally seen with these types of bullets when they impact soft tissue and yaw, and this one fragmented.
What does it mean when a bullet fragments?
That means its structural integrity wasn't able to hold up. Unlike the other bullet, this bullet with probably very close to the same velocity, this one maybe just impacted different objects in this particular victim.
Judge, I'm going to object to this being beyond the scope of this witness's testimony.
Sustained. I think he answered the question. I think the question was, what do you mean by a fragment, a bullet fragment? What does that mean? And I think he's explained what it means.
You can take that down. Is there a difference in how a .223 round fragments versus a .40 caliber bullet?
Yes, and it would be a function of the velocity. Again, the .223 bullets traveling at over 3,000 feet per second. There's a lot more dynamics, a lot more energy going on there. So once the bullet yaws and turns and has the ability to, again, it's still high velocity,
I'm
come
going to
apart.
object. This has been asked and answered and gone over, and it's beyond the scope of this witness's expertise.
Sustained.
Would you look at Exhibit 311?
And just to be clear, I sustained it on asked and answered grounds. So under Rule 611A.
Can you tell on Exhibit 311 who this was taken from?
Christina Black,
Or Blosh?
B-L-A-C-H-E.
And would you look at Exhibit 326?
Okay.
Can you tell who that was collected from?
This is Denise Trainom.
Thank you. Now, did you also look at fragments that you were not able to either eliminate or identify to a reasonable degree of scientific certainty as having been fired from the rifle?
Yes, there were quite a few.
And were there ones that you found that had some characteristics in common with having been fired by the rifle?
Yes, just based on their structure, they appeared to be consistent with the same type of ammunition that was being fired.
If I can have those back, I'm going to give you some additional examples.
Those are, do you want all of these?
I'll take all of these. I've handed you what have been previously admitted as People's Exhibits 103, 112, 121, 126, 127, 128, 310, 608, 609, 615, 625, 295, 640, and 643. Are these items that you examined as part of your firearms and ballistic examination?
Yes, they are.
And are these items that you were able to determine to a reasonable degree of scientific certainty had the same general rifling characteristics as the rifle but could not be identified or eliminated?
There's quite a few of these look like they're the nose or the tips of these bullets that may have some of the rifling characteristics present because they go down towards the cantilever part.
What does it mean when you find something that has the same general rifling characteristics, but that you can neither include or eliminate as having been fired by the rifle?
Just based on the lack of individual characteristics. Because they have the same general characteristics, there would be an inconclusive examination, but the lack of individual characteristics preclude me from identifying them because, again, there's the individual marks are generally found towards the base of the projectiles or even along the land impressions, but some of these did not have sufficient parts of the lands left behind because they're fragments of an intact bullet. So that would not allow me to observe enough information or individual characteristics to make an identification.
But is it, you were not able to find something sufficient to say that these were not fired from the rifle?
That's correct.
If you could first look at 103. And does that fragment indicate who it was taken from?
Yes, this is from victim Gowie.
If you could look at 112. Who is that one from?
Victim McQuinn.
And exhibit 121.
Okay. That indicates victim Wingo.
And if you could look at 126, 127, and 128.
Okay, I see on 126 and 127, it has victim T's. 128, I'm having a little trouble locating.
Okay. If I could, I'm going to retrieve 126 and 127 from you.
Okay.
And perhaps we can put both of these up sort of side by side. I don't know. Maybe not. We'll do them one at a time. Which one is this? 126? What are we looking at in this one, and what made it possible for you to neither identify it or eliminate it?
Okay, that's the nose portion of a 223 bullet. See the nose portion here with some damage. Usually that's a close point. The bottom, the top part here is actually heading towards the base of the bullet, and parts of this area would have some of the land impression from the rifle, but because it's so damaged, just able to tell the measurements were consistent on the land impressions that might be present. But again, not enough for an identification or to eliminate it.
Could you put up 127, please? What were you able to determine about this fragment?
Same with this fragment. It appears to me to be part of the side of the jacket, and again, not having enough information and a lot of damage due to the fragmentation of the bullet. I was unable to make a positive identification or elimination.
Thank you. If you would look at People's Exhibit 310. Does that indicate who that was from?
Victim Hankins,
And Exhibit 295.
uh, 295 indicates Alejandra Cardona Lamas.
Thank you. Now, did you also examine fragments that you determined had no comparison value?
Yes, quite a few also.
What do you mean by having no comparison value?
Meaning that they didn't have any rifling characteristics present for me to compare to any of the test-fired bullets from the rifle. So they would appear to be maybe copper jacket fragments, lead fragments that had no viable information from the barrel that fired it. So therefore they get the no comparison value.
Was there anything you could tell about some of those fragments that there was anything about them that was consistent with the kind of ammunition that you examined in this case?
Yes, some of them did have some physical characteristics that would at least point me to being part of an M855 223 bullet.
Let's see, I'll take those back from you. I'm going to bring you some additional exhibits to look at. Are those all exhibits that you examined?
Yes, they all appeared to be. I'll have my initials and stickers on them.
Are these fragments that are consistent with steel penetrators?
Quite a few of them. Looks like the first maybe 6 or 7.
And when we talk about something being consistent with a steel penetrator, what does that mean?
That just means it has the shape and configuration and the characteristics of one being steel and the conical shape where it would go into the nose of these bullets. And they were just noted as such.
And I've handed you exhibits 441, 447, 105, 106, 130, 627, 296, I believe. If you could look at exhibit 441 first, please. Can you tell who that was collected from?
Okay, I'll have to search out 441. I have 447.
Okay, and who was 447 collected from?
Victim medic.
You could look at 105 and 106.
Okay.
And who are those collected from?
Both of these indicate victim Gawi.
130,
Victim Teves.
and I'm going to take a couple of those and put them on the Elmo. What is this that we're looking at?
That is the steel penetrator tip that's inside the copper jacket of an M855 round, the type of rounds, the green tip rounds that were used in this case.
When you talk about a copper jacket, what do you mean?
The copper jacket is the nose portion that's envelops this steel penetrator. Inside the copper jacket is the steel penetrator and then the lead at the base that makes up the three major components of this particular round. So the copper jacket is the part that touches the inside of the barrel. That's this material I would use to make my comparisons to the test-fired rounds from this rifle. The other portions of the bullet don't touch the inside of the barrel, but in this particular case, they're very indicative of that particular round, that green tip round being used because of the steel penetrators that were found.
If you could put up the other two, and maybe you can put them on together. Or maybe not. Maybe that doesn't work. Unlike some of the other fragments that we've seen, the steel penetrators seem to look consistent to one another.
Yes, ma'am.
Thank you. You can take that down. Did you also find fragments that had no comparison value but were consistent with copper bullet nose tips that are found in the .223 Remington ammunition?
Yes, there were a few of those also. Yes, you did. I have one up here.
If you could, do you have Exhibit 449 there?
Yes, I do.
Does that indicate which victim that came from?
Yes, it's victim medic.
If I could have that one, please.
Okay.
Sorry. What are we looking at here?
That's the copper jacket nose portion of one of the 223 bullets that were fired in this event.
So that's consistent with the kind of ammunition used?
Yes, ma'am.
And would it be accurate to say that the tip of the bullet itself never touches the inside of the barrel such that any marks can be left on it?
Right, where this one fragmented, it was up high enough to where it's starting to narrow down and doesn't touch any of the lands on the inside of the barrel.
Now, did you also look at BB shot?
Yes, it did.
Are these items that you also examined in this case?
Yes, ma'am.
Are you able to tell with BB shot which kind of which gun it's fired from?
Well, there's no identifiable marks to the barrel of any of the firearms, but this is consistent with the the load of the shot shells that were fired, that were identified as having been fired in the Remington 870. These are steel, BB-sized pieces of shot.
If you could look at Exhibit 437, please.
Okay, I have 437.
Does that indicate who that was taken from?
Yes, it indicates victim Childress.
And Exhibit 96?
I don't have 96.
I did not give you 96?
No, ma'am.
Okay. If you would look at 116, if you have that one.
Okay, yes, I do have 116.
And who was that collected from?
Victim Wingo.
Now, were you also able to look at some projectiles and make a determination to a reasonable degree of scientific certainty that some .40 caliber projectiles were in fact fired from one of the handguns collected in this case?
Yes, I was.
You could particularly look at Exhibits 595 and 621.
Okay.
And are these items that you examined in the course of your examination of all of the evidence in this case?
Yes, they are.
Were you able to determine to a reasonable degree of scientific certainty that Exhibits 595 and 621 were fired from one of the pistols recovered in this case?
Yes, I was. Based on my microscopic comparison of these two bullets to the test-fired bullets that I generated from the Glock 22 pistol, I was able to make the determination to a reasonable degree of scientific certainty that these two bullets were fired from the Glock 22 pistol that was recovered at the theater.
And the Glock 22 pistol, was that the one that also had a sight on it?
Yes, it had the laser sight under it.
If I could have those to put under the elbow. I'll take this one. You could explain to us what we're looking at here.
Okay. Right here, this is the bottom portion of the bullet. This area here is the side of the bullet and the nose, and what it has done, it is mushroomed. It starts out at this diameter, 0.40 inches. Whatever material this hit caused it to mushroom and impact and basically expand almost twice the diameter. The base area here is the area that I would look at and make my comparisons versus the test-fired bullets that I generated from the Glock 22 as well as the Glock 23. And even though the bullet looks very damaged, the area is very usable, especially at about 15 power under my microscope. I'm able to look at and find, or was able to find sufficient individual characteristics that, again, to a reasonable degree of scientific certainty, I was able to identify this as having been fired by the Glock 22 pistol.
Thank you. I don't have any more questions for you.
Cross-examination, Mr. King.
Good morning, sir.
Just so that we're clear, the general rifling characteristics that you're talking about, the 870 shotgun doesn't have any rifling characteristics inside the barrel, does it? That's a smooth bore barrel, correct?
Right, that is correct.
Both of the Glock pistols and the Smith & Wesson rifle that have been admitted in this case have the same general rifling characteristics in that they have 5 lands and grooves each and a right-hand twist. Is that right?
No, the Glocks are 6-sided. So there's 6 areas of damage that are done to the bullets fired from a Glock. And they're different configuration because they are, the bullets are squeezed into this hexagonal profiled barrel. There's 6 edges that are squished onto the surface of the bullet. I'm sorry, that's about as demonstrative as I can get. Whereas on the Smith & Wesson, there's 5 actual cuts into that caused visual damage to the surface of the bullets on that aspect. So there's a difference.
I thank you for correcting me on that. And I'm not suggesting that you, for that reason, wouldn't be able to tell the difference between the .40 caliber bullets and the rifle bullets. There's certainly a lot of other ways to do that, fair to say.
Yes, there are.
The size of them and the shape of them. And
That is
like
correct,
that.
yes.
The point is that these general rifling characteristics that are left on these bullets are left both in the pistols and the rifle as opposed to the shotgun, was my point.
Yes, that's correct.
And the purpose, generally speaking, is to create a spiral pattern on the inside of the barrel, which will then spin the bullet, facilitating accuracy, essentially.
Right. And they're mandated on rifles and handguns by the BATFE to put rifling inside of their barrels.
Kind of like the same principle as like throwing a spiral with a football, like Tom Brady throwing a deflated football, right?
Correct. It's going to fly more accurately in that aspect, but also it can leave individual marks, so it can be traced possibly back to that particular firearm.
And I just have a few questions about the firearms. The demonstrative that you brought in, which was a Colt
Yes.
rifle, is identical in function essentially to the Smith & Wesson rifle. Is that right?
Yes, it is.
And I noted when you had your demonstrative out that the barrel is considerably shorter, considerably, maybe 2 or 3 inches shorter. Is that like a 14-inch barrel?
Yes, it's a 14.5-inch barrel.
And the difference is that that's a law enforcement rifle, and law enforcement are allowed to have 14-inch barrels. That wouldn't be legal for a civilian to have a rifle like that. Is that right?
You can buy them. You have to go through your sheriff and get the stamps and pay the proper fees. It's what's considered a short-barreled rifle. We get it mostly for its compactness, so it will be more suitable for what our field agents use them for. Whereas, a 16-inch barrel or 20-inch barrel for the normal population, a little less portable, but again, you'll get more velocity. So there's a little trade-off with both.
Right, and absent having some special permitting and stuff like that, if you were to just go into a store and purchase a rifle like this, you couldn't buy one that was that short. You'd have to buy one with a longer barrel, like this rifle.
Correct, the 16-inch barrel. You demonstrated the shotgun as being a manual reloading system.
And both of the Glock pistols and the Smith & Wesson rifle are semi-automatic weapons. Is that correct?
That is correct.
And that is distinguishable, and this is probably obvious to this jury, but I just want to be clear. These are not what you would call a machine gun or a fully automatic weapon where it just keeps firing until there are no more bullets. In these weapons, you have to individually pull the trigger for each separate bullet, correct?
Yes, for the semi-automatics, you would have to pull the trigger for each shot that's being fired. And for the shotgun, not only pull and release the trigger, you'd also have to work the pump. So that one has a little extra step.
Now, you've talked some about the shotgun shot that was used, namely the bird shot. There were also, and you testified about this yesterday, 6 shotgun shells that contained double-aught buckshot. Is that right?
That is correct, yes.
And the distinction, and I think you testified about this yesterday, is that these are, there are fewer pellets, but they're considerably larger in size. Is that fair to
Yes.
say?
Yes, that's correct.
And traditionally, for hunting, birdshot is for hunting birds, and buckshot is for hunting deer, right?
Right. I don't know, I'm having trouble with the birdshot and the BB size. BB's actually rather large, so it's kind of like on the spectrum heading towards like the buckshot range. So it's for larger game or geese, that kind of sort of thing, where you need the projectiles to retain their energy.
Sure. And suffice it to say, they're all different size of shot.
Yes, it spans the gamut from very small to the double-aught, triple-aught buck size.
And none of the 6 rounds of double-aught buck that you were fired, is that right? They were all unspent rounds?
Right, they were unspent, they were live.
And you have no indication, based upon the evidence you received, that there were any buckshot rounds that were fired in the theater, correct?
That is correct.
Now, you talked about 3 different, first of all, both of the Glock pistols and the Smith & Wesson rifle, they lock with the bolt open when the magazine is empty, correct?
Yes, that's correct.
So what that means is that it's fairly simple to reload them. You just need to insert a new magazine and press the bolt release, or like you indicated, pull back on the manual arming, what's the word?
The charging handle.
Charging
Correct.
handle, in order to reload the weapon, is that right?
Yes, if you were able to shoot the 3 semi-automatic firearms, 2 where the magazines were empty, they would lock back and facilitates reloading if you haven't practiced that very often. The bolt's wide open, insert a new magazine and close the bolt, whether you slingshot the charging handle or hit the bolt release, or do the same thing with the pistols. That will get fresh ammunition back into the firearms.
And in this circumstance, there were 3 different, your items, 72, 82, and 85, which were People's Exhibits 566, 573, and 576, that had some damage to them. Do you remember those
I do.
bullets? And those were bullets that were not fired.
That is correct. They're still
But in your-
live.
I'm sorry, I don't mean to interrupt you. Go ahead. Were you done?
Yes, I was.
Those were bullets that in your report you wrote had been worked through the action of that rifle, correct?
No, those 3 I indicated had evidence of some sort of feeding malfunction.
And what that meant was that it had they had a flattened portion on the top of the bullet, or one of the sides of the bullet. Is that something?
Right, they were either flattened, they had a dent in them, or one that had a dent as well as the bullet pushed way back in.
And that would be consistent with feeding malfunction, in your opinion, based upon your experience as an armorer?
Yes, that's correct.
Normally, those bullets would feed from the magazine in a linear fashion, perpendicular to the ground, essentially, until they're the elevator moves them up into an area where the bolt can catch them and push them into the firing chamber, right?
Right, well, the elevator's on the shotgun, but they're, after they leave the magazine, they're pretty much just a little bit above horizontal in their, it's a very direct straight shot above the feed ramps on the M&P rifle that would help it just go directly in.
And I think what you testified to yesterday is that would cause a jam of the weapon.
Yes, it would normally cause a jam.
Now, based upon the fact that there are 3 of those, you would conclude, based upon your experience, that there were more than one jam of that weapon, correct?
More than one jam or more than one attempt to cycle the bad ammunition out and get the M&P rifle back up and running again.
So there would have to be either 2 or 3 jams or attempts.
Attempts, yes, sir.
Now, a misfeeding like that can occur due to having overloaded your magazines, essentially. I think you testified yesterday that law enforcement, you load 28 rounds into those 30-round magazines.
Right, we try and download them because if you try and insert those magazines on a closed bolt rifle, normally we don't shoot our rifles to slide lock or where the bolt is locked back. So we don't know if we fired 15 or 25. So we're going to possibly reinsert a fresh magazine with the bolt closed so we don't have to go through all those manipulations. So some of these feeding problems could indicate either the bad magazines or just other attempts at trying to get fresh rounds into that gun.
In your item 245, which was identified as People's Exhibit 270, that was a magazine, a 30-round magazine that was found that had 30 rounds in it. Is that correct?
Almost there.
Your 245?
Sorry, I have a few pages of notes here. Oops. There we go. That one's a long travel for that. Yes, that is correct.
And your item 224, which was also a rifle magazine that was located and you processed, was a rifle magazine that had 31 rounds in it. Is that right?
Yes, that is correct.
And in your report, you note that when loaded with the 31 rounds of ammunition, it will not properly lock into the rifle when the bolt of the rifle is forward.
That
correct?
is correct, yes.
Won't function correctly.
No, sir.
Your item number 226, which is a magazine that you processed, also trying to find People's Exhibit number here. There are so many numbers.
I know.
It would be People's Exhibit number 693.
Okay.
That's a magazine also that you had that also was located with 31 rounds in it. Is that right?
That is correct, sir.
And your notation in your report is the same with regard to that, loaded with the 31 rounds that it won't lock into the bolt of the rifle and function properly, correct?
That is correct.
You testified on direct examination yesterday that the 40-round magazines that you examined, most of them had damage to the lip area of the magazines. Is that right?
Yes, that's correct.
And you said you didn't know that damage could be caused by a number of different things, fair to say.
Fair to say, yes, sir.
Dropping it on the ground, trying to jam it into the rifle when it wouldn't go in.
I would probably go with the first one more because the well is opened and the area of damage would kind of be in the open area for the magazine well.
And you don't, I'm sorry.
Oh, just saying that it most likely occurred from hitting the ground.
And you don't know whether that occurred hitting the ground in the theater or whether they were brought to the theater in that condition or not, do you?
That is entirely true.
And those are the type of things as an armorer that you have to keep your eye on with your equipment, right?
Yes, and when damaged stuff comes to me, I really don't have a question about how or when it happened, just to get it out of circulation and replace it or repair it.
Item number 246, which is a magazine. People's Exhibits 263 and 264 was also a rifle magazine loaded with 31 rounds of ammunition. Is that right?
Yes, in my report, my item 246 is described as a rifle mag with 31 rounds, but I just have 31 rounds of ammunition.
Same condition as the other two magazines that were overloaded with 31 rounds. Is that right?
Yeah, if those were removed from a standard 30-round magazine, then that would be overloaded.
And item number, the magazine, and you showed this via the document projector to the jury. Your item number 228, which is People's Exhibit 260 and 261, as admitted, was the one that was very damaged on the lip portion of them. Is that right?
Yes, that's correct.
The ammunition that this green tipped ammunition that you described, this is a type of ammunition that you can go online and buy or go to a store and buy. Is that right?
That is correct, yes.
You talked some about the drum magazine. The drum magazine, I think you said was, well, first of all, it's not the best kind of drum magazine that there is, fair to say?
Right, it's patterned after a device called the Beta Mag, which is probably, I think it's about twice as much as what this knockoff magazine is. Even those from the internet appear to have problems, again, because it's so much stuff going on in there to make work with reliability. So on the surface, it sounds really neat to have 100 rounds available, but at what cost? The normal 30-round mags are about $7 or $8, and they function until the magazine springs wear out, and you can fix those up again and put new magazine springs and have a new, perfectly good magazine. Whereas these other ones, they come with a graphite lube to keep the bullets from sticking to each other, to keep them from malfunctioning. It's just a lot of work to not have to reload.
And you all don't use those at the CBI, do you?
No, sir.
There appears to be on the rifle what looks like a scope of some kind. Is that a scope like you would use hunting that would magnify things or not?
No, it's what we call a red dot sight. So it basically just projects a red dot in your field of view, and if sighted in properly, they're very effective for quick acquisition of targets and shooting.
And you brought up a good point there. When sighted accurately, in order for that to work properly, you have to zero that sight. Is that right? So
That is correct, yes.
make sure that it's lined up properly and zeroed with the target accurately. Fair to say?
Correct.
And if it's not, it's not going to be much help.
Right, your red dot may be somewhere else.
The There was another, on the pistol, on the Glock 22 that you testified fired some of those rounds. There's a laser sight on that as well. Is that right?
That's correct, yes.
And this is the kind of laser, it's attached to the slide of the pistol, is that right?
Actually, to the frame, so it's kind of follows where the muzzle is going.
And it projects out a laser beam, is that right?
That's correct.
That kind of a sight has to be zeroed in for accuracy too, isn't that right?
That's correct, yes.
And now you don't use, on your Glocks at the CBI, you don't use a laser like that, do you?
No, we don't.
And it can cause problems, can it not, with the weapon?
Yes, there are some reports that the lasers or anything attached to some of the rails, especially on the Glock 22s, can bind the frame and cause it to malfunction.
Thank you. If I can have a moment, Your Honor.
You may.
I don't have any other questions. Thank you, Agent.
Thank you.
Ms. Pearson, do you have any redirect?
One, Agent Higashi, you used the acronym BATFE.
Correct.
What do you mean by that?
The Bureau of Alcohol, Tobacco, Firearms, and Explosives.
And is that the agency that would determine the characteristics or what rifles and shotguns and handguns need to be able to do to be sold to the public?
Yes, they are. They're the ones that make all the rules.
No more questions.
Any recross? The jury may have questions for you, Agent Higashi. It looks like they do.
Okay, Your Honor.
Thank you. Thank you. Would counsel please approach? All right, Agent Higashi, there are some questions that the jury has submitted that I have found, based on the rules of evidence and other applicable rules of law, are appropriate. The first question is, approximately how much does the loaded shotgun weigh, the loaded rifle, and the loaded Glock, if you know?
Okay. I would say we'll go backwards, the loaded Glock, maybe a pound and a half to 2 pounds, fully loaded. The rifle's probably around 7 to 8 pounds, and the shotgun would be maybe 5 pounds.
The next question is, how many pellets did you say were in the red shotgun shells?
In the red shotgun shells, those are what we call low recoil double-aught buck loads. So typically what they do is they remove one of the pellets, so there would be 8 total pellets, whereas a standard double-aught buck load would hold 9 pellets.
The next question is, what size is bird shot? And then in parentheses it says hunting load, end parenthesis or close parenthesis, as compared to the BB shot or 00 shot.
Okay. Typically what I think of for bird shot would be something that you would use for sporting clays or target shooting, and that would be a size 7.5 size shot. So that's about 1/10 of an inch, 0.10. Shotgun nomenclature goes backwards, so it's a little hard to visualize at first, but it's the BB size shot is 0.177 in diameter. So the larger the number, the smaller the size shot. So 7.5 size shot, you start looking at 1/10 of an inch. 9 size shot would be like 0.08 inches in diameter. 11 size shot, which is really fine bird shot, would be like 0.06 inches in diameter. And then you go the other way when you start getting into the buckshot loads. We have double-aught buck, which is the most prevalent one, where you get the pellets are like 0.32 inches. I think there's the triple-aught buck, which is, I think, 0.35 inches. And we have 0 buck, we have number 1 buck, number 4 buck, and those would all vary in sizes, going smaller in diameter. So there's a whole myriad of types of loads that the 12 gauge can fire.
Any follow-up questions, Ms. Pearson?
Your Honor.
Any follow-up questions, Mr. King?
No, thank you.
May this witness be released from his subpoena?
You may.
Any objection?
Without objection.
All right, thank you.
Thank you, Your Honor.
Agent Higashi, thank you.
Thank you, Your Honor.
Please call your next witness.
We'll call Christopher Moore.
Good morning, sir. Could I have you raise your right hand for me so that I can administer an oath? Do you solemnly swear or affirm under penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Please be seated.
Thank you.
Could you please tell us your full name for the record and spell your first, middle, and last names?
Yes. Christopher Lee Moore.
And can you spell your first, middle, and last names?
Yes. CHRISTOPHER. Lee LEE. And Moore MORE.
Mr. Edson, you may proceed.
Thank you. Sir, I'm going to direct your attention to July of 2012, and specifically July 3rd of 2012. How were you employed back on July 3rd, 2012?
I worked for a FedEx office off 13700 East Colfax Avenue in
Where
Aurora.
Sorry, is that in Aurora?
Yes, it's major cross sections would be Colfax and 225.
What was your duties at the FedEx office during that time period?
I dealt with customer service, office printing, and shipping.
What is FedEx Office?
It's a center that you can go to have office things to get printed, or if you want to ship something or have something held, you could do that all in one location.
Can customers have items delivered instead of to their house to that FedEx office via FedEx?
Yes, we have the opportunity to hold at a location. Our center had that opportunity, so if you were to order something online, you can have it sent to our center, and it'll be held for about 5 business days.
What is the process for someone to come in and pick up the items that they have requested shipped and be held there?
So if the package had already been to our location, they'll receive a phone call that they have a package held, how long it's going to be held before it gets sent back. By then, the customer would have to come in, show a photo ID or a tracking number, and then we'll have them sign a release form, and then just release it out to them.
That process that you just described, was that part of your duties back in July of 2012?
Yes,
I'm going to direct your attention to July 20th of 2012. Were you also employed by FedEx office back on that date?
yes,
Were you contacted by law enforcement in relation to the shooting that had happened at the Century 16 Theater?
yes,
I don't want you to get into any sort of conversations or statements, but did you ultimately talk to law enforcement about a customer by the name of James Holmes?
yes,
At some point in the days after July 20th, 2012, did you have an opportunity to view a video surveillance from the FedEx office from July 3rd, 2012?
no,
At some point before your testimony today, have you had an opportunity to view a video surveillance of FedEx office from July 3rd, 2012?
yes,
Did you see yourself in that video surveillance?
yes,
Did you also see individual related to the purchase picked up by James Holmes?
yes.
Your Honor, may I approach the witness, please?
You may.
I've shown counsel and have also placed before you, sir, People's Exhibit 1021. Do you recognize that?
Yes.
What is that?
It has my signature and the date.
Okay. Is that a copy of the video surveillance from July 3rd, 2012?
Yes,
Is that a copy that you previously have watched yourself?
yes.
When did you watch that particular copy?
June 5th, it says 2015.
Were you able to see yourself in that video?
Yes,
Were you able to see yourself assisting a customer on July 3rd, 2012?
yes,
Do you actually remember that transaction?
I do.
Does that particular video surveillance fairly and accurately depict the customer pickup of some items from July 3rd, 2012?
Yes,
Do I have a move for admission of People's Exhibit 1021?
Any objection?
No objection.
Without objection, People's Exhibit P-TR-1021 is admitted and may be published.
Sir, a couple of questions before we publish the surveillance video. What do you recall about this particular transaction from July 3rd, 2012?
so the customer came into the center and approached the service desk and said that he had some packages to pick up. The gentleman had short sleeve shirt, shorts on, a kind of reddish orange long hair, and he wore a beanie. I remember he had sunglasses.
I'm
as well.
sorry, can you pull the microphone down a little bit, please, so we can all hear you? I missed. Can you repeat the last part?
Yes. So the customer came into the front service desk, and he said that he had some packages to pick up. What he was wearing, he had short sleeve shirt on, shorts, long reddish orange hair. He wore a beanie and sunglasses. Went to. We have a cage where the packages are held in, but if the cage is too full, we have a safety zone where you put packages as well. So went to go pick up the packages, sat him on the desk, got his tracking number, scanned out the packages, had him sign a release form, and that was pretty much it.
Do you remember anything about the packages?
They're very heavy, and they made like a rattling noise as if like metal was rattling together.
Okay. Do you remember how many packages?
There were 6.
Did you help the customer transport the packages out of the store?
No,
How did the packages get out of the store?
he brought them out himself.
Judge, at this time, I would request publication of 1021. I'll tell the court it's 5 minutes long with no sound.
All right. The request is granted.
May I approach the witness, Judge?
You may. Do you want me to dim the lights, Mr. Edson?
Yes, please.
Okay.
So just a couple more quick questions. I should have asked you this before, but were you the individual in the black or gray shirt with the black pants?
Yes.
It appeared that you were scanning some of the boxes. What are you doing there?
Releasing the packages out of our system.
To the best of your recollection and viewing of this video, were all the packages that were ordered and were held there, were they all picked up?
Yes.
Judge, can I have one moment, please?
Yes.
I have nothing further, Judge. Thank you.
All right, is there any cross-examination, Ms. Brady?
No, sir. Thank you.
Oh, thank you. The jury may have a question for you, sir. Give us a moment, please. Would counsel... Jury has submitted a question that, based on the rules of evidence and other applicable rules of law, I have determined it's appropriate. The question is, when you spoke with the defendant during the transaction, can you comment on his demeanor at the time? Did he seem calm, anxious, or neither?
Calm but very quiet.
Any follow-up questions based on that question and that answer, Mr. Edson?
No, thank you, Judge.
Any follow-up questions from you, Ms. Brady?
Just briefly, and sir, your interaction with him was very short. Is that correct?
Yes.
Okay. Thank you.
May this witness be released from his subpoena?
Okay, Your Honor, thank you.
Any objection?
No objection. Thank you.
All right, sir, thank you.
Thank you.
Members of the jury, it's 10:15, so let's go ahead and take our morning break. Please keep in mind that my advisements related to your conduct apply during the break, and then we'll see you back here in 20 minutes, okay? Enjoy the break. Thank you. The record should reflect the jury has exited the courtroom. Please be seated, everyone. Is there anything we need to talk about at this time on behalf of the people? Mr. Orman?
Your Honor, I just handed to counsel a future exhibit. We're going to seek to admit 1088, And I don't expect counsel to have any objections at this time, but I expect they might based on previous objections they've made. These are jail kites or messages that the defendant sent to jail personnel requesting things and so forth. And because I anticipate a potential objection from the defendant, I wanted to give that to them so they have time to formulate that. But I also thought it would be appropriate to provide the court a copy so that we can discuss that before we attempt to admit it. I don't see that happening today, and frankly, I don't see that happening tomorrow. It's most likely next week, but I just wanted to follow that same procedure.
All right, thank you. I appreciate you doing that. Why don't we wait before you give it to me until they've had a chance to review it? If they say they have no objection, then I don't need to review it. If they have an objection, then I will review it with the objections in mind.
Thank you, Your Honor. I understand.
All right, in terms of Exhibit P-TR-1227, which we talked about yesterday, and I ruled on yesterday, I had offered the defense an opportunity to have a few things redacted from it. Have the parties conferred about that?
I did confer with counsel. She indicated that she would like those redactions, and then I went over the specific redactions with her to make sure that we agreed on what they should be.
All right, is that correct, Ms. Spengler?
That is correct.
Okay, great. And so, Ms. Spengler, you have chosen to have the redactions made, and it sounds like the people have made the redactions. Is that correct?
That's right.
All right, great. Thank you. Okay, we'll be on break. I'll see you back here in about 20. The court will be in recess.
So we finished up hearing the testimony from the CBI analyst who went bullet by bullet and fragment by fragment of the evidence that he looked at from the weapons used in the shooting and pinpointed actual bullets and fragments to the person that they impacted. And then we just heard and saw some surveillance video that was from a FedEx employee at the time with an interaction with the defendant prior to the shooting. What we still anticipate today, and we had heard it yesterday leading up to today, is the admission of some email conversations between the defendant and his girlfriend at the time. We've heard her name multiple times referenced by the doctors, Gargi. We have also heard arguments about why these email are not relevant, so clearly there is detail in these email that could be telling, and the person that can connect these email and have them be relevant evidence is the girlfriend herself, who we have been heard from sources would take the stand, and that could potentially happen today. So what we want to play for you is the debate that the judge heard in his ruling on why he will allow these emails to be admitted into evidence in the court, and the purpose that that he went through both sides, hearing the arguments about the detail of what should be redacted or what shouldn't be allowed, and here is the judge from yesterday deciding why these emails will be allowed, probably later today.
The emails in question will allow the jury, and when I say the emails in question, I'm referring to the ones in P-TR-1227, will assist the jury as the jury considers the defendant's mental state and mental capacity in this continuum or progression of time between 2011 and 2012. And it's, for example, Drs. Reed and Metzner appear to me to have relied on the defendant's interactions with others, his communications with others, his behaviors, the organization of his speech and thinking, his mental processes and his mental capacity, and how any of that may have changed in 2012 as compared to 2011 and before. And these emails would be examples of some of those things. In any case, I agree with what Mr. Orman said last week when he argued about this exhibit, and he said that ultimately it is the jury that will make the decision on the issue of sanity, not Dr. Reed or Dr. Metzner or any other experts. So even if the experts had not relied on these exhibits or on these emails, it doesn't mean that they are irrelevant. They're not rendered irrelevant just because of that. But as I said, I believe that they have relied on some of these communications. They have relied on all the information that they have been provided, and certainly it's my understanding that they've been provided emails that the defendant was sending and have specifically looked at the things that I've talked about, the defendant's communications with others, interactions with others, the defendant's behaviors, organization of speech and thinking, the defendant's mental processes and the defendant's mental capacity and cognitive abilities, and how they may have changed between 2011 and 2012. Let me just say, by the way, that I understand that just because you're able to interact with others, to communicate with others, to process information, to respond to information logically, reasonably, coherently, and appropriately, etc., I get it. I get that that all does not necessarily mean that you're sane. I get that. And that's a point the defense has been making throughout. But that also doesn't mean that any evidence of your cognitive capacity to interact with other people, to communicate with them, to process information, and to respond to information coherently, logically, reasonably, and appropriately, etc. And when I say etc., I'm referring to the other things that I have mentioned, the other activities that these emails deal with or are probative of, or the other aspects of the defendant that the defendant's mental state that these emails are probative of. It doesn't mean that they have no relevance to the issue of sanity. So yes, on the one hand, just because someone can communicate and interact with people and process information, it doesn't mean that they're sane, but that also doesn't mean that the person's communications and interactions and evidence of his ability to process information and to respond to it appropriately and coherently is inadmissible, or that it is irrelevant. And I think that the testimony of the two court-appointed experts, Drs. Reed and Metzner, show my point, or I think they corroborate the point that I just made. But as I said, the relevance of this exhibit exists independent of their opinions. So for all those reasons, I find that these emails are relevant. I also find that the probative value of these emails is not substantially outweighed by the danger of unfair prejudice or by the danger of confusing the jury or inviting the jury to speculate, or by the unnecessary presentation of cumulative evidence. In terms of the specific objections, let me run through the 12 emails or email exchanges that were identified by Ms. Spengler. The first one is email August 23, 2011, number 1359, and the number refers to the bait stamp number. This is an email exchange between the defendant and his father, Robert Holmes. And then I think there was an argument that there is double hearsay because Mr. Holmes, Robert Holmes that is, discusses statements by Chris Holmes, the defendant's sister. It's not hearsay and it's not double hearsay because these statements are not being admitted for the truth of the matter asserted. In terms of character evidence related to Chris Holmes, I don't find that to be character evidence. Again, it is not being introduced for the truth of the matter asserted, and I don't think it rises to the level of character evidence. It is a statement, I think, that Robert Holmes is conveying to his son about something that Chris said to him about her roommate in college, and her roommate possibly being a Crip, C-R-I-P. And the defendant then responds to that, finding it unlikely that that's true or that that's the case. And so it's probative because, for all the reasons I stated earlier, but it is also probative specifically because it shows the defendant's ability to understand and process the information and events discussed by his father. It also demonstrates his mental or cognitive capacity to respond to his father in a logical, coherent, reasonable, and appropriate fashion, and it is within the time frame that we've been working, or that I've been working with. It's August 23, 2011. It's certainly within the time frame that the experts have found to be relevant. So the court concludes that this evidence is probative of the issues of sanity and the culpable mental state elements of the crimes charged, and the probative value of the evidence is not substantially outweighed by any of the dangers listed in Rule 403. Again, this is an exhibit. This is one of the earliest emails in the exhibit. It's from August 23 of 2011. And by the way, most of the emails are from 2012, but this is one of the earlier ones. But I think in addition to what I just said, it also gives the jury a reference point, a point of reference to compare the defendant in 2012 to. What was the defendant like before 2012? And was there any change? Was there anything that changed? Was there anything that changed in terms of his mental capacity that shows that he developed a mental illness, or that perhaps even if he had had a mental illness already, that somehow it became more, that it was manifested more clearly. I think the jury, in order to assess those types of issues, needs to have a point of reference, needs to be able to compare that to something before that. Number two is the email from October 30, 2011, Bait stamp number 2964. This is an email exchange between the defendant and his mother, which contains a reference to speeding and the police being lame. And Ms. Spengler, again, I think in an effort to be as candid as possible with the court, acknowledged that this is probably not inadmissible character evidence under Rule 404. She didn't concede it, but she said it's probably not inadmissible character evidence. And I appreciate her candor, and I agree with her. I don't think this is inadmissible character evidence, or that it falls under Rule 404 either. As to the irrelevant and Rule 403 objections, it appears to me that the primary concern here by the defense is for the risk of unfair prejudice. I see very little, if any, risk of unfair prejudice here. I mean, a speeding ticket in the context of this case is extremely unlikely to have any risk to prejudice the defendant in any unfair way, or in any way for that matter. The same is true for the defendant's comment about the cops in Colorado being lame for not even having a 15-mile-per-hour leeway, as he put it. A lot of people get a speeding ticket at some point in their life, and when it happens, it is not uncommon for people to feel annoyed at the police for having received a ticket, and it's not uncommon for people to have the type of reaction the defendant had, especially given that it was, he felt that this was a speeding ticket for going, I think, 11 miles over the speed limit. Also, the most reasonable inference that can be drawn from a subsequent email from November 15, a subsequent email exchange about 2 weeks later between the defendant and his mother, which is at bait stamp number 3297, is that this was the defendant's first speeding ticket. The defendant's mother asks the defendant if there's a way to do online traffic school to knock off the speeding ticket. The reaction was not, oh, well, another speeding ticket, you know what to do, or just pay it off, you've done it in the past, that kind of thing. The reaction seems to me to suggest that this is not a common occurrence with the defendant. On the probative side, in addition to the reasons that I have stated earlier, the email from the defendant in this exchange contains a discussion about activities that he is engaging in with his gal, as he refers to her, and with his friends. One of the big themes in this trial has had to do with the defendant's ability or inability to socialize with others in 2012, including how shy and introverted and socially awkward he was at that time. The parties appear to disagree about whether these are symptomatic of mental illness or whether they are merely normal traits of the defendant's personality, and whether there was a change in these behaviors at some point in 2012. The defendant's discussion of social activities with his girlfriend and friends in late 2011 goes to these issues. As such, this is evidence that is probative of the issues of sanity and the culpable mental state elements of the crimes charged, and the probative value of the evidence is not substantially outweighed by any of the dangers listed in Rule 403. Having said all of that, in an abundance of caution, if the defense wishes, I will order the prosecution to redact this particular page of the exhibit by deleting the following words. And then I got a speeding ticket because the police are lame here. 46 in a 35 zone, not even a 15 mph leeway. In my view, such a redaction will not take away the primary probative value of the email, but will completely avoid any danger of unfair prejudice. So I'll leave it to the defense to tell me whether they prefer to have that redaction made or whether they would rather not have the redaction made. Either way, the defense is not waiving their objection. I understand their objection. I'm overruling it. I'm giving them a choice of whether they wish to have that redacted or not, and it is up to them to make that determination. Number 3 is an email from November 15, 2011, Bait stamp number 3297. I just mentioned this a moment ago. This is an email exchange between a defendant and his mother. This is the one that contains a reference to the speeding ticket and whether it can be knocked off through online traffic school. The defendant responds that the amount of the fine is not yet showing online. The defense makes the same objections to this email as it made to the last email, so it's the same ruling. In this email exchange, by the way, on the probative side, the defendant mentions that he plans to spend Thanksgiving with a bunch of his peeps, which I infer to mean his friends, and with his gal, Gargi, which he says should be fun. For all the reasons I have mentioned previously, including in the ruling on the admissibility of the last email from October 30, 2011, this email exchange, in my view, is probative of the issues of sanity and the culpable mental state elements of the crimes charged, and the probative value of the evidence is not substantially outweighed by any of the dangers listed in Rule 403. Consistent with my last ruling, if the defense wishes, I will order the prosecution to redact Mr. Holmes's comment, or excuse me, Mrs. Holmes's comment. No response to my email about your speeding ticket. Can you knock it off your record by online traffic school? And the defendant's response, I don't know about the traffic school. The fine isn't listed online yet. And by the way, that last sentence by the defendant implies to me that he had gone online and looked for the fine due on the ticket, something which again is probative of his capacity to understand the world around him, to process information, to react appropriately, logically, reasonably, and coherently to it. But as I said, I will still order those redactions if the defense wants them, because in my view, such redactions will not take away the primary probative value of the email, but will completely avoid any danger of unfair prejudice with respect to the speeding ticket. And the same thing is true with the last email. Next is number 4, an email from December 9, 2011, bait stamp number 3987. This is an email by Cami Kennedy, a program administrator at the University of Colorado, asking about the defendant's correct date of birth. The defendant responds with his correct date of birth. And if I remember correctly, I think she had 2 possible dates of birth and was trying to figure out which one was the right one. Ms. Spengler said, seemingly, I suppose, this is insignificant, but there's no relevance, and why draw the juror's attention to the fact that the university may have had 2 dates of birth to the defendant? I agree that this is insignificant in terms of any unfair prejudice or any risk for unfair prejudice. In terms of the probative value, the court relies on all the reasons I have previously articulated. Specifically, as it relates to this email exchange, I note that the defendant responds to a query by the school. He processes the information and replies with the information requested in an appropriate, reasonable, logical, and coherent format, which again goes to his state of mind and his mental processes, and by extension to the issues of sanity and the culpable mental state elements of the offenses charged. And in my view, the probative value of the evidence is not substantially outweighed by any of the dangers listed in Rule 403. Next is the January 16, 2012 email, bait stamp numbers 4456 through 4459. This is an email exchange between one of the defendant's professors, Diego Restrepo, R-E-S-T-R-E-P-O. All the email from Professor Restrepo says is that he marked up a document apparently submitted to him by the defendant using that's a small I, annotate, A-N-N-O-T-A-T-E, on the professor's iPad. There appears to be an attachment to the email with the defendant's submission, and there are 3 handwritten markings or notes by the professor on that submission. The last page, page 4459, bait stamp page 4459, has the defendant's response to the professor's constructive criticism. And the defendant's response is part of an email. Ms. Spengler is right that this email appears to contain a specific document that appears to be homework, but in terms of the and I don't believe the defense objects to the homework. I think the objection is to the email, if I understand correctly. But regardless, I think it's all relevant. In terms of the probative value, I rely on all the reasons previously articulated. As it relates to this specific part of the exhibit, I note that the defendant's response to the professor's constructive criticism shows his cognitive ability to understand and react to constructive criticism, his thought processes, the way he processed information, the way he put information together, all of which is relevant to the issues of sanity and the culpable mental state elements of the offenses charged. And the probative value of the evidence is not substantially outweighed by any of the dangers listed in Rule 403. Next, I have an email dated January 31, 2012, Bates stamp number 5334. This is an email by the defendant to Frank Guido, Guido. I think Frank Guido is a professor at the University of Colorado, and the defendant is inquiring about a third rotation. There's a reference in the email to the work being done by Mr. Guido or Professor Guido on impulsive aggression disorder.
Your Honor, just so the record's
Yeah.
clear, I think it's actually Guido Frank. I think the last name is first.
Okay, thank you. Guido Frank, thank you for that correction. And so I believe that the particular concern the defendant has is the potential for unfair prejudice as a result of the mentioning of impulsive aggression disorder. If this were the only email related to the defendant seeking to be admitted into a third rotation, I might understand the defense's concern with respect to the reference to impulsive aggression disorder, the subject of the research of this lab. But given that there are 4 emails that are almost identical and contain what appears to be boilerplate language, in which the defendant is requesting admission into a third rotation, and the only difference that I can see, substantive difference that I can see between the emails is the subject of the lab work being done, I'm not concerned because it is clear to me, and I think it'll be clear to the jury, that the email does not demonstrate the defendant's interest in impulsive aggression disorder. Rather, when the email is viewed in the context of the other 3 emails, the other 3 similar emails, it is clear to me that the defendant is simply trying to be allowed into a third rotation. That's consistent, by the way, with the evidence that the jury has heard so far. Additionally, there has been no mention in this case of impulsive aggression disorder as something that the defendant was concerned with in his self-diagnosis, nor has there been any reference to this disorder by any expert, and there's no evidence that this disorder was present in the defendant at any time, or that the defendant's alleged conduct at any time was consistent with this disorder. So in the end, I don't see much, if any, risk for unfair prejudice, and this email has probative value for all the reasons that I have said before, including with respect to the defendant's state of mind, ability to process information, the issues of sanity and the culpable mental state elements of the offenses charged, and the probative value of the evidence is not substantially outweighed by any of the dangers listed in Rule 403. Nevertheless, having said all that, if the defense wishes, in an abundance of caution, I will order the people to redact those 3 words from the email: impulsive aggression disorder. Such a redaction, in my view, will not take away the primary probative value of the email, but will completely avoid any danger of unfair prejudice.
And that was the long explanation by the judge as to why these email will be allowed likely later today. We keep teasing that. We don't know for certain. Clearly the schedules get mixed up, especially yesterday with the majority of the day being excusing 3 jurors from the jury pool, leaving 21. That lasted until I was in court, I think at 2 o'clock, right after lunch, is when actual testimony from Dr. Metzner continued. So clearly half a day was lost yesterday. It was likely that those emails would have been introduced into evidence and possibly hearing from the girlfriend yesterday. That's what we're anticipating later today. Looking at a viewer-submitted list, we're at 174 witnesses who have taken the stand. The majority of the survivors have been on the stand. I know we still haven't heard from a few. The one that really stands out to me, Ashley Mosier, I saw her in court during the first week of the trial. She was in a wheelchair on the right side of the gallery. Just from watching how this is unfolded and how they're kind of sprinkling some survivors and then some key witnesses and then some experts, I would venture to guess that she'll be one of, if not the last person to take the stand to leave that imprint on the jury from someone who survived but had some of the most horrific injuries. Again, Ashley Mosier, the mother of Veronica Mosier Sullivan, lost her daughter, lost her pregnancy, and was paralyzed in the shooting. She still has to take the stand, but we've heard evidence throughout the case pinpointing certain weapons, certain ballistics that would impact her and other victims and survivors of the shooting. Let's get you back into the Arapahoe County Courtroom number 201 for the second half of the morning of the trial.
Colorado versus James Eagan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. Let's bring the jury in, please.
Your Honor, could I ask one quick thing? In an upcoming witness very soon, we were going to address the issue of those Gmail chats, and I know the court had wanted to have an opportunity to look at them and rule on them. I just wanted to bring that to the court's attention.
Yes, could you get that for me, please? It's on my round table. Thank you. Thank you. I did have a chance to review People's Exhibit P-TR-649 last night and today, and mostly this morning. And for the same reasons that I ruled that Exhibit P-TR-1227 is admissible, I find that this exhibit is also admissible. So I incorporate by reference the lengthy comments I made yesterday with respect to Exhibit P-TR-1227. There were 3 objections made with respect to Exhibit P-TR-649 by the defense. One of them was under Rule 802 of the Colorado Rules of Evidence. That's the hearsay rule. To the extent that the Gmail chat between the defendant and his former girlfriend, I believe her name is Gargi Datta. His statements are not hearsay because they are admissions by a party opponent. To the extent that they contain Ms. Datta's statements, those statements are not hearsay because they're not being introduced for the truth of the matter, but rather to place the defendant's statements in context so that the jury can understand what it is that he was saying in the Gmail chat. In terms of the objection with respect to relevance and also the objection with respect to Rule 403, as to relevance, I find that these Gmail chats are probative for all the reasons that I stated in my lengthy ruling yesterday on Exhibit P-TR-1227. But I think in a way, this is even more probative than those emails because this exhibit depicts in a lot of ways the defendant's relationship with his former girlfriend. This was the first and only romantic relationship that he had before the shooting, and the experts who have testified so far, both of them, Drs. Reed and Metzner, have talked about this relationship. have relied to some extent on this relationship. There has been a lot of talk by the parties in the trial, including in opening statements and in the questions asked of witnesses, that have referred to the defendant's ability to form relationships and the defendant's ability to socialize. This has been a big theme throughout this trial. There seems to be a disagreement, as I said yesterday, between the defendant's shyness and the defendant's nature as an introvert were just personality traits, normal personality traits that you see in people sometimes, or whether they were indicative of some kind of mental illness. These Gmail chats also contain discussions about friends that the defendant has, so it's not just about his relationship with Gargi Datta, but also with respect to other friends. It also talks and shows information related to activities that the defendant was engaged in, things he was doing with friends, things he was doing with Gargi. It also contains information related to his views on school, and specifically some of the labs. There are a couple of Gmail chats that refer to or that appear to imply that he seems bored or unhappy with the work in the lab, and that he wishes he was doing different kind of work. I think at some point he refers to neuroscience and how he would be more interested. He's more interested in neuroscience, but that's a soft science. And that goes to, again, some of the themes that have been developed throughout the trial as to whether he was lacking in motivation for whatever reason at school, or whether the lack of motivation was an indication of mental illness. So that is also, the exhibit is also probative for that reason. There's some discussion as well about what's referred to as the rapist, and it appears that it may be a reference to therapy, a therapist, and I don't know if that's a take off of the SNL skit. Instead of referring to a therapist, it's the rapist. I think in one particular Gmail chat, the defendant refers to the rapist, and he's asking Gargi if she's going to go see the rapist, and then he adds something like, for $400, Alex, referring apparently to Alex Trebek. And that's the skit from Saturday Night Live where they're playing Jeopardy, and instead of saying therapist, the person says the rapist. And it appears that Gargi is going to therapy. The defendant talks about how he had therapy when he was young, but it was group therapy with his family, and he didn't enjoy it. So it's relevant for that reason too. There are statements in here, I think, that that are probative of the defendant's views to some extent about therapy and therapists. Those are the notes I wrote. So for all those reasons, it is clearly relevant under Rule 401. The question then is it admissible under Rule 403? And I haven't heard anything that leads me to believe that this would be, that there is a risk of undue prejudice, or that any of the concerns listed in Rule 403 would require the exclusion of the exhibit. In my view, the probative value of the exhibit is not substantially outweighed by the dangers of unfair prejudice. And I want to make clear that Ms. Brady, I think, told the court yesterday she has no objection to the last Gmail chat, the one from March 25th of 2012. And it's a lengthy Gmail chat, but and it's one that Dr. Metzner specifically relied on in forming his opinions. But in my view, if I'm going to admit that Gmail chat, I think, again, it is important to admit some of the earlier Gmail chats. It goes to what I said yesterday. You can't just show the picture between March and July and expect the jury to assess and evaluate all of the arguments and all of the issues that are being made in this trial. You have to have some point of reference for the jury. You have to provide the jury a point of reference, something to which it can compare the defendant as he was in 2012, and specifically between March and July of 2012. If the jury's just shown that snapshot, the jury can't assess the arguments that I have discussed that have been developed throughout this trial, and the contentions that are being made and the issues that are being put before the jury. So I think in terms of the time frame, it is relevant. I think the earliest Gmail chat goes to October 10th. It's certainly within the time frame that the experts have talked about. Both experts have said that the defendant had negative symptoms or some type of symptoms of mental illness even before then, and so this is within the relevant time frame. It is certainly within the school life of the defendant, and so it's also within that time frame as well, which I have discussed at length before. So for all those reasons, I find that the probative value is not substantially outweighed by any of the dangers listed in Rule 403. So it is admissible. All right, Mr. Brockler, you may approach and you may retrieve the exhibit. And with that, are you ready for the jury?
Yes, sir.
All right. Are you ready for the jury, Ms. Spengler?
We are, Your Honor. I do notice that the model is out, and this might be a good time or perhaps closer to the lunch break for the court to read the instruction regarding the model.
Yes, thank you for reminding me. Let me try to find it. I will give it at the next time that it's used, okay? All right, let's bring the jury in, please. And before I do that, actually, I think the prosecution was going to review the instruction. Let me just make sure the record is complete on this. What happened is the defendant tendered an instruction, and it's been marked as defense tendered instruction number 1. I made some revisions to it, and I gave the defense a couple of choices, and one of them was just to have the first paragraph of this instruction as I have revised it. The other one was to have both paragraphs of this instruction, which I which basically is the two paragraphs in my instruction follow the two paragraphs in the tendered instruction, but I have revised both paragraphs. As I understood it, without waiving her objection, Ms. Spengler chose the instruction that has both paragraphs with my revisions, as opposed to just having the first paragraph. And do the people have anything to add to this or anything to say, any objection that you want to make, any additional objection? I overruled your request to introduce the exhibit as substantive evidence, but is there any objection to the instruction as I have revised it?
No, Your Honor.
Okay, thank you. Let's bring the jury in, please. Please be seated, everyone. The record should reflect that the jury has joined us again. Welcome back, members of the jury. Call your next witness, please.
Patricia Legreta Roars.
Good morning. Could I have you raise your right hand for me so that I can administer an oath? Do you solemnly swear or affirm under penalty of law that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? Please be seated. Please tell us your full name and spell your first, middle, and last names.
My full name is Patricia Legarreta Roars, Patricia Legarreta Rohrs.
All right, Ms. Tish-McGuire, you may proceed.
Thank you. And I'm going to first ask you to pull that microphone really close to you. Thank you. Were you at the Century 16 movie theater on July 19th of 2012 in Aurora, Colorado?
Yes.
Did that go into the early morning hours of July 20th of 2012?
Yes.
Please tell the jury a little bit about what you remember from the day of July 19th prior to going to the movie theater that day.
I was grocery shopping. My boyfriend at the time was sick. I was running around doing all the errands. I had gone to Sam's Club, Walmart.
What time did you decide to get the movie tickets that day?
I had finished around 4 or 5, and the Walmart is close to where the theater is at, so I called my boyfriend to see one last time if he wanted to go to the midnight premiere of Batman, and when I called, he had, was like, yes, let's go. So before I went home, I stopped and got tickets for all of us, and then went home.
Could you please tell the jury who all of us is?
All of us is my boyfriend at the time, who's now my husband, Jamie Roars, my daughter Azariah Roars, and our son Ethan Roars.
Now, how old was Ethan Roars at the time?
He was 4 months.
4 months old.
Yes.
And how old was Azariah?
She was 4 years old.
Okay. What time did you arrive at the movie theater that night?
I don't know the exact time, but it was after 11.
What'd you do when you got to the movie theater?
We found seats, and then my daughter needed to use the bathroom, so me and her went to use the bathroom, and then we went back into the theater, sat down, and I remember I hardly ever pay attention, but they were showing, it wasn't previews, but like commercials, and me and my daughter were freaking out and laughing because it was the first time that we'd ever been in a theater that had a back exit. And so me and her were like, oh, how cool, turned around, noticed the exit, and then that was it before.
What brought your attention to the fact that there was a back exit?
Like I said, the fact that I'd never been in a theater that had one. Usually it's just front exit. So me and my daughter thought that that was cool that we were, first time being in a theater with back exits.
Was there a commercial that drew your attention to that back exit?
Yeah.
Judge, I'm going to object at this point to cumulative.
Overruled.
You can go ahead and tell the jury.
I, remember the whole cell phone thing and dancing cell phone, and then just the fact that it was like showing know your exits, and talked about the ones at the front, and then when it said the back, I was like, oh, that's different.
Was there anything about the previews for movies that you remember?
I don't remember all of them. I do specifically remember the Superman preview because I remember a male shouting like yay or woohoo, and a cheer of excitement, and everybody kind of like laughing like.
Your Honor, if I may approach the witness with what's been marked as People's Exhibit 1159.
Yes.
Do you recognize that diagram?
Yes.
Does that diagram fairly and accurately represent what you remember happening on July 20th of 2012 in the theater?
Yes.
Your Honor, at this time I'd move for the admission of People's Exhibit 1159.
Is there any objection?
No objection.
Without objection, it is admitted.
Your Honor, at this time with the court's permission, I would ask Ms. Legarreta Roars to join me at the 3D model to describe for the jury what she remembers happening in the theater that night.
Okay. And members of the jury, this is a good time for me to give you an instruction. It's as follows. This is an instruction with respect to People's Exhibit P-TR-1087, which is the physical model of the inside of Theater 9, a portion of the inside of Theater 8, and the area outside of Theater 9. I'm referring to the model that's there in front of you. A mark on this exhibit was corrected following the testimony of Brett Mills. Mr. Mills testified that the single impact in row 1 at seat 16, identified in earlier testimony by crime scene investigator Maria Perolina, was actually a fabric tear and not related to a bullet or bullet fragment. Therefore, the circle drawn by investigator Perolina on seat 16 in row 1 has been removed from the exhibit. Exhibit P-TR-1087 is a demonstrative exhibit and has been allowed by the court only for use in the courtroom to help you visualize certain physical spaces at the Century 16 theaters and to allow witnesses to explain and illustrate their testimony. Therefore, this exhibit is distinguishable from items that have been admitted as substantive evidence, which you may have an opportunity to view during your deliberations. Does everybody understand that? And people are nodding their head yes and saying yes. All right, with that instruction in mind, ma'am, you may step down and bring the handheld microphone if you would, please. Yes, thank you.
If you just turn that on, please, and I'll have you kind of stand right back here with me so the jury can still see everything. All right, if you could please, first of all, show the jury where you were seated that night.
We were seated about row 14, 15, around this area.
All right, so if you could just make your best educated guess and then tell them where exactly, what seat you were in.
She can't guess, she can estimate.
I apologize, Your Honor. If you could just show the jury approximately where you believe that you were seated that night.
This row.
Okay.
And
if you could tell them what seat you were in.
I was in this seat.
Okay. And what seat was your boyfriend at the time, Mr. Roars, in?
He was in this seat, and Azariah was sitting in between us.
Right, and where was your son Ethan?
Ethan was asleep, and he was in my boyfriend at the time's lap.
Now, what do you recall happening in the movie theater that night?
I remember watching the movie and at some point seeing the exit door on the right side opening and seeing something come flying across and around right here in this area. You heard a pop and then smoke, and I remember thinking like a prank, or sometimes you hear about different midnight premieres, doing different things, and so we continued watching, and then you see the exit door open again, and you could see it because it was so dark, but you could see the light, and I just remember hearing popping sounds, and my boyfriend yelling to get down, and my daughter was asleep, so I remember grabbing her and just throwing her to the ground and laying on top of her.
Now, could you show for the jury on the diagram where it was that you would have been putting Azariah on the ground and laying on top of her?
Right here.
And then what do you recall while you were on the ground with Azariah?
I just recall trying not to panic and thinking to myself to just thinking this isn't happening. And then I remember looking up and seeing my husband cradling Ethan and jumping over the seats to get safety because he was struggling to find room.
Objection as to speculation.
Sustained.
All right, so you saw him physically jump over seats?
Yes.
Okay, and what did you see him do?
After seeing him come over, I didn't see anything else, like where he went.
Okay, so you lost sight of Ethan
Yes.
and Mr. Gores at that point?
Yes.
So what happened with you and Azariah at that point?
We stayed down, and I just remember poking my head up to kind of see what was going on, to figure out what our next step was going to be. And I remember putting my head up and seeing flashes, and I put my head immediately back down, and as soon as I put it down, I remember feeling a pain in my right leg, and I remember screaming and saying, I think I got shot. And then I remember a voice behind me saying...
Objection as to hearsay.
Is it being offered for the truth?
No, Your Honor.
What's it being offered?
It's offered for the effect on the listener.
Right, the objection's overruled.
Right, you can go ahead and tell the jury.
I remember hearing a voice say that I did too, and I remember feeling just a little bit of comfort knowing that I wasn't alone. And it was at that point where I realized that any movement that I made, if I was visible, it was probably going to be shot in that direction. So I tried to stay low, but I was still in my head trying to think, you know, I need to get out of here. I can't stay in here. And at that point, I heard crying, and I looked up in the aisle and found Ethan. And I remember grabbing him, and that's when I knew that I had to get out. So I just started listening, and I noticed that the shots weren't coming as quickly. And that was when I took my opportunity to get up, and I pulled my daughter up and I dragged her up the stairs. And I remember there was that exit, and I knew I just had to get out those doors. And I remember going through the doors, and I was literally dragging Azariah behind me and holding Ethan and just trying my hardest to just get up.
So now when you found Ethan, was Ethan by himself?
Yes, he was.
Okay. And when you said earlier you had stood up and you saw some flashes, could you tell the direction of those flashes?
I could see that they were on that side of the theater.
And when you were hearing the gunshots in the theater, could you hear any different types of gunshots?
Yes, I noticed
I'm going to object now to foundation.
You can go ahead and tell the jury.
I remember that there were differences, like rapid shots, and then there were some that were a little deeper, but not as rapid.
And when you said that you heard the voice of someone also behind you who had said that he got hit also, where was that? Was that person in the same aisle as you?
Yes, it was in the same aisle.
So when you said behind you,
it was, yeah, we were right here, so somewhere, yeah, in that seat right there.
now did you have an opportunity after the shooting to meet that individual?
Yes, I did.
Judge, I'm going to object at this point. It's no longer not being offered for the truth of the matter asserted.
I don't think the question called for hearsay, so the objection's overruled. I don't think it was a question about what was said.
Thank you. Thank you, Your Honor. So did you have an opportunity to meet that individual after the shooting?
Yes, I did.
And do you know who that person is?
Yes, I do.
And what is that person's name?
Jarrell Brooks.
Okay. So how did you go about, just if you could show on the diagram how it was that you went out about getting out of the theater?
I grabbed the kids and ran up this way, and I remember having to go through one door, and it was a little room, and then going out another into like a staircase that went out into the lobby.
All right. And earlier, I think I'd asked you if you had an opportunity to hear different types of gunshots, and what were the differences that you remember hearing?
Some of the shots were more rapid, constant, you know, boom, and then the other set was not as rapid, but like a deeper sounding.
Thank you very much. You can go ahead and take your seat back at the witness stand. Now, what happened when you...
Hold on, Mr. McGuire, before you proceed. The last objection as to hearsay is actually now sustained based on what you said. This went to identification, but there was not enough foundation, so that is hearsay. So the statement by this witness as to who the person was behind her, that is stricken, and the jury will disregard it and treat it as though it never heard it. All right, you may proceed.
After you got through the door, the theater, what did you do next with Azariah and Ethan?
I remember walking around the parking lot, hoping to find Jamie, because at that point I had no idea what happened to him. I left my purse and cell phone in the theater, so thankfully someone lent me their phone, and I called him.
And I'm going to object to relevance as to what happened outside of the theater.
What's the relevance?
There's how she goes about getting medical treatment.
Okay, the objection is overruled.
So someone lent me their cell phone, and I was able to get a hold of Jamie. We found him right away, and he could see that I was bleeding from my leg. So he, instead of waiting, because at the time it was still chaos, So we jumped in his truck and he drove me straight to the hospital.
What hospital did you go to?
Is it the Colorado University? I can't remember the exact name.
University.
Yeah, University Hospital.
What injuries had you sustained at the theater?
It was shrapnel.
Your Honor, if I may approach the witness with what's been marked as People's Exhibits 2548 and 2547.
Yes.
Do you recognize those photographs?
Yes.
Could you, do they fairly and accurately represent you at the theater on July 20th, you at the hospital on July 20th of 2012?
Yes.
Okay, and do they fairly and accurately represent the injuries that you sustained?
Yes.
Your Honor, at this time I'd move for the admission of People's Exhibits 2548 and 2547.
Any objection?
No objection.
Without objection, P-TR-2547 and 2548 are admitted and may be published.
Thanks. If I could please have 2548. All right, this is a picture of you at the hospital that night?
Yes.
Or early morning, rather. And if I could please have 2547. And that's the injuries you sustained to your leg?
Yes.
Did you also sustain some shrapnel injuries to any other part of your body?
Yes.
And could you tell the jury about that, please?
You can take that picture down.
On my right leg as well, all the way up my thigh and up to my hip.
You had shrapnel injuries all
Yeah.
the way up, and they just didn't take pictures of those?
No.
I have no further questions. Thank you, Your Honor.
Is there any cross-examination? Ms. Spengler?
No, there's not.
And the jury does not appear to have any questions. May this witness be released from her subpoena?
Please, Your Honor.
Is there any objection?
No objection.
All right, ma'am, thank you. Call your next witness, please.
Gordon Madonna.
Good morning, sir. You solemnly swear or affirm under penalty of blood that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Yes, I do. All right, please be seated. Can you hand me those two exhibits? Yes. Thank you. Melissa? You're there. Thank you. Could you please state your full name for the record, and please tell us or spell your first, middle, and last names?
Do I have to give you my middle name?
You
Gordon.
can do an initial if you'd like.
Gordon G. Madonna, and that's Gordon Madonna.
And what's your middle initial?
G.
G? Okay. All right, you may proceed, Mr. Edson.
Thank you, Your Honor. What is your occupation, sir?
I'm a police officer, detective,
With what agency?
Aurora Police Department.
How long have you been a police officer with the Aurora Police Department?
With Aurora, 21 years.
Do you have any prior law enforcement experience?
Yes.
Tell us about that, please.
40 years law enforcement experience.
What type of assignments have you worked as a police officer for the city of Aurora?
I've worked from patrol to what they call the Police Area Representative Program, which is PAR. Worked for, in that assignment, business specialties. I've also worked through crime prevention, through environmental design with the planning department. I've taught DARE for quite a few years. I've been a detective for quite a few years, working various assignments from larceny to economic crimes, or fraud, crimes against children, and digital forensics.
Are you currently a detective?
Yes, I am.
What is your current assignment with the Aurora Police Department?
I'm on assignment to the Federal Bureau of Investigation. It's called the Regional, or the Rocky Mountain Regional Computer Forensics Lab, which is down at Dry Creek and I-25.
Is that also sometimes just referred to as RMR CFL?
Yes.
What do you do for RMR CFL?
I'm a forensic examiner.
What is a forensic examiner?
Forensic examiner, digital forensic examiner. We examine various digital devices such as computers, cell phones, in the past PDAs, digital cameras, things like that.
Could you tell us about your educational background, please?
I have an associate's degree of applied science and criminology from the Community College of Aurora. I've attended Metro State College, plus well over 1,000 hours in computer forensics training.
Are you in fact a computer forensic examiner?
Yes.
Tell us about any specialized training you've received in the field of digital and computer forensics and examinations.
I initially started in 2000 with my first examiner training. I've had various classes from the tools that we use, such as Access Data's Forensics Toolkit, guidance softwares, EnCase, X-Ways Forensics, Max Forensics, Parabon, the list goes on.
In general, something like the forensic toolkit you talked about, what are we talking about? What are those things?
That is the software that we use to be able to analyze digital evidence.
Have you received training and background education in a variety of type of software for a variety of different types of electronic devices and computers?
Yes.
Is that ongoing training?
Yes, it is.
Talk to us about that, please.
Well, initially, you get your basic training and so forth, and then you have to take usually 2 classes a year minimum training. We normally do a lot more than that. And then every year you have to pass proficiency tests to show that you're capable of using the software.
Have you been doing that?
Yes.
What type of software are you getting this continuing accreditation?
And the different tools that we use, such as FTK by Access Data, Forensics Toolkit, that's acronym for it, EnCase, X-Ways, Internet Evidence Finder by Magnet Forensics, those type of tools.
I'm going to kind of break this down a little bit. Some of the devices that you perform examinations upon, forensics examinations, does that include computers?
Yes, it does.
Does that include laptop computers?
Yes, it does.
Some of the newer tablets, does it include that?
Yes.
Does it also include the variety of cellular phones that are available?
Yes.
Does it also include other electronic devices, music devices, Apple devices, Mac devices, things like that?
Apple devices, Mac devices, yes.
What about the various companies, Google, Microsoft, things of that nature?
That usually enters into it, yes.
Okay. Are you a member of any professional organizations in relation to the area of computer forensics?
Yes, I am.
Tell us about that, please.
I'm a certified forensic examiner with the Federal Bureau of Investigation. I'm a member of IASIS, which is the International Association of Computer Specialists, member of HTCIA, High Tech Crime Information Association, Investigators Association, the HTCC, High Tech Computer Crime. And I may be missing some of the acronyms there a little bit. And I've also belonged to the Colorado Association of Computer Crime Investigators, past president, vice president, secretary, board member, so forth.
I may have missed this, but do you currently have a certification with the FBI related to computer forensics?
Yes, I do.
Did you have to go through any specialized training related to that?
Yes.
Tell us about that, please.
It's normally a 2-year program of intensive training classes that you have to attend, minimum criteria. And I began that certification process back in 2005 and was able to complete it in 9 months.
Does that also require ongoing training?
Yes, it does.
And have you been doing that?
Yes.
Are you familiar with the acronym CART, C-A-R-T, in relation to computer forensic analysis?
Yes.
What is that?
CART stands for Computer Analysis Response Team, which is actually the program or the bureau, or well, not bureau level of the FBI that sponsors the digital forensics labs.
Are you a member of that in any sort of way?
As a task force officer, yes.
Okay. Have you received any sort of, are you required to go through that type of training to maintain certification?
That would be the same training, yes.
Okay. Have you successfully completed yearly proficiency testing?
Yes,
Have you done that every year since you've been certified?
yes.
What exactly, if you would please, is the Rocky Mountain Regional Computer Forensics Lab that you work at?
The lab is one of 16 labs that's scattered across the United States. Our territory is Colorado and Wyoming, so any law enforcement agency within those jurisdictions can submit evidence to us. We also assist other labs throughout the United States when they get backed up or national emergency, whatever it happens to be, some big event, we'll assist those. We're deputized U.S. Marshals. We can travel anywhere in the United States.
Is that you are as well?
Yes.
Okay, continue.
This lab is consists of, I think it's, last I checked, 13 different agencies that are participating throughout the Denver metro area. And I think we had, last I checked, was 19 examiners or people assigned to that lab.
How long have you personally been a computer forensic examiner?
Since 2003, and with the Bureau since 2005.
In the same capacity?
Yes.
Even prior to your assignment with the Rocky Mountain Regional Computer Forensic Laboratory, had you received any previous digital or computer forensic training?
Yes.
Talk about that, please.
Started in 2000, year 2000 with NW3C, basic data recovery, and completed quite a few classes up until then. And then 2003, we initiated the in-house computer forensics lab in Aurora. And from there, 2004, I went to what at that time was a regional computer forensics lab in Douglas County. I was there until we merged into the FBI lab in 2005, April.
And is that merger still in effect today?
Yes, it is.
Was that merger in effect back in 2012?
Yes.
Have you ever testified in court as a digital computer forensic and or cell phone examiner?
Yes, I have.
In what types of courts have you previously been qualified as an expert?
Been qualified in the as an expert in the 18th Judicial District in Arapahoe County, Douglas County, the 2nd Judicial District, Denver, Aurora Municipal Court, 17th Judicial District, Adams County, and the 10th Circuit U.S. District Court, State of Wyoming.
If you had a rough estimate as to how many times you've testified as an computer forensic examiner for computers and or cell phones in an expert capacity, what might that be?
I think it's about 7 times.
In your career as a computer forensic examiner, if you had to kind of ballpark for us how many examinations and pieces of evidence that you've conducted as an examiner, what would your answer be?
Last I checked, which has been a while ago, I've done over 600 examinations, over 78 terabytes of data.
What's a terabyte?
It's a very big, long figure. A terabyte, if you had to explain it, well, the Library of Congress, last figures I've seen was about 28.5 terabytes. So that's about 2.5 times the Library of Congress.
Okay. Are you familiar with the term peer review in your field?
Yes, I am.
Do you engage in peer review frequently when you're examining items of evidence?
Yes, we do.
Your Honor, to relevance, bolstering.
Overruled. Go ahead.
Yes, we do.
What exactly is peer review?
Peer review is any examinations that we do in the FBI lab. We require 100% peer review. So you do your examination, you create your notes, write your notes, and so forth, and another examiner has to look at that, follow your notes, read them over, and they have to be able to theoretically complete or do the exact same examination that you performed and come up with the same results.
Is the Rocky Mountain Regional Computer Forensic Lab an accredited lab in any sort of way?
Yes, we are.
Explain, please.
We're accredited through the ASCLD, which is the American Society of Crime Lab Directors, and we're accredited internationally. I believe we completed our first certificate or accreditation in 2008, and then just recently 2013.
Forgive me if I've already asked this, but going back to your being an expert and previously testifying in other courts, has that also been for cell phone analysis?
Yes.
So at this time, I would move for admission of Detective Gordon Madonna as an expert in the area of, in the field of forensic examination of computers and electronics to include computers and cell phones. Under 702, People versus Shrek, and the court's previous rulings in this case.
Any objection, Ms. Spengler?
No objection.
All right, without objection and based on my previous ruling in order D-108 and pursuant to Colorado Rule of Evidence 702 and the decision in People versus Shrek, which is published at 22 Pacific 3rd 68, 2001, the court will accept, is it investigator or agent or?
Detective.
Detective Madonna as an expert witness in the field of forensic examination of computers and electronics to include cell phones. What that means, members of the jury, is that I have accepted him as an expert witness in that field, and now he is permitted to render expert opinions in that field because he has been qualified to do so. I remind you that you're not bound by the testimony of a witness who testifies as an expert. The credibility of an expert's testimony is to be considered as that of any other witness. You may believe all of an expert witness's testimony, part of it or none of it. The weight that you give the testimony is entirely your decision. With that, Mr. Edson, you may proceed.
Thank you, Your Honor. I think nowadays most everyone knows what a computer is, but tell us what forensic examinations of computers, what does that entail?
The process entails the department, police department, or whether it be the Aurora Police Department or any other law enforcement agency, submitting a request for service for our services, along with a copy of the search warrant authorizing them to do so in an affidavit. That, whether it be in the FBI lab or the Aurora lab, is basically the same process. That has to be reviewed, and if the examiner and the intake people concur that the agency has a jurisdiction through the warrant and so forth, then we'll accept the evidence, make reservations for them to drop off the evidence, whether it be computers, cell phones, things like that. And then that evidence is entered into a controlled system, evidence control unit, where it's barcoded, labeled, tracked through the entire process. And then the digital evidence is then what we call imaged. In other words, we make a copy of that digital evidence, and then we work from the copy and protect the original evidence. That is processed through our forensic software, and then the examiner will look through, with using that forensic software at the information that's on those devices at the request of the law enforcement agency. Some may be looking for specific things, whether it's pictures or it's what we call, also refer to sometimes as images or documents, those type of things.
Okay. Are there a specific, let me retract that statement. I get the sense there's a couple of different labs. You talked about an Aurora lab, and then you said the Rocky Mountain lab. Are there two different labs?
Yes, there is.
Talk to the jury about that, please.
Okay. I'm assigned to the Rocky Mountain Regional Computer Forensics Lab. The Aurora Police Department has a computer forensics lab also. That's in-house. One examiner is assigned to that lab.
Who is that examiner?
That's Mike Leiker, Detective Mike Leiker.
Okay. So just so we're all on the same page, you are a detective with the Aurora Police Department, correct?
Correct.
Do you work in the Aurora lab?
Occasionally, when they need assistance, yes.
Okay. But you also work in the Rocky Mountain lab as you previously
That is
said.
my full-time position, yes.
You use the term making a copy or an image of the computer hard drive, I believe.
Yes.
Talk to us about that. How does that work?
Well, most everybody here has had computers. You know what a hard drive is. The hard drive is a piece of equipment inside that computer where all the information is stored. That when that computer comes into our facility, whether it be Aurora or it be the Rocky Mountain Lab, That hard drive is removed from the computer and is placed behind what we call a write blocker. That write blocker can be a physical write blocker, which is actually a piece of equipment, or it can be a software write blocker, which is actually operated through software. And the idea is to preserve the original evidence so that you do not alter or change anything on that original evidence. And what we do is we acquire that to our servers. And at the very beginning, we use what's called a hash, or in this particular case, a MD5, which stands for Meta Digest 5, which is an algorithm that we can apply against that hard drive, and it gives us a digital fingerprint of what the information is on that hard drive. When we're done with our imaging, then we'll run that hash against the image, and we should get the same digital fingerprint. If we get a different fingerprint, we know that something's changed. Okay, and then we go back to square one and figure out what's going on. Sometimes hard drives start having problems, what we call flipping a bit. If a 0 changes to 1 or something like that, it's going to throw that entire MD5 hash off, and we'll know that something's wrong. So that's how we check and verify that we have the exact information that's on that hard drive. Once that occurs, then the hard drive goes back into the original computer. It stays in property until it's released back to the original agency or back to the property unit in Aurora.
Why do you not work on the original hard drive?
It's just like any other scientific analysis. You want to preserve the original evidence. So another examiner can come in and do the same imaging and come up with the same results.
What do you do with the original hard drive or the original actual computer once you're done making the copy as you described?
Once we're done with it, it goes back into our evidence, and it stays there until the report is released to the agency, and it's transferred back to their evidence control custody.
Is there any difference between when you look at the hard drive of a computer, say a tower computer, like you can buy anywhere, versus a cell phone?
Yes.
Tell us about that, please.
Well, with hard drives and so forth, they're a little bit easier. Cell phones, the minute you turn on a cell phone, it's automatically changing its memory. Okay, so a hard drive is magnetic. It's either there in what we call bits and bytes, or with a cell phone, that's different. A cell phone, it has to be designed in such a way so that it's constantly changing its memory. It's reorganizing that so that it's more efficient, whereas you don't see that on computers unless specifically told to do so, commanded to do so.
When you're conducting a forensic examination of a piece of electronics like a computer, what information or evidence are you specifically looking for?
It depends on whoever, what we refer to as the case agent, the detective that submitted the request, what they're looking for. If they're looking for, if it's child pornography, images, those type of things. If it's a white-collar crime, such as your documents, spreadsheets, and so forth.
Now, you're a detective with the Aurora Police Department, correct?
Yes.
Describe how your role, even though you're a detective, when you're conducting a computer forensic examination for a case agent like you just described, or in this case, someone like Detective Apple, what is your role versus the other detective within the Aurora Police Department?
Well, we don't act like investigators, okay? We only specifically look for what we're asked to look for and that type of thing. We're totally removed from the investigation. A lot of times we don't know anything about the investigation itself other than what we're told. The specifics of how that computer, that equipment got there. I guess the Bureau refers to it as dispassionate scientists. So we don't have anybody overlooking us saying, you know, you have to find this or you have to do that. It's completely independent.
Okay. Are you familiar with a tool called Cellbrite?
Yes.
What is that?
Cellbrite is a tool, a software tool that's designed to acquire information from cell phones.
The forensic toolkit, the FTK, can that be used on cell phones?
Yes, it can.
What else can it be used on?
Computers, hard drives.
Is that a common software that you use in analysis?
Yes.
When you are conducting an examination of the copy as you described, do you ever create any sort of images or documentation as to what you're finding.
Yes.
Describe that, please.
Ultimately, when the examination is completed, if there are findings, we will complete what's called a findings disc or DVD or Blu-ray, depending on what it is, and that will contain the items that we found that were pertinent to the case.
And those items, are those the ones based on what the case agent had requested of you?
Yes.
I'm going to direct your attention to July of 2012, specifically July 21st of 2012. Were you then a detective with the Aurora Police Department?
Yes.
Were you at that time assigned to the Rocky Mountain Computer Forensic Laboratory?
Yes.
On July 21st, 2012, did you become involved in any sort of way related to the theater shooting case at the Century 16 Theater?
Yes.
I'm going to backtrack to July 20th. We all know the dates of when this happened. Did you have any involvement on July 20th from a detective perspective?
No.
What was the first aspect of your role in this case, going back to July 21st, 2012?
On the 21st, about 9 a.m., I received a phone call from Detective Mike Leiker, Aurora Police Department, requesting assistance.
You described him already, but who is Detective Leiker?
Detective Leiker is the computer forensic examiner for the in-house lab at Aurora.
Do you oftentimes work with Detective Leiker?
Yes.
Was there a particular piece of electronics that you were requested to assist in the examination with back on July 21st, 2012 at that time?
Yes.
What was that?
An iPhone?
Your Honor, may I approach to retrieve an item of evidence, please?
Yes.
Thank you. Sir, I placed before you what's been previously admitted as People's Exhibit 538. Do you recognize that?
Yes, I do.
What is that?
iPhone?
Is that the iPhone that you were requested to conduct an examination upon?
Yes.
Where was the iPhone when you first received it?
It was already at the Aurora Police Department computer forensics lab.
Did you begin work on the examination of the iPhone at that time?
Yes.
Was that a computer forensics examination?
Cell phone or digital cell phone examination.
Okay. At some point, again on July 21st, 2012, were you requested, was your presence requested related to other electronic items?
Yes.
Talk to the jury about that, please.
I was requested to respond to, and I have to look at the exact address, I think it's 1690 Paris Street, to meet with the ERT team, which is the evidence response team from the Federal Bureau of Investigation, to collect digital evidence.
Are you familiar with the Federal Bureau of Investigation's evidence response team?
Yes.
Had you worked with them prior to July 21st, 2012?
Yes, quite a few times.
Are you familiar with an individual by the name of Dan Lehman?
Yes, I am.
Who is that?
He is the supervisor for the ERT team, special agent.
Are you familiar with the, well, let me ask it this way. Did you respond to the 1690 Paris Street address in Aurora?
Yes, I did.
Are you familiar with that area of Aurora?
Yes, I am.
What county is that in?
Adams County?
Are you also familiar with the Century 16 Theater?
Yes, I am.
What county is that in?
That's Arapahoe County.
Did you ever go to the theater for any reason on July 21st, 2012?
No.
What did you do when you arrived to the Paris Street address?
Talked to the detectives that were there. I believe it was Detective Wilson, the supervisor Pat Smith, and Special Agent Dan Lehman. They advised me of the status of what they were doing and so forth, and that they weren't ready for me yet. So I kind of waited around for them until they asked me to respond inside to collect the evidence.
Would that be Detective Tom Wilson?
Yes.
Were there items of evidence you ultimately received or took into custody?
Yes.
What were those items of evidence?
The tower computer, NZXT, I believe, a Lenovo tower, Toshiba laptop, a Lapan tablet. There was a modem and a wireless device, and I think there was about 7 items.
Where were those items when you took them into your possession?
They were in the hallway next to on the 3rd floor next to the apartment.
Okay, were they right outside of the apartment?
Yes.
When you arrived on scene, was there law enforcement keeping watch over those items when you arrived?
Oh, yes. Special agent from the Bureau, Jeff Holmes, was there.
Okay. Are you familiar with Jeff Holmes?
Yes, I am.
Did you take into custody those items from Jeff Holmes?
Yes.
What did you do with the items?
Myself, Detective Wilson, Tom Wilson, and the CSI, Darvin Harrell, brought those items down to the CSI van and placed them in the back there, closed it up, and CSI Harrell drove him to the Aurora Police Department, and I followed him immediately behind him. And once at the Aurora Police Department, we unloaded the van, brought him directly up to the computer forensics lab.
Did you maintain eye contact with CSI Tech Harold the entire trip?
Yes.
What time was this at?
I'd have to look at my notes to be sure. I think I went upstairs about 7:30, and it was about 8:30 when I finally received the evidence.
In the evening?
Yes.
And this is again July 21st?
Yes.
What happened to the items once you took them to the laboratory?
They're brought into the lab. They have to be inventoried. They have to be photographed. They were processed for fingerprints and DNA evidence.
And did all of that occur in this case?
Yes.
At some point later in July 21st, later in the evening of July 21st, 2012, did you receive some additional electronic type items from the apartment?
Yes.
Talk about that, please.
Special Agent Holmes responded to the Aurora Police Department, and he had 2 thumb drives in his possession, and advised that they came from the apartment and he needed to add them to the evidence to be processed.
How many total thumb drives were examined?
I would have to refer to my notes to be specific.
Would it refresh your memory to refer to your report?
Yes.
Okay. Judge, can I have one moment, please?
Yes.
Detective, did you co-author an 8-page computer forensic report related to the items that were analyzed in this case?
Yes, I did.
Would that report refresh your memory?
Yes, it would.
I'm not sure if I asked, but may I approach, Judge?
Yes, you may.
So a couple things. I've handed you what's been, appear to be at least an 8-page document. Are you familiar with that document?
Yes, I am.
What is that?
This is our findings report.
Okay. What I'm going to ask you to do is to read through that, tell me when your memory is refreshed to the question as to how many thumb drives were ultimately analyzed, and then just go ahead and flip that over if you would, please. That refresh your memory, sir?
Yes, it does.
Go ahead.
3 thumb drives.
So you received 2 later from Jeff Holmes?
Yes.
What about that other one? When did you receive that?
That was at the initial scene.
Your Honor, may I approach the witness, please?
You may.
I've handed you what's been previously marked as People's Exhibit 4885 and 4886. Do you recognize those two?
Yes, I do.
What are those photographs of?
These are, the first one, 4885, is a picture of the CyberPower PC, the NZXT that we examined. And 4886 is a close-up of the evidence label that's on that computer.
The same computer?
Yes.
All right. Those photographs accurately depict the eCyber Power Tower, the NZXT, as you referred to. Those photographs accurately depict that tower when you conducted your examination upon it?
Yes.
Judge, I would move for admission of 4885 and 4886.
Is there any objection?
No objection.
Without objection, P-TR-4885 and 4886 are admitted and may be published.
Thank you. If we could have 4885, please. Thank you. The items that you previously described, the evidence items, the ones that you took into custody at the apartment, as well as the thumb drives that were later brought to you, did you conduct examination upon those items?
Yes, I did, along with Detective Leiker.
Okay. Now I recognize there's a difference between the hard drive, like that tower, that type of examination, versus a cell phone examination. Is that fair to say?
Yes.
Did you conduct the appropriate examination on both of those items?
Yes.
Were the digital examinations, forensic examinations, conducted in accordance with the lab policies and protocols?
Yes.
Just so we're clear, where were the examinations, where did that take place?
At the computer forensics lab at the Aurora Police Department.
You described earlier that you oftentimes work off of what a case agent had submitted to you as far as a request. In this case, did you get a request from a particular detective related to those items?
Yes.
Who was the detective that submitted a request?
Detective Apple?
Is that Detective Craig Apple?
Yes.
Gentleman to my right?
Yes.
What was the request from Detective Apple as far as the examination of those items? What was he requesting?
He was looking for images, documents, internet, web history, relating to anything involving firearms, ammunition, explosive, things like that.
Did you stay within the parameters of Detective Apple's request?
Yes.
Were you successful on conducting the examination of those previously mentioned electronic items?
Yes.
You described earlier about I think you said findings DVD, is that correct?
Yes.
What is a findings DVD?
Well, in this particular case, it was a Blu-ray because there was so much information, but a findings is whether it's a DVD or a Blu-ray, the disc that contains all the information that we located that was pertinent to the investigation. We call it bookmarking, and our forensics software creates this report for us with everything that we bookmarked, and it pulls the files that are associated with that into that disc so that we can present it to the case agent and they can use it.
How is that type of report different than, say, back when you were a detective in the non-computer area when you would write a report and put that information? How specifically is that findings Blu-ray in your case, how is that contained?
Well, we still do a written report that you would see like any other investigation and so forth, but this is all digital.
As far as the findings being digital, does that also include some of the images related to the items that you retrieved and looked at in your examination?
Yes.
In this particular case, did you create a findings DVD or Blu-ray, as you said, associated with the examination for those particular items?
Yes.
When you looked at the various items that you described, were there any of them that contained some of the information that was specifically requested by Detective Apple?
Yes.
What were the items that contained some of the information that was requested by Detective Apple?
There was documents, images, web history, and so forth.
Which particular devices contain those types of items?
I believe it was the NZXT tower computer, CyberPower, the iPhone, iPod. mainly.
You talked about a Toshiba laptop.
Yes.
Did you conduct a forensic examination on that Toshiba laptop?
Yes.
Was there any items of evidence that were specifically related to Detective Apple's request or otherwise pertinent to his investigation?
None that we noted, no.
A LaPan tablet, I believe you stated that as well.
Yes.
What is a LaPan tablet?
It's a small tablet computer.
Did you conduct an examination of that tablet?
Yes.
Were there any items of evidence specifically related to Detective Apple's request?
None that we noted, no.
A total of 3 thumb drives, I believe you stated?
Yes.
Did you examine all 3 of those thumb drives?
Yes.
Was there anything pertinent on those thumb drives that were specifically related to Detective Apple's request?
No.
You described a modem, I believe. What exactly is a modem?
Modem is a device where you can hook it up to the internet and be able to access.
Was that modem even examined?
No.
Why not?
No reason to.
Did you also take into your custody some Netgear wireless adapters?
Yes.
What are those?
That's just so mainly you can use them on a laptop or something like that to connect to your modem to access the internet.
Were any of those items examined?
No.
And why not?
No need to.
So you still have before you People's Exhibit 538?
Yes.
That's the iPhone, I believe. Tell us, if you would, please, how did you conduct the examination of the defendant's iPhone?
We take the iPhone and we connect it to our Cellbrite equipment, which is basically an interface device that plugs into there, and it prevents any writing to that cell phone itself, and it copies the information off of that cell phone to our forensics computer and creates a file for us, and then we can process that file looking for contacts, addresses, SMS messages, which stands for short message service, text messages, internet, depending on the type of the phone, internet history, browsing, and so forth.
When you're conducting an examination of an iPhone, is that a full forensic examination?
No, as I mentioned earlier, the problems with cell phones is the minute you turn that device on, it wants to start changing its memory, reorganizing it, make it more efficient, and so forth. So each time you turn it on, it's going to change a little bit. It's not going to change the information that's on there unless a specific, and this is a reality nowadays, a specific command can be sent by a cellular service provider to wipe the information on that cell phone. So one of the other things that we'll do is we'll prevent any communications of that device to the cellular network to protect it.
Did you do that in this case?
Yes, we did.
Did it appear that this cell phone was wiped in any sort of fashion?
It did not.
Okay. Were you able to recover some of the contents of the iPhone using the software you described?
Yes.
Were you able to determine the owner name of that particular iPhone?
Yes.
What was that?
James?
Were you also, in conducting the examination of that iPhone, were you able to discern what the phone number is associated with that iPhone?
Yes.
Do you recall what that is?
Not specifically. I'd see the report.
Would it refresh your memory to look at your report?
Yes.
Okay, if I could just have you flip your report over with the court's permission, and again, let us know when that refreshes your memory.
Yes.
Direct your attention to the first page.
Okay.
And what was the phone number?
858-44-97348.
Okay, have you flip your report back over for us, please. Do you recall what the network service was associated with that iPhone?
I believe it was Verizon.
Were you able to locate any specific email accounts associated with that iPhone?
Yes.
Describe that for us, please.
There was 2 email accounts, and I believe it was dsherlockb@gmail.com and dsherlockb@hotmail.com.
Were you able to look at images or photographs contained within that iPhone?
Yes.
How did you do that?
Once we acquire the image of it and create the file, and then the software processes that, and it categorizes those into different individual areas, like, say, the SMS messages, the text messages, the images. And then you can view those individually.
And did you do that in this case?
Yes, we did.
Were you able to save copies of those images?
Yes.
Are you familiar with the term metadata or metadata?
Yes.
What is that?
Metadata basically is data about data. So it's information that describes that type of file.
Were you able to recover any of the metadata associated with some of the images that you recovered from this iPhone?
Yes.
Were you able to save that as part of your findings Blu-ray?
Yes.
Also, the photographs, were those contained within your findings Blu-ray?
Correct.
Your Honor, may I approach the witness, please?
Yes.
I've handed you what's been previously marked as People's Exhibit 425. Do you recognize that exhibit?
Yes, I do.
What is that?
These are copies of the images that were on the cell phone, along with the associated metadata.
Did you personally recover those images related to your examination of this iPhone?
Yes, myself and Detective Liker.
And are in fact those the images that you recovered?
Yes.
Is there also metadata associated with that exhibit as well?
Yes, there is.
Is that the metadata that you recovered from the cell phone that relates to those particular pictures?
Yes, it is.
Is there also amongst People's Exhibit 425 an image related to a web page?
Yes, there is.
And that was an image as well?
Yes, it is.
Okay. Also an image that you recovered from that iPhone?
Yes.
Did those photographs fairly and accurately depict the images that you recovered from the iPhone that's before you as People's Exhibit 538?
Yes, they do.
Judge, I would move for admission of People's Exhibit 425.
Is there any objection to the admission of P-TR-425?
No objection.
All right, without objection, P-TR-425 is admitted and may be published. Before you publish it, Mr. Edson, why don't we go ahead and take our lunch break? Unless you think you're going to finish within the next couple of minutes.
I'm not going to finish with the examination. I would request to publish at least one photograph.
Okay.
And then if we could please have and to be more clear, Judge, I'd request to publish one photograph and the metadata associated with that.
All right.
425-5, please. What are we looking at here?
Actually, let's take our lunch break, and then I'll talk to counsel for just a minute. All right, folks, this is a good time to take our lunch break. Please keep in mind all of my admonitions related to your conduct when you're not in the courtroom. I'll see you back here in an hour and a half, okay? So at approximately 1:30. Have a good lunch. Please be seated, everyone. The record should reflect that the jury has exited the courtroom. Mr. Ensign, I just want to make sure that you don't run afoul of my order D-108. At pages 22 and 23, I stated that the testimony of Detective Madonna would be limited to describing the examination of the computers and electronic devices collected, including the methods and software employed, and that he would not render any opinions about what information was extracted, what the evidence means, or what the evidence is otherwise associated with. And what I meant by that is he can talk about the categories of information that he extracted from the computer, but my understanding is that the people did not intend to have him opine or testify about the specific contents of the images or whatever data may have been extracted from the computer, and to then testify related to what that information depicts or what that information means or what it's associated with or what significance it had in the investigation. Does that make sense?
It does. And perhaps the court should look at People's Exhibit 425, and I can explain to the court what my intention was and to make sure that it does not run afoul of the order.
Okay, what's your intention?
How this exhibit, and this would be similar to the iPhone, the iPod, as well as the tower computer, is a photograph of the image, like the court just saw. The second page is the metadata associated with that. My question is limited to when that image was created. There's a created date on that, and that's essentially my questions. He's not going to be opining about how this photograph relates to the case, anything related to that. It's strictly, do you recognize this photograph? What date was it created? Photograph, what date it was created? That's my intention.
All right, I think that's within the bounds of the order. I think where you would run afoul of it is if you start talking about what's depicted in on this particular page. Oh, that's a picture of Mr. Holmes. That, I think, would be outside of the boundaries that I have set. So if he's going to say that's an image that was created on such and such a date based on the methods that I have described or the procedures that I have talked about, I think that's fair. But I think where he gets beyond his area of expertise is if he starts talking about what the contents of the images may be or the contents of the data may be and what significance they have in the case or what they are associated with or what they mean to him or what they think, what he thinks, what role he thinks they played in the investigation. Does that make
Understood,
sense?
Judge.
Okay, great. All right, is there anything else we need to talk about at this time?
Anything else, guys? Nothing for the people. Thank you.
Anything on behalf of the defense?
No.
All right, thank you. Enjoy your lunch break. I'll see you back here at about 1:30. The court will
The court will be what? It was cut off. The court will be ... I'm assuming in recess. We are in recess until 1:30 Denver time, day 29 of the Aurora Theater shooting trial. All in anticipation of this afternoon when we expect the former girlfriend of the defendant to take the stand and explore these emails and G-chats she had with him leading up to the months and ahead of the shooting and possibly even back more than a year or two. We heard some objections by the defense as to the majority, all but one of these emails and G-chats being included as evidence. They were okay with this last one, and I think it was in March of 2012, but the judge overruled, saying that all of these were pertinent and relevant, and they had to go back far enough to give perspective to the jury. And I want to ask 7 News legal analyst Dan Recht about that. Dan, when it comes to this evidence, again, we're talking about sanity at the time of the act. So what is the purpose of building this timeline of whatever may have been discussed between the defendant and his girlfriend in 2011 and 2012? What's the point of that?
Well, one might argue with it, but the judge ruled that it gives the jury a bigger picture so that all of these pieces make sense when they look at them together. And the defense objected under Rule 403, which says even if these things are somewhat relevant, if they're attenuated in time, or they might have a propensity to confuse the jury. They should be kept out, but the judge didn't go along with that. So the judge, to summarize again, simply said, we want to give the jury a big picture here so that they can understand the little pieces of the Gmails and the discussion, and hence, he says, I'm going to let it all in.
And Dan, we've heard a lot of the objections to these email just being presented as evidence. Is it necessary to have these email as evidence to have the girlfriend on the stand? And conversely, does the girlfriend need to take the stand to be able to present this email and GChat evidence?
Yeah, I don't think they would get this stuff into evidence but for the girlfriend taking the witness stand and talking about the fact that these are email or text or Gmail exchanges that she had with James Holmes and identifying them as such. So no, in the abstract, without her, I don't think they would become pieces of evidence. With her, they're coming into evidence.
From the defense standpoint, why would you concede one email out of dozens or hundreds? We don't even know how many, based on what we've heard in open court. But why would the defense concede the last one and then object to every other one? That seems to me, from an outside perspective, that there's clearly stuff in the other ones that they don't want the jury to see, but will throw the prosecution a bone and say, well, this one is okay.
Well, I'm not sure, but I think what they had in mind, and the reason they made that decision, is the last one was the one most recent in time, so the one arguably the very most recent and relevant, therefore, to his sanity, because it happened the closest in time to when this happened in the theater.
And from the jury standpoint, dealing with many cases where jurors are instructed of only being able to determine things based on law, and again, based on the law, was this defendant insane or sane at the time of the shooting? And they're presented all this evidence that suggests a mindset ahead of time, planning ahead of time, discussions ahead of time. How does a jury, or how do you try to convince a jury not to take that into consideration when it comes time to deliberate? Again, trying to focus on that one day, that 1 hour, the 20 minutes at the theater itself.
Well, these emails and Gmails cut both ways. They're not necessarily inconsistent with what the defense expert on sanity, Dr. Gurr, is going to say when the defense has its turn to present evidence. She will admit that he went through this process, that there was planning involved, but that he was delusional and getting more and more delusional. So the closer you got in time to the actual shooting, the more delusional and psychotic he was. And hence he was, or she will say, insane at the time he was in the theater. So I think a lot of this comes down to how Dr. Gurr is going to handle these pieces of evidence that have already come into evidence, because she can testify to those things and presumably will.
And one question on the jury hangover from yesterday. They've had a night to sleep on the realization that three are no longer with them. There's probably a temptation to try to find out what happened, but that's what got the three, or one, in trouble in the first place, and then led to the dismissal of three total yesterday. For the jury, it's probably the elephant in the room that there's not even, besides the admonition, there's really no discussion about it, though the judge clearly hinted enough to them by when he read the admonitions again and reminding them to stay away from news reports. I think he hinted enough that they could imply what may have happened. But do you try as an attorney to somehow reference it again, or do you trust that these jurors have moved on? What's your perspective when dealing with an issue like this from the jury?
Yeah, this is a difficult situation, and it happens often in trials, and that is that jurors are instructed not to talk to each other about certain things, but they spend so much time together, and there's an inclination to, in fact, talk to each other. Now, after yesterday, they're going to see, and I agree with you, I mean, it doesn't take a rocket scientist to sort of figure out that these people were excused, the three jurors, because of looking at the media, etc., because that was the judge's admonition moments after he excused the three. So they're going to know that, and they're going to know not to do that, and they're going to be incredibly careful not to talk to each other about what's going on, at least for some period of time, because three of them got the boot as a result of something having to do with the media.
And then one quick question.
But it's awkward, and there's certainly some awkwardness in the jury room for sure.
Well, let me ask that. When it comes to deliberation time, is this fair game to talk about?
Well, not the exclusion of the three jurors. No, that's not fair game. And whatever anyone's read in the newspaper, even though they're not supposed to read anything, or on social media, that's not fair game. It's still, even in the deliberation jury room, whenever that is, months from now, they have to confine their discussion to the evidence presented. And if they don't, they run the risk of one of the jurors, like happened yesterday, telling the judge these other jurors are not acting appropriately and disobeying the court's order.
Dan Recht joining us in the lunch hour of day 29 of the Aurora Theater shooting. Dan, thanks for your time, and we expect to see the former girlfriend of the defendant take the stand this afternoon, which will give us more questions for you at the end of today. It is almost 12:15 Denver time.
I'll be here.
Thanks, Dan. Lunch going until 1:30 in the afternoon. What we want to start with now, and we're engaging with you, and Brian Hernandez is on Scribble right now. Earlier today, we heard from Patricia Lagaretta Roars, who is now the wife of Jamie Roars, who was her boyfriend at the time of the shooting. Patricia talked about her experience in the theater, and you'll remember from last month, Jamie Roars testified about disconnecting with his family during the shooting, losing track of where they were. So we're going to play you the sound from earlier today with Patricia. Someone on Scribble requested if we could play back some of the sound from Jamie's testimony when he took the stand last month. Erica Tinsley found that sound, so we're going to play back-to-back Patricia Roars and then Jamie Roars that you heard from last month, and then we'll get back to yesterday's pivotal moment of three jurors being dismissed and the events that surrounded one juror coming forward with a note describing some jury misconduct, learning things that they should not have known, and the resulting dismissal of three jurors. So that'll take us through the lunch break, and we'll see you on the backside of this.
Before I went home, I stopped and got tickets for all of us and then went home.
Could you please tell the jury who all of us is?
All of us is my boyfriend at the time, who's now my husband, Jamie Roars, my daughter, Azariah Roars, and our son, Ethan Roars.
Now, how old was Ethan Roars at the time?
He was 4 months.
4 months old?
Yes.
And how old was Azariah?
She was 4 years old.
Okay. What time did you arrive at the movie theater that night?
I don't know the exact time, but it was after 11.
What'd you do when you got to the movie theater?
We found seats, and then my daughter needed to use the bathroom, so me and her went to use the bathroom, and then we went back into the theater, sat down, and I remember I hardly ever pay attention, but they were showing, it wasn't previews, but like commercials, and me and my daughter were freaking out and laughing because it was the first time that we'd ever been in a theater that had a back exit. And So me and her were like, oh, how cool, turned around, noticed the exit, and then that was it before.
What brought your attention to the fact that there was a back exit?
Like I said, the fact that I'd never been in a theater that had one. Usually it's just front exit. So me and my daughter thought that was cool that we were, first time being in a theater with back exits.
Was there a commercial that drew your attention to that back exit?
Yeah.
Judge, I'm going to object at this point to cumulative.
Overruled.
You can go ahead and tell the jury.
I, remember the whole cell phone thing and dancing cell phone, and then just the fact that it was like showing know your exits, and talked about the ones at the front, and then when it said the back, I was like, oh, that's different.
Was there anything about the previews for movies that you remember?
I don't remember all of them. I do specifically remember the Superman preview because I remember a male shouting like yay or woohoo, and a cheer of excitement, and everybody kind of like laughing like.
Your Honor, if I may approach the witness with what's been marked as People's Exhibit 1159.
Yes.
Do you recognize that diagram?
Yes.
Does that diagram fairly and accurately represent what you remember happening on July 20th of 2012 in the theater?
Yes.
Your Honor, at this time I'd move for the admission of People's Exhibit 1159.
Is there any objection?
No objection.
Without objection, it is admitted.
Your Honor, at this time, with the court's permission, I would ask Ms. Legaretta Roars to join me at the 3D model to describe for the jury what she remembers happening in the theater that night.
Okay. And members of the jury, this is a good time for me to give you an instruction. It's as follows. This is an instruction with respect to People's Exhibit P-TR-1087, which is the physical model of the inside of Theater 9, a portion of the inside of Theater 8, and the area outside of Theater 9. I'm referring to the model that's there in front of you. A mark on this exhibit was corrected following the testimony of Brett Mills. Mr. Mills testified that the single impact in row 1 at seat 16 identified in earlier testimony by crime scene investigator Maria Perolina was actually a fabric tear and not related to a bullet or bullet fragment. Therefore, the circle drawn by investigator Perolina on seat 16 in row 1 has been removed from the exhibit. Exhibit P-TR-1087 is a demonstrative exhibit and has been allowed by the court only for use in the courtroom to help you visualize certain physical spaces at the Century 16 theaters and to allow witnesses to explain and illustrate their testimony. Therefore, this exhibit is distinguishable from items that have been admitted as substantive evidence, which you may have an opportunity to view during your deliberations. Does everybody understand that? And people are nodding their head yes and saying yes. All right, with that instruction in mind, ma'am, you may step down and bring the handheld microphone if you would, please. Yes, thank you.
If you just turn that on, please, and I'll have you kind of stand right back here with me so the jury can still see everything. All right, if you could please, first of all, show the jury where you were seated that night.
We were seated about row 14, 15, around this area.
All right, so if you could just make your best educated guess and then tell them where exactly, what seat you were in.
She can't guess, she can estimate.
I apologize, Your Honor. If you could just show the jury approximately where you believe that you were seated that night.
This row.
Okay.
And
if you could tell them what seat you were in.
I was in this seat.
Okay. And what seat was your boyfriend at the time, Mr. Roars, in?
He was in this seat, and Azariah was sitting in between us.
Right, and where was your son, Ethan?
Ethan was asleep, and he was in my boyfriend at the time's lap.
Now, what do you recall happening in the movie theater that night?
I remember watching the movie, and at some point seeing the exit door on the right side opening, and seeing something come flying across, and around right here in this area, you heard a pop and then smoke, and I remember thinking like a prank, or sometimes you hear about different midnight premieres, doing different things, and so we continued watching, and then you see the exit door open again, and you could see it because it was so dark, but you could see the light. And I just remember hearing popping sounds, and my boyfriend yelling to get down. And my daughter was asleep, so I remember grabbing her and just throwing her to the ground and laying up on top of her.
Now, could you show for the jury on the diagram where it was that you would have been putting Azariah on the ground and laying on top of her?
Right here.
And then what do you recall while you were on the ground with Azariah?
I just recall trying not to panic and thinking to myself to just thinking this isn't happening. And then I remember looking up and seeing my husband cradling Ethan and jumping over the seats to get safety because he was struggling to find room.
Objection as to speculation.
Sustained.
All right, so you saw him physically jump over seats?
Yes.
Okay, and what did you see him do?
After seeing him come over, I didn't see anything else, like where he went.
Okay, so you lost sight of Ethan
Yes.
and Mr. Gores at that point?
Yes.
So what happened with you and Azariah at that point?
We stayed down, and I just remember poking my head up to kind of see what was going on, to figure out what our next step was going to be. And I remember putting my head up and seeing flashes, and I put my head immediately back down, and as soon as I put it down, I remember feeling a pain in my right leg, and I remember screaming and saying, I think I got shot. And then I remember a voice behind me saying...
Objection as to hearsay.
Is it being offered for the truth?
No, Your Honor.
What's it being offered?
It's offered for the effect on the listener.
Right, the objection's overruled.
Right, you can go ahead and tell the jury.
I remember hearing a voice say that I did too, and I remember feeling just a little bit of comfort knowing that I wasn't alone. And it was at that point where I realized that any movement that I made, if I was visible, it was probably going to be shot in that direction. So I tried to stay low, but I was still in my head trying to think, you know, I need to get out of here. I can't stay in here. And at that point, I heard crying, and I looked up in the aisle and found Ethan. And I remember grabbing him, and that's when I knew that I had to get out. So I just started listening, and I noticed that the shots weren't coming as quickly, and that was when I took my opportunity to get up, and I pulled my daughter up and I dragged her up the stairs, and I remembered there was that exit, and I knew I just had to get out those doors. And I remember going through the doors, and I was literally dragging Azariah behind me and holding Ethan and just trying my hardest to just get up.
So now when you found Ethan, was Ethan by himself?
Yes, he was.
Okay. And when you said earlier you had stood up and you saw some flashes, could you tell the direction of those flashes?
I could see that they were on that side of the theater.
And when you were hearing the gunshots in the theater, could you hear any different types of gunshots?
Yes, I noticed
Judge,
that...
I'm going to object now to foundation.
You can go ahead and tell the jury.
I remember that there were differences, like rapid shots, and then there were some that were a little deeper, but not as rapid.
And when you said that you heard the voice of someone also behind you who had said that he got hit also, where was that? Was that person in the same aisle as you?
Yes, it was in the same aisle.
So when you said behind you...
It was, yeah, we were right here, so somewhere, yeah, in that seat right there.
Now, did you have an opportunity after the shooting to meet that individual?
Yes, I did.
Judge, I'm going to object at this point. It's no longer not being offered for the truth of the matter asserted.
I don't think the question called for hearsay, so the objection's overruled. I don't think it was a question about what was said.
Thank you. Thank you, Your Honor. So did you have an opportunity to meet that individual after the shooting?
Yes, I did.
And do you know who that person is?
Yes, I do.
And what is that person's name?
Jarrell Brooks.
Okay. So how did you go about, just if you could show on the diagram how it was that you went out about getting out of the theater?
I grabbed the kids and ran up this way, and I remember having to go through one door, and it was a little room, and then going out another into like a staircase that went out into the lobby.
All right. And earlier, I think I'd asked you if you had an opportunity to hear different types of gunshots, and what were the differences that you remember hearing?
Some of the shots were more rapid, constant, boom, and then the other set was not as rapid, but like a deeper sounding.
Thank you very much. You can go ahead and take your seat back at the witness stand. Now, what happened when you...
Hold on, Mr. McGuire, before you proceed. The last objection as to hearsay is actually now sustained based on what you said. This went to identification, but there was not enough foundation, so that is hearsay. So the statement by this witness as to who the person was behind her, that is stricken, and the jury will disregard it and treat it as though it never heard it. All right, you may proceed.
After you got through the door, the theater, what did you do next with Azariah and Ethan?
I remember walking around the parking lot, hoping to find Jamie, because at that point I had no idea what happened to him. I left my purse and cell phone in the theater, so thankfully someone let me their phone, and I called him.
And I'm going to object to relevance as to what happened outside of the theater.
What's the relevance?
There's how she goes about getting medical treatment.
Okay, the objection is overruled.
So someone let me their cell phone, and I was able to get a hold of Jamie. We found him right away, and he could see that I was bleeding from my leg. So he, instead of waiting, because at the time it was still chaos, so we jumped in his truck, and he drove me straight to the hospital.
What hospital did you go to?
Is it the Colorado University? I can't remember the exact
University.
name. Yeah, University Hospital.
What injuries had you sustained at the theater?
It was shrapnel.
Your Honor, if I may approach the witness with what's been marked as People's Exhibits 2548 and 2547.
Yes.
Do you recognize those photographs?
Yes.
Could you, do they fairly and accurately represent you at the theater on July 20th, you at the hospital on July 20th of 2012?
Yes.
Okay, and do they fairly and accurately represent the injuries that you sustained?
Yes.
Your Honor, at this time I'd move for the admission of People's Exhibits 2548 and 2547.
Any objection?
No objection.
Without objection, P-TR-2547 and 2548 are admitted and may be published.
Thanks. If I could please have 2548. All right, this picture of you at the hospital that night?
Yes.
Or early morning, rather. And if I could please have 2547. And that's the injuries you sustained to your legs?
Yes.
Did you also sustain some shrapnel injuries to any other part of your body?
Yes.
And could you tell the jury about that, please?
You can take that picture down.
On my right leg as well, all the way up my thigh and up to my hip.
You had shrapnel injuries all
Yeah.
the way up, and they just didn't take pictures of those?
No.
I have no further questions. Thank you, Your Honor. So, after you took your seats that night with your family, what did you do while you were waiting for the movie to start?
We were just hanging out, people watching, and my wife was looking at her phone on Facebook, showing pictures to me of people dressed up like Batman. And I mean, we went to the movie theater all dressed in our Batman shirts too. Even Ethan had his little Batman onesie on. So.
Did you recognize any people coming into the theater in particular?
Really, there's a few that catch my mind. There was one couple that had a baby carrier, and we were like, look, we're not the only one that brought a baby to the theater. And we had actually came to the Spider-Man, which was a...
I'm just going to stop you right there for that.
Okay.
At some point in time, did your movie begin that evening?
It did. It did it around midnight and previews. Yeah, it did.
What happened that evening?
We were just watching the movie, you know, it had just started, and the whole scene with Bane, you know, with the plane crash, and then all of a sudden, this is a few minutes into the movie, I remember them showing a picture of Catwoman because she had just stolen Bruce Wayne's diamonds, and then all of a sudden I hear the exit door open, you know, and I recall a couple things flying through the air, you know, and one, my initial thought was a smoke bomb, you know, and I was thinking to myself, oh, you dumb kids, you know, you just ruined the movie, everyone has to leave. And I heard the door close, so I thought whoever did it just ran off, you know, and then the rate at which the smoke bomb, what I thought at the time, was going was, you know, it wasn't like any smoke bomb I had ever saw, so, and then you immediately start coughing, and then I realized something else was going on, and I heard the exit door open again, and at that time, you know, I heard shots go off. I didn't even get a chance to look who came in the exit door, and I immediately told my wife to get down, you know, and I ducked down with Ethan, and just hearing gunshots and screaming.
What do you recall doing after you had ducked down with Ethan?
So I ducked down with Ethan, and something just didn't feel right. You know, I was ducked down underneath the chair, and I look up, and Ethan's head was exposed. You know, he had got caught in between the two seats in front of us. So I tried pulling him through, and he wasn't coming through the seat. So I jumped over the seat with Ethan into the aisle in front of us.
What happened after you had jumped down to the seats with Ethan?
Yeah, I remember laying down in the aisle over with him and just, you know, hearing gunshots and screaming and thinking to myself, you know, you're processing everything, and, you know, I'm just thinking that whoever's doing this they're coming to kill us, you know. I can't just sit here. So I made a run for it, you know. So we ran down the stairs, and at a point, you know, you realized you weren't going to make it. Just that, you know, people are dropping right in front of you, and at the time you feel like it's a nightmare, you know. You can't really tell if it's reality, you know it's reality, but your brain's trying to process it, and people are falling down dead, and other people are just diving out of the way, and I made it down to about the second and third row, and I like juked in the second row, and, you know, people were just dropping there, and then I like ran back into the stairway, and I was like, I have to run back up, so I ran back up, and at that time I tripped on the stairway and landed on my forearm, and you know, I placed Ethan down there, and I was like, I have to look for a way out, and I remember seeing the balcony right there, and so I ran over to it, and at that time, you know, the shots had probably stopped for, you know, I mean, to me it seemed a lot longer, but probably a second or two, and I looked over and was thinking if I could jump, and if there was anyone there, you know, waiting to shoot me, and, you know, and if I could jump with Ethan, and if he'd make it, and I turned around to look for him, and I couldn't find him, so, and then at that time, shots started going off again, you know, really fast, and I was like, I have to jump or I'm gonna die, so I jumped off over the balcony, and I was thinking to myself, you know, when I was down there, you know, they're still in there, I have to go back and get my family, and, you know, I couldn't go back in there. I knew if I went back in there I was going to get shot or I was going to get killed. So I ran out the movie theater thinking, you know, I should call 911. So I ran out the movie theater through the concession area, and we parked my truck over to the side. So I was trying to call 911, and I could already hear the sirens, coming. And I was thinking, well, what do I do next? So, and I'm like, well, I don't know if they're going to have a shootout with the cops. I don't know, what's going on. So at that time I got in my truck and I drove across the parking lot right to the mall area. And I remember there were some girls and some other kids running, and I told them get in the back of my truck, and they looked at me because like I was crazy, because I mean they heard the gunshots too, and at that time I was just crying out, and I was dialing Patricia's phone over and over again, and all I could think in my head, it was, they're all dead, your family's done.
403, 401.
I'm sorry, I couldn't hear you.
Objection 403, 401.
Sustained. Ask another question, please.
At some point in time, were you able to get in touch with your family?
I was, I got a phone call from a Colorado number, and, I have a 505 area code since I'm from New Mexico. So, I mean, I don't get 303 area codes ever. So I was hoping it was Patricia, and, so I immediately picked up the phone and asked her, I was happy to hear her voice. And at the same time, I didn't know how to tell her that I lost our son in the movie theater, and then she told me that she had Ethan and she had Azariah. So, and I asked if all of them were okay, and she said she had been shot, so I immediately drove right back into the parking lot of the movie theater and began searching for them, and we found each other, and she showed me her shot wound, and I told her to get in the vehicle.
I'm going to stop you right there. At this time, Your Honor, I'd ask the court's permission for Mr. Roars to take the cordless microphone that's up there and to meet me at the model.
Yes.
All right, Mr. Roars, if you could kind of stand right here, and if you could first please describe, and kind of stand here so that otherwise we kind of block. If you can come up close to me, sorry, I know you spent too much time next to me, but okay. So if you could please tell the jury where you were seated, and if you could tell them what seats you were in, and Azariah and Patricia as well.
Okay, so we were seated. I would say there was a couple here. I was probably seated right here in one of these two aisles.
And where was Azariah sitting and where was Patricia sitting in relation to you?
I'll go with this aisle. So I was here, Azariah was here, and Patricia was here closer to the end.
And where was Ethan again?
Ethan was sitting on my lap.
Okay, so Ethan is the 4-month-old.
Yeah, we were...
Ethan is the 4-year-old, correct?
Correct. Yeah, we...
4-month-old, sorry.
Decided that it'd be better for me to hold him since he was knocked out, sleeping, and we didn't want to deal with taking in the carrier.
Now, could you describe for the jury on the model where it was that you saw that door open when the movie had started?
It was over here.
All right, and where was that stink bomb that you saw?
I would say it landed right over here somewhere.
And were you able to see any flashes?
I was.
Where did you see flashes?
All through the front of the theater.
All right, and can you just point that out a little bit better for the jury?
Right over here in this area.
Were you able to see any smoke in the theater?
Yeah.
Where was that?
It was kind of all around my area at least.
So where was the area that you first jumped over the seats with Ethan?
So if it was, this aisle, I jumped over to this aisle and we were laying right here.
And could you show the jury on the model where it was that you went with Ethan at first?
Yeah, so I ran down here, and people were getting shot or falling all around here. And so I ran, I would say, into this aisle right here. And, everyone was falling down and screaming. So I decided to run back up the stairs and then we tripped right over here or so, and I placed Ethan down somewhere in that area.
And was that the last time you saw Ethan inside the theater?
That was.
Okay, and then you described for the jury before like a balcony that you jumped over. Could you talk to the jury about what you described for the jury on the model what you were talking about?
Yeah, it's this area right here.
All right, and is this in fact where you jumped over?
Somewhere around this step and this step.
All right, and then can you show the jury on the model where you landed?
I landed right over here.
All right, and what happened when you landed?
I landed on my ankle, you know, and I immediately looked up to see if there were any other shooters, you know, waiting to shoot me in the stairs, and I didn't see anybody. And I was thinking to myself, you know, you gotta run back in there, and you gotta get your family. And then, you know, the other side of me was saying, you know, you gotta run out of here. You gotta get help. So I ran out of here, and
Was that back into the main area?
back into this main area, and there's a door right here that connects both these sides. You can either come, you know, a main door here, and you can either go left or you can go right.
And then you went back through the main lobby.
I did.
And at any point in time, did you ever see the shooter in the theater?
I did not. I tried to stay low and try to stay out of the way, because, you know, I thought to myself, if I could see him, he could see me, and, you know, then it's done.
All right, thank you. You can take your seat and turn off the microphone. Thank you very much. Were you able to drive your wife to the hospital that evening?
I was.
What hospital did you go to?
I took her to University Hospital.
Were you able to seek medical attention for yourself while you were at University Hospital?
I was initially, you know, I was running off adrenaline, so I didn't really even feel my ankle, and I was more concerned about my wife's wounds than mine. And then, you know, as time went on and we were sitting there in the waiting room, the adrenaline started going down, and I looked at my ankle and it was really swollen. So I asked them to take an x-ray of it.
And were you informed that you had a sprained ankle?
Yeah, they gave me some pain medication for my ankle, and that was it. I mean, there were.
Objection, Your Honor. Oh, thing. Next question, please.
Okay.
Your Honor, at this time I would just ask to clarify for the court that People's Exhibit with the modifications we discussed at the bench will be admitted 1158, but I'm not asking to publish it at this time.
It's been admitted.
Thank you. I have no further questions. Thank you, Your Honor.
Thank you. Any cross-examination, Ms. Spengler?
No.
All right. The jury may have a question for you, sir. Give us a moment, please. Would counsel please approach? Sir, the jury has submitted a question that, based on the rules of evidence and other applicable rules of law, I have found is appropriate. The question is, did Ethan wake up during the shooting?
Oh yes, definitely. When I realized something was wrong, when I initially ducked down,
The record should reflect that juror number 872 is now present in the courtroom. Good afternoon, ma'am.
Hello.
How are you?
I'm good. How are you?
Good. I wanted to bring you in because I wanted to ask you if you have been exposed to information about the case from a media report or any media reports, whether it's through the internet, newspaper, or social media, including Facebook, your Facebook feed.
No, I mean, my last, I think it was Thursday or Friday, my husband called me and he had asked me a question regarding something he's seen on Facebook, something about Twitter or something. And he was on speaker and I told him, look, I don't know anything about it. And that was basically the gist of it. Other than that, I haven't.
What did he say to you about Twitter?
Well, he asked me if I knew who the lawyer was, and I said no. Why? And he was like, "Well, that idiot's tweeting on Facebook," and that was pretty much how it goes on. He knows that I'm not supposed to talk about it, and I don't read the newspaper, and when I watch TV, it's not the news. So I mean, him and I got into a really big argument about it because he knows, and it just so happened to be when we were on lunch.
And have you heard any other information about related to the case, whether through your husband or anyone else, or whether through the internet or any media reports from any source? Have you heard any information about the case?
No. And even if I'm on Facebook or something, if I do see like the headlines of it, I don't click the link. I specifically stay away for that reason.
And have you seen any of the headlines and read any of the headlines?
Not knowingly. You just skim over them. But other than that, I don't like pick them out to find them.
Have you discussed some of this Twitter information that you received from your husband with other jurors?
No. I don't know what her juror number was, but she was sitting right next to me when my husband had called me, and then when I hung up the phone with him, it was just kind of like, oh, what was that about? And I was like, well, I don't know.
What you said? I don't know.
Yeah. I told her, I was like, well, apparently this is what happened on Twitter.
And what did you tell her happened on Twitter?
Just that one of the lawyers had tweeted about. I don't even know what the tweet was about. I just know that he tweeted about the case during a testimony. I didn't read the tweet. I don't know what the tweet was about.
And when was this?
I think it was sometime last week. I don't remember.
And did your husband provide any other information to you about?
No. I basically that was it, and then I got off the phone with him.
Did he say anything else related to the attorney or the party, which side it was, or anything like that he was referring to?
No, he just asked. No, he asked me who George Brockler was, or who Brockler was, and I said, well, he's one of the lawyers, and he was like I said, he said, well, that idiot tweeted during the testimony, and that was it. I didn't ask what he tweeted or anything like that.
During the breaks, do you usually hang out in the patio downstairs, in the lounge area with a few of the jurors?
Occasionally.
Occasionally,
and if I don't, I'm out for lunch.
Okay. All right. And do you remember talking to the other jurors about any of this conversation you had with your husband?
I don't.
All right.
I mean, if this happened yesterday, maybe, but honestly, I don't remember. I don't think I did, because I didn't have a conversation with anybody about it specifically. We didn't sit down, we didn't talk about it in conversation. It was just more of a in passing kind of thing.
Why didn't you bring it up to my attention? I've been telling jurors throughout that even if, despite their best efforts, they inadvertently come upon any information related to the case, whether it's accurate or not, or whether it's directly from the media or not, if they inadvertently come up on or hear or overhear any information about the case, they should tell my staff that they need to talk to me.
Right. There's no excuse for me not telling you. It was more so I just really don't pay attention to my husband most of the time. So it wasn't really that important at that time, I didn't expect, you know, anything out of it. So it was just kind of pushed under the rug and forgot about.
Okay, let me have you step out for just a moment, please. Thank you. The record should reflect that juror number 872 has now stepped out of the courtroom. Are there any other questions that the people want me to ask this juror?
Well, Your Honor, I think that the original juror number 673, it also indicated a statement about a motion for a mistrial. I mean, that's awfully a specific question to ask, though.
Right, that's why I didn't ask it.
So I'm not asking anything about that. I just thought I would mention that that was not discussed with her.
Right. Mr. King, any other questions that you want me to ask?
I agree with Mr. Orman's comment about that. I noted that as well. I also noted that the information from juror 673 is rather specific about the information contained in the Twitter or tweet or whatever it is itself,
right.
Pertaining to the video, and it seemed to match very closely what the actual tweet was. I would ask, if I recollect correctly, juror 872 said that this phone call with her husband was on speaker. So perhaps we should ask if the others were there. It sounds like the others were there and overheard it, and that's why they had a conversation about it. I'm pretty unclear about that, but
I will follow up with juror number 872 about that.
and perhaps we should also ask her if there was a second incident. I suppose you have asked if there are any other incidents. So
I have, and I just didn't want to ask, did you hear anything about a mistrial? That would be improper. So I'll bring her back and ask her about whether there was a second incident, and I'll ask her if, when she had her husband on speaker, if there were other jurors around within distance to hear what was being said. But regardless, I have some concerns about this juror, and if the parties are in agreement, and maybe this will make the additional questions, although I think it makes sense to ask the additional questions, so I will ask them, but if the parties are in agreement, I am inclined to let her go, to excuse her. So is there any objection?
Can I have a moment, Your Honor?
Yes. I mean, clearly, there has been a violation of my advisements. My advisements say you cannot obtain any information about the case, and if you obtain information about the case, even inadvertently, you have to tell me about it. You have to tell my staff that you need to talk to me. Furthermore, between her and juror 673, I find juror 673 to be the more credible juror. And so I don't know that we're getting the full story from this particular juror.
Not object, Your Honor.
All right, Mr. King?
we don't object to her being excused, Judge. We have additional concerns, though. I have concerns, very serious concerns about Juror 412 and the way she responded to the court's questions. So my thought is that we may need to go back and re-question these other jurors again about the information related by Juror 872 to determine whether that's the case. And we may be asking Judge to poll the panel individually about whether anyone has had any contact with this juror or received any information.
Let's take it one step at a time. Let's not get ahead of ourselves.
Good, understood.
I have some concerns about Juror 412 as well, Mr. King. So she took her time answering questions. She paused. She used words that suggested at times that she was holding something back or might be holding something back, such as saying, not that I heard and processed. I don't know who answers questions that way when they are asked, did you hear something about this? Usually people tell you, no, I haven't heard anything. I didn't have concerns with juror number 495. I thought juror 495 was being forthcoming, and it may well be that she just didn't hear a whole lot, other than she overheard juror number 872 say something along the lines of maybe looking something on a phone, and she thought it was a joke and therefore didn't report it to the court. But I do have some concerns about juror number 412 as well in terms of her demeanor and how credible she was with me, or perhaps the better word is how forthcoming she was with me. So if the parties are asking me to release 412, I would grant that request.
Judge, may we have a moment, and while we're thinking about that, we have some concerns about 495 as well. There were some long periods of silence when the court was asking its questions, and her statements are in direct contradiction of Juror 673. And so that, it sounded better when she said it, but it's contradicted by the very credible statements of Juror 673. So who specifically identified her. So our request is that you dismiss all three of them at this point in time, Judge. And we have 12 alternate jurors in this case, and that's why we have 12 alternate jurors. And we're well into the case. We're more than halfway through the case. And any kind of discrepancy should be resolved in favor of making sure that this is an impartial juror. And there's no harm in excusing these jurors. Essentially, we believe all four jurors should be excused, Judge. We believe that 673 has been tainted by what she's heard about the case. And I'm willing to deal with that argument too when it comes, but I don't want to jump ahead of myself here. I'm sorry.
I think we're jumping around a little bit. So let's deal one by one. First, there has been no objection already with respect to 872, and so I will release 872. The next question is 412. The defense is asking me to release number 412. And is there any objection to me releasing 412? Yes.
We don't object, Your Honor.
Okay, 412 will be released. I agree with Mr. King. I had some concerns about her credibility when she was in here talking to me. 495, Mr. King is right that her statement is inconsistent with what 673 said. However, it's possible that she just didn't hear it. It's possible that this is not an inconsistency. It's possible that 673 thought that 495 would have heard this comment, but that 495, in fact, did not hear the comment. And so unless there's an agreement to release her as well, I'm inclined to follow up with her, or actually follow up with perhaps 673 and see whether 673 thinks if that 495 was in a position where she would have been able to hear this conversation. I mean, this is not, one word we're talking about. These are a couple of comments, 2 or 3 comments that we're talking about. And so I think 673 may be able to shed further light as to whether she thinks 495 would have been close enough to have been able to hear this. Mr. Orman?
Your Honor, I don't object to that. The only thing I think that should be noted is very often people are around things that are said and don't pay attention or don't remember. And it's possible that 495 was there whenever this conversation occurred, but it just didn't listen to it. And so I agree that there were some pauses with 495, but I think they were very different than the pauses with 412. It seemed to me the pauses with 495 where she was really thinking about trying to give an accurate answer to the court. That's the way it looked to me.
So, yeah, that's how it looked to me as well. But I will follow up with 673 before I make a determination with respect to 495, unless you have an objection to that.
No, Judge, I do not. And I don't disagree with Mr. Orman that it's possible that she just didn't hear.
Right.
It's also possible that she did hear, and she doesn't want to tell us to get one of her fellow jurors in trouble. And my position is we should err on the side of caution.
Okay, I got you. I will bring 673 back. In light of the decision to release 872 and 412, do you have any problem with me not following up with 872 as to whether there was a second incident and as to whether she thinks anyone was around within a short distance when she had her husband on her speakerphone? Or do you still want me to follow up with
I think we need to follow up on that, Judge.
All right, I will follow up on those 2 questions. Let's bring 872 back, please. All right, the record should reflect that number A72 is now back in the courtroom. Thank you for your patience. A couple of follow-up questions. Was there a second incident where you discussed something related to the case, or someone discussed it with you?
No. The only one that I can think of is the Twitter.
And you said you had your husband on the speakerphone. Do you know whether there were other jurors within a close distance or a short distance who would have been in position to hear what was being said?
Well, there's usually 4 of us that all eat lunch in the same area, and I don't know of the other 2 that heard, but I'm sure the one sitting right next to me heard it.
And who was sitting next to you?
I don't know her juror number.
Where does she sit?
Right here.
Okay, so that would have been juror number 412.
Yeah.
You think she would have heard it?
Yeah, I don't know. I mean, if she heard it, she didn't say anything to me about it.
But she was sitting right next to you.
Yes.
Who are the other people who usually eat lunch with you? Who would have been there during that time when you had your husband on the speakerphone?
I don't know. But I know she sits up in the back corner, and then the other one, I don't know where she sits.
And the woman who sits in the back corner, it's the top row all the way at the end?
Yes.
And how close would she have been, was she to you?
Well, she was on the other side. I was sitting on the far end of the patio in the shade, and she was over walking in the sun.
Can you estimate for me how many steps she would have been away from you?
Maybe about 25 feet.
25
She was pretty far.
25 feet?
Yeah.
So she was pretty far.
Yeah.
And so, but juror number, the other juror, juror number 412, was sitting right next to you.
Yeah.
So, okay. All right. All right. Give me just a second. I'm going to ask you to step out one more time.
Okay.
Thank you. Thanks for your patience. All right. The record should reflect that A72 has now stepped out of the courtroom. That confirms it for me that 412 was not being completely honest with us, or perhaps without the completely. And I think that's what all of us thought, the parties and I, the attorneys and I, all thought that, and that corroborates what I had concluded. So at this time, I'm going to bring A72 back, and I'm going to excuse her. Then I'm going to bring 412 back, and I'm going to excuse her. Neither one of them is going to be allowed to enter any of the jury rooms while the other jurors are in there. They're going to be taken downstairs, and then when the jurors are not around, they'll be escorted so that they can get their possessions, and they will be escorted out of the building. Okay. Okay. The record should reflect that juror number A72 is back in the courtroom. Ma'am, I'm going to go ahead and excuse you at this time. So you are discharged from jury service in this case. I want to advise you that you are prohibited from talking to any of the other jurors in the case. I know that you may have made acquaintanceships or friendships with some of the other jurors. You cannot talk to them while they remain on the jury. Do you understand that?
Yes.
And you also cannot talk to the members of the media. I'm prohibiting you from talking to the members of the media until the trial is completed.
Okay.
Do you understand?
Yes.
Okay. All right. Thank you. The record should reflect that juror number 412 is back in the courtroom at this time. Ma'am, I'm going to go ahead and excuse you at this time. You're excused and discharged from jury duty in this case. You are not allowed to talk to any of the other jurors as long as the trial is pending, as long as the trial is continuing. You also are prohibited from talking to any members of the media until the trial is completed. And when I say trial, I mean the entire thing, including any proceedings that may be had in this case. Do you understand?
I do.
All right, thank you. You're discharged. All right, next I propose bringing in juror number 673 and following up with her. Is that okay with everyone?
Yes, Your Honor.
All right, let's bring 673 back, please. record should reflect that juror number 673 is back in the courtroom. Ma'am, I want to thank you again for doing the right thing. You did the right thing, and I very much appreciate you doing this. I brought you back in because I want to follow up on the discussion we had earlier. You indicated that at the time that you heard these statements by the juror who sits in seat number 9, juror number 872, that there were a couple of people present, a few people present, and one of the people that you identified is the person who sits in the top row all the way at the end, which is seat number 8. That's juror number 495. And my question is, do you remember how close she was in terms of distance to the person making the statements? In other words, I'm trying to figure out what is it that made you believe that she may have heard these statements?
Honestly, it's because it's usually the four of us talking. And so, I mean, maybe she was farther away from the group that was talking. But usually we're close enough to where it's easy to hear.
So usually you're close enough to each other that you'd be able to hear.
Yes.
Okay.
I mean, if she didn't hear it, she didn't hear it. I know that all four of us were standing around.
And juror number 872, the juror who sits in seat number 9, didn't make the statement just to you.
No.
She just made the statement.
Yes.
Did you see her at any point speaking on her phone, on speakerphone with anyone?
No.
No, you didn't see that part?
No.
And you didn't hear her talking to her husband on speakerphone about anything?
No.
But you remember her making the statements that you said she made both last week and also yesterday?
Yes.
And do you think in both incidents, the person who sits in seat number 8, juror number 495, was in the area, the vicinity?
Yes. I know yesterday for sure.
For sure yesterday she was in the vicinity?
Yes.
Okay.
And then I'm pretty sure, almost positive, that the other time as well.
Okay. What about the person who sits in the 4th seat from the end in the top row? I understand that sometimes she goes on break with you folks in the patio, juror number 535. Do you know whether she was there?
I don't. That's why I didn't mention her.
Okay. Do you recall her not being there or her being there, or do you just not remember?
I don't remember.
You don't remember. Okay. All right. Thank you, ma'am. Let me have you step out again. Thank you very much. Okay, the record should reflect that juror number 673 has now stepped out of the courtroom again. Given that record, I'm inclined to grant the defense's request to release number 495. I think 673, juror number 673, is the most honest of all these jurors that I've spoken to today. And I believe what she says. I think she's being very candid with the court. I think this was a hard thing for her. She's not looking like she's getting any pleasure out of this at all. This is actually seemingly painful for her, but I think she's doing it because she felt it was the right thing to do, and I appreciate her doing that. But I find her to be the most honest of all the jurors. And if she's telling me that juror number 495 was in the vicinity, then I believe her. And again, you know, this isn't a one word type of thing. There are multiple comments, and I think it's likely that juror number 495 would have heard some, if not all, of these comments. So I'm inclined to grant the request. Is there any objection?
I don't object, Your Honor.
All right, I will release number 495. So before we take 673 back to the jury room, she's waiting in the hallway, right? Yes. Mr. King, I think you had said that you wanted, you might have a request to excuse her, or perhaps you actually made the request to excuse 673. Do you want to make that request still?
Yeah. Yes, please.
Okay.
And I could not agree with the court more. I think that she's doing the right thing. I think that she's being very honest. I'm just very concerned about the nature of the information that she's been revealed to. She now knows about a mistrial. A request for a mistrial that was denied. That's likely could have a prejudicial effect. She knows about the tweeting thing and Lord knows what else. So I just think I'm requesting that we dismiss her as well.
Well, what she has heard, number one, she didn't hear from the media directly or from any news source directly. She heard it from another juror who claimed that she got it from her Facebook feed. So for one thing, she doesn't know if this is accurate or not, and she said that when she was in here. Number two, she heard that they have tried to call a mistrial, but she said she didn't know which side, and that the attorneys have now been prohibited from using or from having phones in the courtroom, and that one of the attorneys posted on Twitter that he or she hoped the jury saw part of the video, and the judge was mad, but she didn't know which attorney it was, and she didn't know if it was a female or male attorney, and she didn't know if it was a prosecutor or a defense attorney. And she didn't know what came of the, if anything, of the attempt by anyone to call a mistrial. So I read the People versus Moore case, 321 Pacific 3rd, 310, a Colorado Court of Appeals case from 2010, and that case is not on point, but that's a case in which it was revealed to the court that there had been that the jury had been exposed to a newspaper article containing prejudicial information about the defendant, and the court set forth the analysis that trial court judges should engage in if this situation arises. And what the Court of Appeals said is that a trial court should deal with juror exposure to prejudicial publicity during the trial as follows. Number one, the trial court must determine whether the publicity is inherently prejudicial. Number two, if so, the court should canvass the jury to determine whether the jury learned of the prejudicial publicity. And number three, the trial court should individually examine exposed jurors to determine how much they know of the publicity and what effect, if any, the publicity will have on their deliberations. Now, I have questioned multiple jurors now, including juror number 673. This information that juror 673 heard, in my view, is not inherently prejudicial information to the defendant. She doesn't know who it was related to. She only knows vague or general details. And Mr. King said, who knows what else she has heard? You know, we can't have it both ways. We can't on the one hand say, boy, she's really honest and really candid with the court, and on the other hand say, who knows what else she heard that she's not telling us? I think we either trust her and rely on her or we don't. And I find her very reliable and trustworthy. I think she's being very candid with the court. And so when she tells me, this is what I've heard, I believe her completely. And so if this is all she's heard, I don't see how this is inherently prejudicial to the defendant. And then I have examined her individually, and I will examine her further, but I have examined her about what effect, if any, the publicity will have on her deliberations, or actually I asked on her ability to be fair and impartial, and she said none. I can still be fair and impartial. I will still be fair and impartial. I will bring her back and ask her about what effect, if any, this information may have on her deliberations, or what effect, if any, it will have on any decision she makes in this trial, and whether this information will at any point influence her in any way or affect her decision-making or be in the back of her mind at any point during the trial. All right, the record should reflect that juror number 495 has now stepped out of the courtroom. Are there any other questions that the prosecution would request that I ask of this juror?
I think you covered it, Your Honor.
All right, any other questions, Mr. King?
Judge, my colleagues may have a suggestion, but my one suggestion is, my recollection is that juror 673 indicated that this conversation, at least the conversation that took place yesterday, took place on the patio.
Okay.
And so I didn't know, I know that you referred to the lounge area. I'm unfamiliar with any of these areas, but maybe it would jog her memory if you were to mention the patio area. And
I will do that. I thought that she had referred to the lounge, but I'll ask the patio. That's what I was referring to, and it sounds like that's where the group of folks tends to hang out during the breaks. The only one she added that juror number 673 had not mentioned is possibly juror 535, who sits in seat number 5. So, but I'm happy to bring her back and make sure that she understood that as the patio.
my understanding or my thought was that perhaps they were taking a smoke break out there.
That's possible, yeah.
The other question that I'm being asked is whether or not this juror has heard anything about media reports on the case from any source.
I will ask that. All right, let's bring her back, please. Although I think the last question is covered by some of my other questions, but I'll ask it anyway. The record should reflect that juror number 495 is back in the courtroom. Thank you for your patience. I want to follow up on some of the discussion we had, because I want to make sure that we're talking about the same thing. When I refer to the lounge area, did you understand that as the patio as well downstairs outside?
Yes.
Okay. Where sometimes, do jurors smoke there sometimes?
Yes.
Yes. Okay. And so that's what you were referring to?
Right.
All right. And that's the place that you were referring to when you were talking about those few of you who during the breaks go there to smoke and hang out?
Right.
Okay. And the other follow-up question I had is, have you heard any media reports about the case since the trial started?
I have not, no.
Okay. Have you heard anything reported about the case in the media through any means, whether it's TV, radio, newspaper, magazines, internet, social media, through any means? Have you heard or seen any reports about the case from the media?
Not, I mean, if I see something, then I just turn the page or scroll past it really quick. I have not read anything or heard anything.
Okay, so you've been following all of my advisements?
Yes.
And have you complied with each and every single one of my advisements since we started this trial?
Yes.
Okay. All right, thank you. Let me have you step out again.
Okay.
Thank you for your patience. All right, I'm going to bring in the next juror, who is juror number 412, unless there are any other questions that the parties want me to ask of juror number 495. Any other questions?
The only other question, Judge, and I apologize for not thinking of this earlier, is to ask her why she did not inform the court of this previously. My understanding is that you've instructed this jury very, very clearly over and over again that if there's any violation in any way of the court's orders by themselves or by other jurors from any source, that they're to notify the court. And that's potentially a violation of the court order that could affect this juror's future service.
Well, what she said was that there was mention of maybe looking something on a phone. And then she said that she thought that the person was joking. So it didn't sound like what she heard was that someone actually looked something up on the phone, but that she said she could to try to find out what was going on because this was a long break. And then she said that she thought he was joking. I will bring her back and clarify that just to be sure, okay? Let's bring her back, please. All right, the record should reflect that juror number 495 is now back in the courtroom. Let me follow up on this statement that you think you heard.
Okay.
What I heard you say is that you heard during one of the breaks that there was mention of maybe looking something on a phone.
Right.
And when do you think that happened? doesn't have to be the exact day. If you can remember this week or last week or before last week or something along those lines.
It wasn't this week.
So not yesterday or today.
No.
Okay.
Early last week?
You think maybe early last week?
Yeah.
And what exactly is it that you heard this person say?
Just, there was, like I said, there was a long break or something. And so we were excited, an extra break or something, so we were excited to go outside, and was just mentioned, well, let me get out my phone and check the news.
And did you actually see her check?
I did not see her check the news.
Did you believe that she had violated one of the court's orders?
I took it as her jokingly saying it.
And you didn't actually see her?
And I did not actually see her at that time do it.
After she said that, did she start using her phone, or do you know whether she started using her phone for any purpose?
I don't specifically remember. I mean, all of us take our phones out there, and we're on them pretty much constantly while we're out there. So, she could have even said it while being on her phone. But I didn't put any, I took it as her saying it jokingly.
Okay, you didn't believe that she was in violation of one of my advisements that I have been giving you.
Correct.
Okay. All right. Do you remember anything else about that event?
No, I mean, it was just a fleeting passing comment, and then we all just carried on with what we were doing.
And do you know who else was present when she made that comment?
It would have been the people that I mentioned before, with the exception of maybe the person in the very back row. She doesn't tend to stay out as long as we do.
Okay, the person that you said 4 seats in from the right hand, looking at the jury box.
Right.
It would be my right hand side, 4 seats in. That would be the person sitting in seat number 5, juror number 535. Okay.
Right. That would be the only person that, like I said, we go out there and she doesn't tend to stay out there as long.
So you think she wasn't there?
I can't say for sure, but
you don't know.
She may have been, right.
Okay, you don't know if she was or not.
Right.
Okay. All right, great. Let me have you step out again, please. Thank you. Thanks for your patience. Okay, the records reflect that juror number 495 has now exited the courtroom. The records reflect that juror number 412 is now present in the courtroom. Good afternoon.
Hello.
I brought you in because I wanted to ask you whether you've heard any juror make a statement of any kind about the case during one of the breaks, and specifically last week and yesterday, and in terms of location, specifically in the patio downstairs or in the lounge area.
Not that I'm aware of.
Okay. You don't recall hearing anything?
No. Sometimes we talk about like quotes and clothes and shoes, but I don't remember hearing anything about the case.
Okay, clothes and shoes. The clothes you may be wearing and shoes you may be wearing?
Yeah.
Okay, when you say quotes, what does that mean?
Like air quotes.
Oh, okay. Air quotes, but not related to this case?
No.
And not related to anything happening in these proceedings?
No.
All right. And let's expand it to before last week. Have you heard at any time any juror make a statement anywhere, whether in the patio or anywhere else, about this case?
I've heard people talk about the length, going over 5 o'clock, past 5, 5:30, 6.
Okay, so scheduling, and my staff talks to you folks about that often in terms of how late you can stay and that kind of thing as well.
Right.
But what about anything else in terms of the case or in terms of what might be reported in the media or in any media reports? Have you heard anyone comment about what, information related to the case or information reported by the media related to the case? Have you heard anyone make a comment about that? And when I say anyone, I'm referring to one of the jurors.
No.
No? And my understanding is sometimes during the breaks you go to the patio with a few other jurors. Is that right?
I do.
Have you heard any such comments while you were there at the patio made by any juror statements related to the case or what may have been reported about the case in the media or anything like that?
Specifically talking about the media?
Anything related to the case?
No, just talking about schedules and stuff.
Okay.
I tend to play my phone.
Okay, that's okay.
So
that's all right. All right.
No.
Have you received any information or seen or heard or read any information about the case in any media report since the case started?
I look at Huffington Post, but I scroll past anything that has to do with anything
related to the case?
Yes.
And so you're following my advisement to avoid any stories about the case?
Yes, I don't look at the news. I don't watch the news with my family. We don't even watch it anymore. I watch Rachel Maddow.
Okay. And you've been following my advisements, each and every one of my advisements, since we started this trial?
Yes.
Okay. All right. And I want to make sure that I open it up because initially I asked you questions about during one of the breaks in the patio downstairs, and I said last week or maybe yesterday, but let's open it up without any restrictions as to location and without any restrictions as to time. Have you ever heard a juror make a statement or make a comment about the case or about information from the media related to the case?
I can't think of any that I've heard and processed, I guess. I can't think of any that I've paid any attention to, anything about the media.
All right. Even if you weren't paying attention and processing it, have you heard any juror make any statements about the case or information in the media about the case? Whether you happen to be part of the conversation or whether you happen to not be specifically talking to the juror but happen to overhear what the juror said. Have you heard a juror make any statements in any way related to the case, including information in the media about the case?
I'm trying to recollect anything I may have heard, and I just, specifically the media, nothing.
Or even if it's not specifically related to the media, related to anything in any way related to the case, that's not scheduling. Anything related to the proceedings or what's happening here in the courtroom, related to the case in that way. Have you heard anyone make a statement like that that comes to mind?
No, just like I said, the scheduling, sometimes shoes that people wear, clothes, outfits,
Okay.
hairstyles.
All right. Got it. All right. Thank you. Let me have you step out for just a moment, please. All right, the records reflect that juror number 412 has now stepped out of the courtroom. Are there any other questions that the people would like me to ask this juror, Mr. Orman?
No, Your Honor, thank you.
Any other questions from you, Mr. King?
No, thank you.
All right. Thank you. Let's bring her back one more time, please. The record should reflect that juror number 412 is back in the courtroom. Ma'am, thank you for your time. Please don't discuss with anyone what we've talked about here, okay?
Yes.
Will you promise me to do that? That you will?
Absolutely.
Okay, thank you. So don't discuss anything I asked you. Don't discuss anything you said. Don't discuss any of this conversation that I've had with you one-on-one, okay?
Yes.
All right, and will you promise that you will continue to follow each and every one of my advisements throughout the trial?
Yes.
And I should also tell you, don't infer anything from this discussion, okay? Don't try to speculate. I wonder why he's asking me the question. You shouldn't do that at all. Will you promise me that you will not do that?
Yes.
All right, great. Thank you very much.
You're welcome.
Good afternoon, everyone. This is the case of the people of the state of Colorado versus James Eagan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. We are outside the presence of the jury. Juror number 901 has indicated that she needs to speak with me about something. So we're going to bring her in first, okay? Let's bring her in, please. Good afternoon.
Hi.
The record should reflect that juror number 901 is now present in the courtroom. My staff indicated to me that you wanted to speak to me in private.
Yes.
What's on your mind?
Well, we had a little bit of a family emergency this morning, and it's all over the news, and so I figured I better tell you. It also would require me going to Denver Health, and I know you said to speak to you if we had to be anywhere that had to deal with this case, so I had a family member who was in an accident this morning at 3 a.m. and he's okay, sort of. He's alive. But I want to see him, and he's at Denver Health, so I'm asking permission to go see him.
I appreciate you bringing this up to my attention. The request is granted.
Thank
So
you.
you can go and see him. Just be careful when you're there not to try to do any investigation or acquire any information in relation to your juror service on this case.
Okay.
In other words, treat it just as you would if you were not on the jury,
Okay.
and don't go out of your way to make any observations or try to acquire any information in relation to this case.
Okay, I won't.
Okay.
I'm there for one reason.
All right. Let me have you step up for just a moment, okay?
Thank you.
The records should reflect that juror number 901 has stepped out of the courtroom. Is there anything else that the people are asking me to inquire about, or any action that people are asking me to take?
No, Your Honor.
Anything from the defense in terms of any additional inquiries or any request in terms of actions that you want me to take?
No, Judge.
Okay, great. Thanks. Let's just have her go back then. And then let's bring the jury in if the parties are ready. Are we ready for the jury?
Sorry.
Great. Let's bring the jury in, please. Please be seated, everyone. The record should reflect that the jury is back in the courtroom. Welcome back, folks. I hope you had a good lunch. Good. At the end of the morning session, Detective Madonna was on the witness stand, and Mr. Edson was in the middle of his direct examination. And so, Detective, I remind you that you're still under oath. Mr. Edson, you may resume your direct examination.
Thank you. Detective, do you still have People's Exhibit 425 in front of you?
Yes.
We could please publish photograph 5. What is the, within People's Exhibit 525, is there metadata associated with this photograph?
Yes.
What is the created time for this photograph?
The created time is 7/5 of 2012, so July 5th, 2012, 8:32:15 a.m.
And again, this was a photo from the iPhone, is that correct?
Yes.
If I could have number 7, please. What is the metadata created, or capture time, I should say, for this photograph?
The capture time is July the 5th, 2012 at 4:12:36 p.m.
If we could please have number 15, please. What is the capture time associated with this photograph?
Capture time is July the 11th, 2012 at 12:28:24 a.m.
Number 17, please. What is the capture time for this image?
July the 16th, 2012, 8:26:02 p.m.
So, within a few minutes, barely depict the same time on the microwave in that photograph?
Yes.
Number 19, please. What is the capture time for this image?
July the 16th, 2012, 8:27:03 p.m.
'25, please. What is the capture time of this image?
July the 19th, 2012, 5:17:40 p.m.
When you're saying the time being 5:17 p.m., is that local time, non-local time? How does that work with an iPhone?
I believe those are UTC.
What is UTC?
Coordinated Universal Time, and don't ask me why they did it that way, because when you spell it out, it's not the same, but it's Coordinated Universal Time, which is the same thing as Zulu Time, Greenwich Mean Time.
How does that correspond to Mountain Time or local here in Denver?
In July, you'd subtract 6 hours.
27, please. What is the capture time of this image?
Capture time is July the 19th, 2012, 6:22:20 p.m.
Number 31, please. What is the capture time for this image?
July the 19th, 2012, 6:31:13 p.m.
33, please. What is the capture time for this image?
July the 19th, 2012, 6:37:27 p.m.
35, please. Capture time of this image?
July the 19th, 2012, at 6:40:39 p.m.
Okay, you can take that down, thank you. Were you able to look at outgoing phone calls from the defendant's iPhone?
Yes.
Were you able to look at the last outgoing phone call made from that iPhone?
Yes.
Were you able to capture, based upon your examination, the date and time of that last phone call?
Yes.
What was that?
I'd have to refer to the report.
Would that refresh your memory?
Yes.
Do you still have your report in front of you?
Yes.
Okay. So I'll direct your attention to the iPhone report, page 8.
Yes.
When was the date and time of the last phone call?
That was July 20th, 2012, at 6:30:50 UTC.
How does that correlate to Denver time?
That would be roughly 12:30
in the morning?
In the afternoon? In the morning, yes.
What was that number 2? The dialed 2 number?
720-848-0000.
Were you also able to capture the duration time of that call?
It was for 18 seconds.
Were you able to also look at the various contacts in the phone?
Yes.
Was there a contact within the defendant's iPhone for a Robert Feinstein?
Yes.
Was that an email, phone? What was that? Do you recall?
I'd have to refer to it.
Would that refresh your memory to look at your report?
Yes.
Direct your attention, with the court's permission, to refresh your memory with your iPhone report.
That's fine, but when you're refreshing your memory, what that refers to is you can look at the report, put it down, then let him know if that refreshed your memory or not. If it did, then you can answer the question. You're not supposed to read from the report.
Okay.
Does that make sense?
So, sir, I'll direct your attention to page 13 of your iPhone report.
Yes, it does.
Okay, so my question, I don't need you to read it aloud, but was there a contact information for a Robert Feinstein in the defendant's iPhone?
Yes.
What kind of contact info?
Referring back to the report, it would have been email address.
Was there a contact information in the defendant's iPhone for a Lynn Fenton?
Yes.
What kind of contact information?
I believe that was a email address.
Was there a phone number as well?
There was, yes.
Were you able to also look at some text messages within the defendant's iPhone?
Yes.
Were there some text messages contained in the defendant's iPhone from a contact that goes by the name of Hillary?
Yes.
Do you recall the approximate date of some of those text messages?
I believe there was a couple dates in there in April of 2012.
When you capture a text message exchange, do you capture both the outgoing and incoming messages?
Yes.
And did that occur in this case?
Yes.
Were you able to recover any browser web history from the defendant's iPhone?
Yes.
Was there any browser web history on the defendant's iPhone that was within the parameters of the initial requests from Detective Apple related to this case?
Yes, I believe so.
What was some of the browser history, if you recall?
Just right off the top of my head, law enforcement targets, the bomb, things like that.
Okay. Was there any browser history about chemicals such as napalm, gunpowder, things like that?
Yes.
Was there any sort of web browser history on the defendant's iPhone related to weapons, such as guns?
Yes.
What about weaponry such as ammunition?
Yes, I believe so.
Was there any browser history on the defendant's iPhone related to the New York Times?
I don't recall. I'd have to look at my report.
Would it refresh your memory to do so?
Yes.
With the court's permission, I would direct your attention to page 70 of the iPhone report.
70?
70, yes. And again, as the court stated, just refresh your memory and flip it back over when you're done, please. Direct your attention to lines 78 and 79.
Yes, there was.
Okay, what was it?
Something about sending an article to the New York Times.
Do you happen to recall, and again, if you need to refresh your memory, tell me, but do you recall the date of that web search?
I'd have to refer to the report. That would be July the 7th, 2012.
Your Honor, may I approach to retrieve an item of evidence, please?
Yes.
Thank you. I've handed you what's been previously introduced as People's Exhibit 708. Do you recognize that exhibit?
Yes, I do.
What is that?
This is an iPod.
Did you conduct an examination, a forensic examination of an iPod related to this case?
Yes, myself and Detective Liker did, yes.
Is that the iPod that you conducted the examination upon?
Yes, it is.
Did you capture any images that were within the parameters of Detective Apple's request from that iPod?
Yes.
And just so we're clear, can iPods such as People's Exhibit 708, do they have cameras? Can they take photographs?
Yes, they can.
The images that were contained in the iPod, did you place that as part of your report in this case?
Yes.
Your Honor, may I approach the witness, please?
You may.
I've handed you what's been previously marked as People's Exhibit 426. Do you recognize those?
Yes, I do.
What is that?
These are images of materials.
Well, let me backtrack. What are, in general, what are those items? Actually, that's a bad question. Do you recognize People's Exhibit 426?
Yes, I do.
What is it?
They're images that were taken off of the iPhone, or not iPhone, iPod.
Do those images appear to be the same images that you collected as part of your forensic examination in this case?
Yes.
Is there also metadata associated with each of those images in People's Exhibit 426?
Yes, there is.
That metadata, did you also collect that as part of your examination of the iPod?
Yes.
Move for admission of People's Exhibit 426.
Any objection?
No objection.
Without objection, P-TR-426 is admitted and may be published.
Could I have image 1, please? Sir, what is the capture time associated with this image from the iPod?
The capture time is July the 14th, 2012 at 9:02:28 p.m.
Image 3, please. What is the capture time associated with this image?
July the 14th, 2012 at 9:02:40 p.m.
Image 5, please. What is the capture time for this image, please?
July the 14th, 2012 at 9:03:11 p.m.
Image 7. What is the capture time of this image?
July the 14th, 2012 at 9:03:31 p.m.
Thank you. Let me take that down. Were you able to successfully complete a digital forensic examination of the NZ XTE CyberPower PC?
Yes.
Also referred to as a tower computer?
Yes.
Do you know what an IP address is?
Yes, I do.
What is an IP address?
IP is abbreviation for Internet Protocol Address.
What does that refer to?
Internet Protocol Address is so that computers can talk to each other, to servers and so forth on the Internet. So think of it as basically a post office address so that your computer can talk to a server or any other computer out there as long as it knows where the IP address or what the IP address is.
Were you able to establish information related to an IP address for the eCyberPower PC tower that was taken from the defendant's apartment?
Yes.
What is that IP address?
I would have to look at the report to...
Would that refresh your memory?
Yes, it would.
I'd refer you to page 3 of your report with the court's permission.
Go ahead.
Yeah, I'm going to have to read from this because I can't remember.
I can understand. Go ahead.
The IP address is 67.166.38.7.
Thank you, sir. Were you able to retrieve information from that eCyberPower PC related to the operating software?
Yes.
What was the operating software for that computer?
Windows 7 operating system.
Were you able to establish when that operating software was installed?
Where it was installed?
When?
Or when, yes. April 26th, 2012.
Would that be the first time someone would use that particular software on the computer?
Yes.
I'm going to jump around just a bit, but did you conduct a forensic examination of the Lenovo tower as well?
Yes.
Do you recall, did you receive information as to when the last time that tower was used as far as being logged into?
Yes, I did.
When was that?
I'd have to refer to the report.
Would that refresh your memory?
Yes, it would.
Okay. With the court's permission.
Yes.
Refer you to page 6 of your report.
April 25th, 2012.
Okay, and now moving back to the eCyberPower PC.
Yes.
Were you able to establish information as to when the last time the cyberpower PC was logged into?
Yes.
Do you happen to recall that?
Just to make sure, I'd have to refer back to the report.
Okay. Again, with the court's permission.
Yes.
The last shutdown time on the tower computer was July 19th,
Of what year?
2012. Sorry.
Were you able to access or otherwise look at the system's operating clock within the tower PC?
Yes.
Did that appear to be accurate as far as date and time?
Yes, it was.
When you examined the eCyberpower PC, and again, is that the computer that I showed you the photographs of earlier?
Yes.
That tower PC, was there any information related to that tower PC being synced to any sort of products?
Yes.
Describe for the jury, please.
It had been synced to a James's iPhone and James's iPod.
What does that mean exactly?
James, usually you give your iPhone and your iPod a name.
What does it mean? What does it mean to be synced with between the phone and the computer?
To be synced is basically there's two different ways to sync information to between an iPod, an iPhone, and a computer. One of those, the traditional ways, is by plugging it into the computer and backing it up to that computer at the time. You can also do it wirelessly at the same time, and you can also back up information through iCloud.
Were you able to discern which of those types of backup syncs were used?
I believe both of them were used.
Were you able to recover any images from the eCyberpower PC tower?
Yes.
Did you copy those images and place them as part of your overall report in this case?
Yes.
Your Honor, may I approach the witness, please?
Yes.
I've handed you what's been previously marked as People's Exhibit 428. Do you recognize that exhibit?
Yes, I do.
What is that?
These are images that were retrieved from the computer.
Do those images fairly and accurately depict the images that you copied as part of your forensic examination of the eCyberpower PC from the defendant's apartment?
Yes.
Move for admission of 428.
Is there any objection to P-TR-428?
No objection.
Without objection, it is admitted and it may be published.
Did you get a chance to look through those photographs?
Yes.
Do a majority of them, are they the same photographs that were also part of the iPhone?
They appear to be the same, yes.
Okay. When you conducted your examination of the eCyberpower PC, did you also retrieve any sort of browser history?
Yes.
Did you do so via bookmarks?
Yes.
What are bookmarks in talking about computer? What are bookmarks?
Okay, bookmarks, so when we're using our computer forensic software, we see an image, a document, or a file of note that relates to the case. which is what's called a bookmark. You just check it, and then you give it a bookmark name and assigns it to that category. And then when we do our findings DVD, it takes all those bookmarks and puts them in under that category.
Did you do that in this case?
Yes.
Are you familiar with the term called artifacts and related to forensic examinations of computers?
Yes.
What are artifacts?
Artifacts could be files, could be documents. It's anything that you're referring to. So if I find some artifacts related to the case, I could be referring to any of those.
Is that the same or different than bookmarks?
Pretty much the same.
Okay.
Bookmarks is something that you actually have to tell the software to remember.
Were you able to locate any sort of bookmarks or internet web pages, browser history that were within the parameters of Detective Apple's request when you searched or when you conducted the examination of the eCyberPower PC?
Yes.
Are you familiar with Firefox?
Yes.
What is Firefox?
Firefox is a browser for your computer, kind of like Internet Explorer or Google Chrome.
Were you able to locate any browser history within Firefox that was within the parameters of Detective Apple's request?
Yes.
Did you bookmark those browser histories?
Yes.
Do you know what the term URL stands for?
Yes.
What is URL?
It's Universal Resource Locator, which is basically so that if you want to pull down information from a website, if you put the URL into your address part of your browser, it will take you to that server to where the location where that file is located on that server.
Did you yourself, as part of your examination, knowing that you worked with Detective Leiker, did you yourself observe the Firefox bookmarks that were placed in your FTZ report?
Yes.
Did you also, as part of your examination, create any sort of document that listed the URL associated with those particular images?
Yes. And if I may correct you on that, the program that we were using to record those Firefox bookmarks and so forth was actually Internet Evidence Finder. That does, well, you can bookmark in it, but traditionally what we'll do is export everything out of there rather than just individual items.
The URL information and the related to those bookmarks, all that information, was that contained in your overall report as far as the forensic examination goes?
Yes.
Your Honor, may I approach the witness, please?
You may.
For the record, Judge, I'm approaching with 423A and 423B.
Okay.
For the record, I have shown this to counsel. Do you recognize People's Exhibit 423A and 423B?
Yes, I do.
Let's start with 423A. In general, what is that exhibit?
423A are what we'd refer to as screenshots of web pages.
Now, do you specifically recall observing those screenshots when you were working on this case?
Yes.
Do you specifically recall logging that information as far as URL related to it for those screenshots?
Yes.
What is 423B?
423B is a portion of Firefox bookmarks.
Do those Firefox bookmarks associate with the screenshots that make up 423A?
Yes, they do.
Move for admission of 423A and 423B.
Is there any objection?
There is, Your Honor. May we approach?
Yes. you go, sir. All right, the objection is overruled, and so exhibits P-TR-423A and P-TR-423B are admitted and may be published.
When did you conduct your forensic examination on the e-cyberpower PC?
I don't recall the exact date. I would have to refer to my notes.
Would that refresh your memory?
Yes.
With the court's permission, Judge?
Yes.
And I'm going to have to drill down into my written notes to be able to tell you that.
Well, let me just ask this question. You received the e-cyber power PC on what date? Do you recall?
It would have been the evening of the 21st. So it would have been imaged starting that evening. And generally, a 2 terabyte drive would probably go into 2 days. I'm guessing, and this is just a guess, August 23rd.
When you're looking at the URLs that are part of the exhibits that were just introduced into evidence, are you using those URLs to pull up the internet images that are contained within the other half of that exhibit?
The forensic tool that we use for this lists these URLs, okay? When we did the examination, we actually looked at those URLs because the forensic tool, we copy that file off of there, and we could place it on a computer that has internet access, and it'll go directly to that site.
Okay. So what I'd like you to explain for the jury, please, is when you conduct that forensic examination, you get that URL and you take a look at that screenshot, can you say that that's the same image that the user was looking at when they were using that computer?
I can't say 100% no.
Why is that?
Because it would have changed, and let's say we did the examination on the 23rd and we looked at it, you got 2 days difference. Could the website have changed? Yes. Do we know that? No.
Could it also have stayed the same?
Yes.
Did you also recover some information related to a Firefox session store artifacts,
Yes.
specifically for the e-cyberpower PC?
Yes.
Did you, similarly to the Firefox bookmarks, did you create a document that associated the URLs?
Yes.
Did you also, you yourself, view the screenshot images associated with the URLs?
I don't recall on the session artifacts, no.
At some point through the entirety of the investigation, were you able to review the screenshots associated with the session store artifacts?
Yes.
Did you also have an opportunity to view the URL associated with those Firefox session store artifacts?
Yes.
Okay. The images that were collected from the Firefox session store artifacts, were they copied an image as part of your forensic examination of the e-cyberpower PC?
They were there, yes.
Your Honor, may I approach the witness, please?
You may.
This is 424A and 424B, Your Honor.
All right.
I've handed you what's been previously marked as People's Exhibit 424A and 424B. Do you recognize those documents?
Yes, I do.
What are they?
I actually got 2 copies of B, so.
Okay. Your Honor, may I approach again?
Yes.
424B is the session artifacts for Firefox. The complete title is Firefox Session Store Artifacts. And 424A is those associated web pages, screenshots.
And those screenshots associate with the URLs that are part of 424B, is that correct?
Yes.
And Exhibit 424A and 424B are those exhibits that were part of your overall forensic examination and investigation for the e-CyberPower PC that was taken from the defendant's apartment?
Yes.
I would move for admission of 424A and 424B, Your Honor.
Any objection, Ms. Spengler?
Objection to 424B, Your Honor, under 401, 402, 403, the same argument related to the earlier exhibit.
All right, can I see that, please? I think you meant to object to 424A. All right, would counsel please approach? Objection is overruled, and so P-DR-424A and P-DR-424B are both admitted. P-DR-424B is admitted without objection, as was P-DR-423B. But the objection as to P-DR-424A is overruled, just as the objection to P-DR-423A was overruled. Here you go, sir. All right, Mr. Edson, you may proceed.
Thank you. Detective Madonna, from time to time, do you also field follow-up requests, either from the original case agent or someone else associated with the case?
Yes.
In this particular case, did you receive a request to follow up specifically related to music on the Lenovo tower? I'm sorry, the eCyberPower PC?
Yes.
Did you go back and do another forensic examination, or was this just based on the same information you'd already received?
This is based on the same information, the same original images.
Was there any sort of music on the eCyberPower PC on or around July 19th, 20th of 2012?
There was a file on the desktop of the computer, yes.
Okay. Explain that to the jury, please.
One of the things that we can do with our our forensic images is we can take those images and recreate them on our computers, and we can look at the desktop like someone sitting at a computer would be looking at their own desktop. So on this desktop was this file, and I don't recall the exact name of it, 25 minutes something, that was on there, and that's the one you're referring to, yes.
Were you able to determine the length of that particular piece of music?
Yes, I did.
And how long was that?
I'd have to refer to my report.
Would that refresh your memory?
Yes.
Direct your attention to your supplemental report, page 2 of 13. For counsel, it's 9142-1.
I'm not seeing that supplemental report in here.
Okay. Your Honor, may I approach the witness, please?
Yes.
Again, 91-421 for counsel. Or direct your attention to page 2 of 13, maybe even 3 of 13 of your report.
I don't see the exact time in this one, so.
Let me ask you this. Were you able to determine when that block of music was created?
Yes, I did. And I'm looking for my summary. But
Well, let me just ask this question. Go ahead, you can go ahead and flip that back over. What do you recall about the music that you found on the desktop?
Well, I could give you the exact time because I measured it, but at the very beginning of the music, there was 25 minutes of silence built into that. And then 30, 35, 40 minutes, somewhere in there. I'm not sure without looking at my reports.
Okay. And you said you could tell me, I'm sorry, you said you could tell me the exact time, is that what you said?
Yes.
What is that?
The exact time that was on there?
Yeah.
May I refer to my own reports?
Please.
Or my copies of the reports, Your Honor?
Yes.
Okay, the file that we're referring to is 25-minute Music Mania Madness. It's a Windows Media file. The last accessed date and time on that was July the 19th, 2012 at 10:34, and that's local machine time.
Okay. Judge, can I have one moment, please?
Yes.
Judge, I have nothing further. I'm just going to retrieve my report if I could.
Okay.
Okay, and I see the exact time now, so.
Do you have any cross-examination?
I do.
You may proceed.
Thank you. Good afternoon.
Good afternoon.
Detective, I want to start with the web history that you mentioned on direct examination that was taken or observed on the iPhone.
Yes.
Okay. The web history that you mentioned, the guns, the napalm, the ammo, all of that web history related to activity in July of 2012, correct?
Yes, I believe so.
Okay. And the music file you were just talking about on the desktop of that cyber tower that we saw the picture of, that music file was created, accessed, modified all on July 19th of 2012. Is that right?
Yes.
Okay. And then the images that you, the images that are contained within People's, I think it's 424A and 423A, of some of the web history or web activity that you recovered from your forensic examination of that cyber tower. When did you actually plug in those URL or those website addresses in order to pull up those images?
We looked at those, I don't know if it was the same day or the next day on the exam.
Okay, and it looked like if there was something in your report that you looked at, you'd know for sure. Am I right about that?
I believe he was asking me the exact date that we started the exam on the tower computer, and that's in the written portion of the notes.
Okay, but in terms of plugging in those website addresses and taking those images, that would be within, I'm sorry, can you just say that again? Was that?
It would have been within the day or the next day.
Okay, okay. And does an iPhone have an IP address?
Yes.
Okay. And what's the IP address for the phone that you analyzed?
I would have to refer to the report.
Could you do that to refresh your memory if that's all right with the court?
Yes, of course.
Do you have a copy of it, or am I allowed to use my own?
I think you're allowed to use your own. I do have a copy, whatever you'd prefer.
Use your own.
Is that helping with?
I'm not seeing it in here. What I am seeing is the MAC address, which
Okay.
is, I don't know if you know what a MAC address is, mobile access code, which is a specific identifier for that particular unit.
Okay, all right. I wanted to talk to you just briefly about the tower, the one that's associated with the images in 423A and 424A. That cyber power tower, you said that the operating system was installed April 26 of 2012?
Yes.
Okay. And is it your understanding that that computer was actually purchased at the end of April of 2012?
I don't recall when it was purchased, no.
Okay. And then I wanted to talk to you about the most recent requests that you received, work requests that you received in this case, and that would involve, search for some specific terms. Is that correct?
Yes.
Okay. And when I say specific terms, and I say search, I mean taking a look at the computers that were seized from Mr. Holmes' apartment and looking at them specifically, or looking at the data specifically for search terms. Is that right?
Yes.
Okay. And those search terms that you were asked to run against or through the computers included a search for Columbine,
Yes.
Dylan with Klebold,
Yes.
Eric with Harris,
Yes.
Napalm,
Let me look at my list.
did that refresh your memory?
Yes. That is correct.
Mass killings,
Yes.
mass murder,
Yes.
mass shootings,
Yes.
Norway,
Yes.
Oslo,
Yes.
Anders,
Yes.
and Bering.
Yes.
And you ran your analysis through all of those computers, and the evidence did not show that those searches were made on any of those computers, correct?
Well, let's make sure that we understand what search terms are. Search terms, when I'm looking for something on a computer, we call them text string searches. So we're looking for like say the one word mass, and generally within one word of murder. So that's what I'm looking for. It wouldn't be what someone else was typing in. Okay, those are two different types of search terms.
Okay.
So I just want to make sure that's clear.
Okay, but within your search and your specific analysis for those terms, there's no evidence that those terms showed up together related to this investigation on any of Mr. Holmes' computer.
There was a couple of them that produced hits, but they weren't related to the case.
And when we say that they weren't related to the case, what you mean is like a word like Columbine may have shown up in an article, but that wasn't necessarily related to the investigation of this case. Is that right?
Correct.
And that was something that you, with your experience as a forensic examiner, looked carefully and analyzed this data carefully for all of those search terms.
Yes.
Okay. And in fact, you didn't just do that visually, you did that with two separate programs. Is that right?
Yes, that's correct.
Both the forensic the FTK as well as the
Forensic
X-rays.
Toolkit, or FTK, and then also X-Ways.
If I may have a moment.
Yes.
You.
Thank you. Mr. Edson, do you have any redirect?
No, thank you.
And the jury does not appear to have any questions for this witness. May this witness be released from his subpoena?
Yes, Your Honor.
Is there any objection?
Your Honor, we would ask that you remain.
Okay, you may be called again, so you're still subject to the defense's subpoena. Okay, good. Thank you. All right, call your next witness, please.
People call Dr. Michael Doberson.
Let's do that.
Good afternoon, Doctor. Good afternoon. Do you solemnly swear or affirm under penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Please be seated. Could you please tell us your full name for the record and spell your first and last names?
Yes, my name is Michael J. Doberson, and the last name is spelled Dobersen.
And Michael has the regular spelling.
Michael.
Thank you. Ms. Pearson, you may proceed.
And Your Honor, with this witness, we will have graphic images pursuant to Order D98B to be displayed in conformance with your order to P118B.
Are all of the images that you're intending to display during this testimony subject to my order P118B?
Yes, Your Honor. We had included the x-rays because they are part of the autopsy, in addition to the photographs from the autopsies in our P118, and so I believe that they are all covered by the order to P118B.
Okay, thank you. We will plan on displaying them accordingly. You may proceed.
Dr. Doberson, were you the Arapahoe County coroner in 2012?
I was, yes.
Have you since retired?
I retired about a year ago.
How long were you the Arapahoe County coroner?
Approximately 21 years.
Were you involved in conducting autopsies on any of the people who died in the shooting at the Century 16 Theater?
I was, yes.
Before we get to that, would you please describe your educational background for us?
Well, I have a PhD in microbiology from the University of Miami. That was back in 1976. I subsequently went to medical school at the University of Colorado and graduated in 1989. That was followed by specialty training in anatomic and clinical pathology. I completed that at the University of Colorado affiliated hospitals. That was followed by a fellowship in forensic pathology, which I carried out at the University of Washington and at the King County Medical Examiner's Office in Seattle. And after completing that, I became board certified in anatomic, clinical, and forensic pathology. And it was about that time, 1993, that I took the position here in Arapahoe County as the coroner and medical examiner.
While you were the coroner, did you belong to professional associations that are related to pathology and forensic pathology?
Yes.
Did you publish articles relating to forensic pathology?
Yes,
Did you give lectures on forensic pathology?
I did.
When you were the coroner, what did your duties consist of?
For the most part, my duties as coroner consisted of looking into cases where there's been a sudden and unexpected death, and this is especially in situations where there's violent or suspicious circumstances. In those cases, it was my responsibility to investigate them and essentially to come to a determination as to the cause of death and the manner of death in those cases.
What does the cause and manner of death mean?
Well, the cause of death is pretty straightforward, and that's basically what injury or natural disease causes someone to die. So a gunshot wound, a heart attack, something like that. The manner of death can be a little more complicated, but it takes into consideration the circumstances under which the death occurred. It could be a natural death, it could be a homicide, an accident, suicide.
How many autopsies would you estimate that you performed during your career as coroner?
Approximately 6,000.
Have you been previously qualified in a court as an expert in forensic pathology?
Yes.
How many times would you estimate?
I would estimate about 350, maybe 400 times.
Your Honor, I would move to admit Dr. Doberson as an expert in forensic pathology.
Is there any objection?
No, sir.
All right, without objection, and pursuant to Rule 702 of the Colorado Rules of Evidence, and the decision in People v. Schreck, which is published 22 Pacific 3rd, 68, case from 2001, the court accepts Dr. Doberson as an expert witness in the field of forensic pathology. What that means, members of the jury, is that he has now been qualified as an expert, and he has been allowed by the court to render expert opinions in the field of forensic pathology. I want to remind you about the instruction that I have been giving you throughout with respect to expert witnesses, and that is that you are not bound by the testimony of a witness who testifies as an expert. The credibility of an expert's testimony is to be considered as that of any other witness. You may believe all of an expert witness's testimony, part of it or none of it. The weight that you give the testimony is entirely your decision. You may proceed.
Dr. Doberson, we've heard from Dr. Lear Call, who conducted 6 of the autopsies of the deceased from the theater. Did you conduct the autopsies of the other 6 people who died in the theater?
I did, yes.
Was there anything in common between the cause and manner of death for all 6 of those people?
The cause and manner of death were essentially the same for all 12 victims.
Now, as a forensic pathologist, do you have training in firearms and how different firearms cause different kinds of injuries?
Yes.
Is that part of the training you went through in your fellowship in forensic pathology?
It is, yes.
Do you see different kinds of injuries from a shotgun as opposed to a rifle, for instance?
Correct.
And in this case, do you also learn to determine whether or not injuries appear to be caused by close, medium, or longer range shootings?
We do, yes.
In this case, did you see any injuries that were consistent with being close or medium range injuries?
No.
And does that mean that they were longer range injuries?
Correct.
What does that mean in terms of the distance that we're talking about?
Well, generally, it means that the distance from the victim to the gun is greater than 2 to 3 feet. That's really all we can tell.
As part of the autopsy process, did you take x-rays of the victims?
They were taken under my direction, yes.
What's the purpose of taking x-rays?
Well, especially in a case like this where we needed to recover bullet fragments and other foreign material, the x-ray helps to localize that material so we could recover it.
We'll discuss the autopsies in the order that you did them. Was the first autopsy that of Jessica Gowie?
Yes, it was.
And do you recall when that was done?
That was on July 20th at about 8:45 in the morning.
I'm going to hand you what have been marked as People's Exhibits 2518, 2643, 2644, 2645, 2646, 2647, 2648, 3035, 3036, 3037, and 3088. If I may approach the witness, Your Honor.
You may.
Do you recognize all of those as being photographs of x-rays and photographs of Ms. Gowie from the autopsy?
I do.
Your Honor, I'd move for the admittance of People's Exhibits 2518, 2643 through 2648, 3035 through 3037, and 3088.
So it's 3035 through 3038, correct?
3037 and then 3088.
Oh, it's 3088. Okay, I'm sorry.
I believe that's correct. Your Honor, Dr. Doberson, would you look at the very last photo in that and make sure it's 3088?
It is, well, it's 3038.
Oh, it is 3038. Okay, my mistake.
All right. Is there any objection?
No additional objection?
Okay. To the extent that these are subject to my order D98, amended D98B, the objection, or I stand by my rulings, and so they are admissible pursuant to that order. To the extent that these are not subject to that order, I infer that there is no objection and they're admitted without objection. So that's P-TR-2518, 2643 through 2648, and 3035 through 3038.
Was Miss Gowie's body x-rayed?
It was, yes.
If we could have up 2518, please, first. And there should be a mouse that works as a pointer on your screen. Does.
It sort of works.
It's a little
Okay.
little fast, but it's hard, a little difficult to use. What are we looking at in this photograph?
Well, these were, again, x-rays that were taken prior to the autopsy being carried out, and obviously you can see x-rays of the head, the chest, the abdomen, as well as the lower extremities.
Could I have 2643, please? What do you observe in this photograph?
This is an x-ray, a lateral x-ray of the head. And the most significant finding here, I think, is a large defect in the skull. And it's associated with a lot of radiodense particles, or those are actually bullet fragments.
Are you, could you point that out? Is that on the forehead?
That,
if the mouse...
It's not moving very well, but yes, the defect is this darker region. It really corresponds to parts of the skull that are missing. And the very light particles here that I'm pointing to are projectile fragments.
2644, please. Can you tell us what you observe here?
This is a radiograph of the chest, and you could see up on the left shoulder, and by left it's reversed. It's as if the person was facing you. So where the pointer is, you can see 2 bullet fragments in the left shoulder.
2645, please. Can you explain anything that we observe in this x-ray?
This is an abdominal x-ray, and what you can see down in the lower abdomen near the bottom of the picture are 3 bullet fragments, and this approximates where 3 gunshot type wounds were sustained in that area.
2646.
This is an x-ray of the the lower extremities, and where I have the pointer, you can see several bullet fragments. Again, these are very light, irregularly shaped objects.
2647.
And this is an x-ray of both lower extremities. A little further down, you could see both knees in the x-ray. And where I'm putting the pointer are a number of other smaller bullet fragments, and you can also appreciate some of the tissue damage by the darker area of the x-ray, just adjacent to that pointer.
2648, please.
And this is an x-ray of the lower part of the lower extremities, and I don't believe we're seeing any fragments here.
Thank you. You can take that down. After her body was x-rayed, what was the next stage of the autopsy?
Well, the next stage would have been to do the external examination. As you probably have covered already, an autopsy consists of the external examination and the internal examination, and they complement one another with respect to describing injuries.
What injuries did you observe on the external examination?
Well, in all, Jessica Gowie sustained 6 gunshot wounds. The most severe was the gunshot wound to the head, and that's to the left side of the head. The entrance wound was kind of in the left periorbital or around the eye region. She also had 3 gunshot wounds, as I mentioned before, to the abdomen, and there were also gunshot wounds to the left shoulder as well as the right leg, which we saw in the x-rays.
Now, were photographs taken of her during the autopsy and prior to the internal portion of the autopsy?
Yes.
Could I have 3035, please? And is this a photograph of her head showing that massive injury?
Yes, I'm so sorry for this.
Could I have 3036, please?
This you can see the right lower extremity. You could see the effects of the gunshot wound to the right lower extremity.
3037, please. Oh, I'm sorry. And were there additional wounds that you saw on the left leg as well?
There were, but they were very superficial. They're mainly bullet fragments that were found.
3037, please.
And these were wounds that are on the left arm. There were also some over the left side of the torso. And these are simply shrapnel type wounds. Apparently one of the projectiles went through an object, probably a seat, in the theater. It fragmented and impacted these parts of her body. There's very little injury to this. It's very superficial.
You can take that down. After the external exam, did you do an internal exam as well?
I did.
And if I could have 3038, please. Within this, do you see one of the projectiles?
Yes, and this is during the autopsy. Again, the purpose of this was to recover the fragments, but I'm moving the pointer to a conical metallic object, which was part of one of the projectiles, and this was recovered at the time of autopsy. This is her left shoulder.
Thank you. You could take that down. What else did you discover or observe during the internal exam?
Well, except for the fact that she was a healthy young woman, it really pointed out that her death was due to that very severe gunshot wound to her head. That was the cause of death.
Did you find other projectiles in her body?
Yes, we did.
Where were they located?
There were 3 located in the abdomen, and as you could see, there was one located in the left shoulder, and I believe we also recovered some fragments from that injury to her right leg.
Were you able to determine whether her injuries appeared to have been caused by a rifle, a shotgun, or a handgun bullet?
They're very characteristic of a rifle.
Can you describe the path for us that the bullets took through her body, and would the mannequin assist you in describing that?
Yes.
If you could step down, please. And there's a handheld microphone there.
Is that okay? Again, just to reiterate, the most severe wound was to the left side of the head, and the entrance wound was approximately here in that left region around the eye. The bullet path was pretty much front to back. The bullet fragment was also recovered from the left shoulder, if you recall. It just went in to, roughly left to right. 3 bullet fragments were found here in the abdomen. They were recovered, again, left to right. And then the injury on her right leg, a few fragments were recovered. It's very difficult to determine just what the direction was there. It was a very devastating wound. Hard to tell which direction, but those are essentially the injuries that we saw.
Your Honor, can we approach before we go on?
Yeah. You may proceed.
Dr. Doberson, what was the cause and manner of death for Jessica Gowie?
The cause of death was severe injury to the head due to a gunshot wound, and the manner of death is homicide.
Your Honor, this would be a good time for a break.
Okay. All right, members of the jury, it's 3:15. Let's go ahead and take our afternoon break. Please remember that all of the advisements I have been giving you throughout the trial apply during the break. And so please make sure you adhere to all of them. Let's take 20 minutes. I'll see you back here in 20. Thank you. Please be seated, everyone. Dr. Doberson, you may go on break. Thank you. The record should reflect that the jury has exited the courtroom, so we're now outside the presence of the jury. I just wanted to follow up to the, I think it was the last bench conference that we had while Detective Madonna was testifying. I said at the very end of that bench conference that the time frame that we're working with or that we're looking at didn't concern me. And what I meant by that is that it's my understanding that the computer in question was purchased, I believe, in April, or was started being used in April, and the exam by Detective Madonna was done in August. So we're talking about a few months or some months only. We're not talking about a difference of 5 years or 10 years, where I would be more concerned about a website undergoing substantial changes. And so that's what I meant with that last sentence or statement that I said. I wanted to clarify that. All right. Is there anything else on behalf of the people at this time before we take a break, Ms. Pearson?
No, Your Honor.
Is there anything else on behalf of the defense, Ms. Brady?
No, sir.
All right. I'll see you in 20. Thank you. The court will be in recess.
Well, we're hearing from the second coroner who went over the other 6 autopsies right after the shooting. It's Dr. Michael Doberson, a retired coroner from Arapahoe County. We already heard from Kelly Lear-Call, who is the other coroner that did the 6 other autopsies. You saw the mannequin brought back in, so there'll be a lot of referencing of that mannequin in terms of the injuries suffered by the 6 others we have not gone through yet who did not make it out of the theater alive. Still anticipating the former girlfriend of the defendant to take the stand at some point, whether it's no longer today, possibly tomorrow, so that they can get in these email that the district attorney had talked about earlier today, saying that there was going to be a witness later today as a result of what they were talking about, which were those email and GChat sessions. So we were anticipating the former girlfriend to take the stand. That has not happened yet. Some of the new information we saw were some more disturbing photos of the defendant, the selfies that he took, very clear on the screen, shown to the jury, and we want to take you back to the testimony from Aurora Police on the stand, talking about the forensics of the phone and finding these photos and other detailed forensic evidence done by Aurora Police.
What is the, within People's Exhibit 525, is there metadata associated with this photograph?
Yes.
What is the created time for this photograph?
The created time is 7/5/2012, so July 5th, 2012, 8:32:15 a.m.
And again, this was a photo from the iPhone, is that correct?
Yes.
If I could have number 7, please. What is the metadata created, or capture time, I should say, for this photograph?
The capture time is July the 5th, 2012 at 4:12:36 p.m.
If we could please have number 15, please. What is the capture time associated with this photograph?
Capture time is July the 11th, 2012 at 12:28:24 a.m.
Number 17, please. What is the capture time for this image?
July the 16th, 2012, 8:26:02 p.m.
So, within a few minutes, fairly depict the same time on the microwave in that photograph?
Yes.
Number 19, please. What is the capture time for this image?
July the 16th, 2012, 8:27:03 p.m.
'25, please. What is the capture time of this image?
July the 19th, 2012, 5:17:40 p.m.
When you're saying the time being 5:17 p.m., is that local time, non-local time? How does that work with an iPhone?
I believe those are UTC.
What is UTC?
Coordinated Universal Time, and don't ask me why they did it that way, because when you spell it out, it's not the same, but it's Coordinated Universal Time, which is the same thing as Zulu Time, Greenwich Mean Time.
How does that correspond to Mountain Time or local here in Denver?
In July, you'd subtract 6 hours.
27, please. What is the capture time of this image?
Capture time is July the 19th, 2012, 6:22:20 p.m.
Number 31, please. What is the capture time for this image?
July the 19th, 2012, 6:31:13 p.m.
33, please. What is the capture time for this image?
July the 19th, 2012, 6:37:27 p.m.
35, please. Capture time of this image?
July the 19th, 2012, at 6:40:39 p.m.
Okay, you can take that down, thank you. Were you able to look at outgoing phone calls from the defendant's iPhone?
Yes.
Were you able to look at the last outgoing phone call made from that iPhone?
Yes.
Were you able to capture, based upon your examination, the date and time of that last phone call?
Yes.
What was that?
I'd have to refer to the report.
Would that refresh your memory?
Yes.
Do you still have your report in front of you?
Yes.
Okay. So I'll direct your attention to the iPhone report, page 8.
Yes.
When was the date and time of the last phone call?
That was July 20th, 2012, at 6:30:50 UTC.
How does that correlate to Denver time?
That would be roughly 12:30
In the morning?
in the afternoon. In the morning, yes.
What was that number 2? The dialed 2 number?
720-848-0000.
Were you also able to capture the duration time of that call?
It was for 18 seconds.
Were you able to also look at the various contacts in the phone?
Yes.
Was there a contact within the defendant's iPhone for a Robert Feinstein?
Yes.
Was that an email, phone? What was that? Do you recall?
I'd have to refer to it.
Would that refresh your memory to look at your report?
Yes.
Direct your attention, with the court's permission, to refresh your memory with your iPhone report.
That's fine, but when you're refreshing your memory, what that refers to is you can look at the report, put it down, then let him know if that refreshed your memory or not. If it did, then you can answer the question. You're not supposed to read from the report.
Okay.
Does that make sense?
So, sir, I'll direct your attention to page 13 of your iPhone report.
Yes, it does.
Okay, so my question, I don't need you to read it aloud, but was there a contact information for a Robert Feinstein in the defendant's iPhone?
Yes.
What kind of contact info?
Referring back to the report, it would have been email address.
Was there a contact information in the defendant's iPhone for a Lynn Fenton?
Yes.
What kind of contact information?
I believe that was a email address.
Was there a phone number as well?
There was, yes.
Were you able to also look at some text messages within the defendant's iPhone?
Yes.
Were there some text messages contained in the defendant's iPhone from a contact that goes by the name of Hillary?
Yes.
Do you recall the approximate date of some of those text messages?
I believe there was a couple dates in there in April of 2012.
When you capture a text message exchange, do you capture both the outgoing and incoming messages?
Yes.
And did that occur in this case?
Yes.
Were you able to recover any browser web history from the defendant's iPhone?
Yes.
Was there any browser web history on the defendant's iPhone that was within the parameters of the initial requests from Detective Apple related to this case?
Yes, I believe so.
What was some of the browser history, if you recall?
Just right off the top of my head, law enforcement targets, the bomb, things like that.
Okay. Was there any browser history about chemicals such as napalm, gunpowder, things like that?
Yes.
Was there any sort of web browser history on the defendant's iPhone related to weapons, such as guns?
Yes.
What about weaponry such as ammunition?
Yes, I believe so.
Was there any browser history on the defendant's iPhone related to the New York Times?
I don't recall. I'd have to look at my report.
Would it refresh your memory to do so?
Yes.
With the court's permission, I would direct your attention to page 70 of the iPhone report.
7-0?
70, yes. And again, as the court stated, just refresh your memory and flip it back over when you're done, please. Direct your attention to lines 78 and 79.
Yes, there was.
Okay, what was it?
Something about sending an article to the New York Times.
Sir, what is the capture time associated with this image from the iPod?
The capture time is July the 14th, 2012 at 9:02:28 p.m.
Image 3, please. What is the capture time associated with this image?
July the 14th, 2012 at 9:02:40 p.m.
Image 5, please. What is the capture time for this image, please?
July the 14th, 2012 at 9:03:11 p.m.
Image 7. What is the capture time of this image?
July the 14th, 2012 at 9:03:31 p.m.
Thank you. Let me take that down. Were you able to successfully complete a digital forensic examination of the NZ XTE CyberPower PC?
Yes.
Also referred to as a tower computer?
Yes.
Do you know what an IP address is?
Yes, I do.
What is an IP address?
IP is abbreviation for Internet Protocol Address.
What does that refer to?
Internet Protocol Address is so that computers can talk to each other, to servers and so forth on the Internet. So think of it as basically a post office address so that your computer can talk to a server or any other computer out there as long as it knows where the IP address or what the IP address is.
Were you able to establish information related to an IP address for the eCyberPower PC tower that was taken from the defendant's apartment?
Yes.
What is that IP address?
I would have to look at the report to...
Would that refresh your memory?
Yes, it would.
I'd refer you to page 3 of your report with the court's permission. Go ahead.
Yeah, I'm going to have to read from this because I can't remember.
I can understand. Go ahead.
The IP address is 67.166.38.7.
Thank you, sir. Were you able to retrieve information from that eCyberPower PC related to the operating software?
Yes.
What was the operating software for that computer?
Windows 7 operating system.
Were you able to establish when that operating software was installed?
Where it was installed?
When?
Or when, yes. April 26th, 2012.
Would that be the first time someone would use that particular software on the computer?
Yes.
I'm going to jump around just a bit, but did you conduct a forensic examination of the Lenovo tower as well?
Yes.
Do you recall, did you receive information as to when the last time that tower was used as far as being logged into?
Yes, I did.
When was that?
I'd have to refer to the report.
Would that refresh your memory?
Yes, it would.
Okay. With the court's permission.
Yes.
Refer you to page 6 of your report.
April 25th, 2012.
Okay, and now moving back to the eCyberPower PC.
Yes.
Were you able to establish information as to when the last time the eCyberPower PC was logged into?
Yes.
Okay. Do you happen to recall that?
Just to make sure, I'd have to refer back to the report.
Okay. Again, with the court's permission.
Yes.
The last shutdown time on the tower computer was July 19th,
Of what year?
2012. Sorry.
Were you able to access or otherwise look at the system's operating clock within the tower PC?
Yes.
Did that appear to be accurate as far as date and time?
Yes, it was.
When you examined the eCyberPower PC, and again, is that the computer that I showed you the photographs of earlier?
Yes.
That tower PC, was there any information related to that tower PC being synced to any sort of products?
Yes.
Describe for the jury, please.
It had been synced to a James's iPhone and James's iPod.
What does that mean exactly?
James, usually you give your iPhone and your iPod a name.
What does it mean? What does it mean to be synced with between the phone and the computer?
To be synced is basically there's two different ways to sync information to between an iPod, an iPhone, and a computer. One of those, the traditional ways, is by plugging it into the computer and backing it up to that computer at the time. You can also do it wirelessly at the same time, and you can also back up information through iCloud.
Were you able to discern which of those types of backup syncs were used?
I believe both of them were used.
Were you able to recover any images from the eCyberPower PC tower?
Yes.
Did you copy those images and place them as part of your overall report in this case?
Yes.
Your Honor, may I approach the witness, please?
Yes.
I've handed you what's been previously marked as People's Exhibit 428. Do you recognize that exhibit?
Yes, I do.
What is that?
These are images that were retrieved from the computer.
Do those images fairly and accurately depict the images that you copied as part of your forensic examination of the eCyberPower PC from the defendant's apartment?
Yes.
Move for admission of 428.
Is there any objection to P-TR-428?
No objection.
Without objection, it is admitted and it may be published.
Did you get a chance to look through those photographs?
Yes.
Do a majority of them, are they the same photographs that were also part of the iPhone?
They appear to be the same, yes.
Okay. When you conducted your examination of the eCyberPower PC, did you also retrieve any sort of browser history?
Yes.
Did you do so via bookmarks?
Yes.
What are bookmarks in talking about computer? What are bookmarks?
Okay, bookmarks, so when we're using our computer forensic software, we see an image, a document, or a file of note that relates to the case, which is what's called a bookmark. You just check it, and then you give it a bookmark name and assigns it to that category. And then when we do our findings DVD, it takes all those bookmarks and puts them in under that category.
Did you do that in this case?
Yes.
Are you familiar with the term called artifacts and related to forensic examinations of computers?
Versus James, Eagan Holmes, case number 12CR1522. The record should reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. Are you folks ready for the jury, Ms. Pearson?
Yes, Your Honor.
Ms. Brady?
Yes, sir.
Okay, great. Let's bring the jury in, please. Please be seated, everyone. The record should reflect that the jury is back in the courtroom. Dr. Doberson, I remind you that you're still under oath. And Ms. Pearson, you may resume your direct examination.
Dr. Doberson, did you do a second autopsy on July 20th of 2012?
I did.
And who was the person that you conducted the second autopsy on?
That was Alexander Boeck.
And do you know what time you began Mr. Boeck's autopsy?
It was about 2:30 in the afternoon.
I'm going to hand you what have been marked as People's Exhibits 2515, 2606, 2607, 2608, 3039, and 3040. Do you recognize those as photographs from the autopsy of Alexander Boeck?
I do.
Your Honor, I'd move for the admittance of People's Exhibits 2515, 2606 through 2608, 3039, and 3040.
Is it 3040 or 30? Yes, 3040. Thank you.
No additional objection.
Okay. Based on my previous rulings in amended order D98B, the exhibits are admitted to the extent that there has been any objection to them. To the extent that there was no objection in motion D98 or any other motion in the past, then they're admitted without objection. So that's P-TR-2515, 2606 through 2608 inclusive, and 3039 and 3040. And they may all be published.
Was his body x-rayed as part of the autopsy?
It was.
Could I have 2515, please? What do we see in this photograph?
Well, these are, as you mentioned, x-rays were taken, and these are x-rays of the head, chest, and the left side of the body. I'm sorry, the right side.
2606, please. Was there anything that you could observe in this particular x-ray?
Yes, in this particular x-ray, this is obviously an x-ray of the head, and you can see various round, dense foreign bodies, and these represent shot from a shotgun blast.
2607. What do you observe in this?
This is an x-ray of the chest, and as you can see, the same projectiles are present in the chest and also in the right shoulder.
2608. What are we looking at in this one?
Well, this, I think this is reversed. We're still looking at the right side. Again, you see some of these shots, and I'm just putting the pointer by one of them, but they're present in the chest and the right arm.
You can take that down. Did you do an external exam?
Yes.
What did you observe on the external exam?
The main injury here was a shotgun injury to the right side of the head, probably from the same shotgun blast. The right arm, right shoulder, and right chest were also injured.
Were photographs taken of his body during the autopsy, but prior to the time of the internal exam?
Yes.
If I could have 3039, please. Is this Mr. Boeck?
It is.
And do you see the shotgun blast to his head in this one?
Well, for the most part, you just see blood. The actual shotgun type injuries are to the right side of his head.
3040, please. What do you see in this photograph?
This was taken at a later time during the autopsy, and the actual shotgun wounds are more visible. Again, you can see them on the right side of the head, face, shoulder, and chest, as well as the arm.
You can take that down. Did you do an internal exam as well?
Yes.
What did you discover during the internal exam portion of the autopsy?
Well, during the internal exam, there were some injuries to the right lung. Some of those shot did penetrate his chest. For the most part, the most severe injury was the shotgun injuries to the head. Some of the pellets did extend into his skull and injured the brain.
Was shot pellet recovered from his autopsy?
Yes.
Were you able to determine, based on the injuries that you saw, what kind of a firearm caused his injuries?
Yes, this was a shotgun.
And would you step down to the mannequin to describe the path that the pellets took in his body?
Well, as I think you can see from the photographs, the shotgun blast came from the right side. There were quite a few pellets that were entering his head, face, and the neck as well. And then there were a few that entered the arm, the chest, and the shoulder. The pellets to the chest did penetrate and injure his right lung, but the most severe injury was to his head.
Were you able to determine a cause and manner of death for A.J. Boyk?
Yes.
What was the cause of death?
The cause of death were head injuries due to a shotgun wound to the head.
And the manner of death?
Homicide.
Did you do a third autopsy on July 20th of 2012?
I did.
And who was that?
That was Matthew McQuinn.
What time did you begin that autopsy?
That was at 4:45 p.m.
I'm going to hand you what have been marked as People's Exhibits 2520, 2521, 2620, 2621, 2622, 2623, 2624, 2625, 2626, 2627, 2628, 3041, 3042, 3043, and 3045. Are these all photographs that were taken during the autopsy of Matt McQuinn on July 20th of 2012?
Yes.
Your Honor, I would move for the admittance of People's Exhibits 2520, 2521, 2620 through 2628, and 3041 through 3043, and 3045.
Any objection?
No additional objection.
All right, to the extent that there has been an objection to any of these exhibits, I rely on my rulings in amended order D98B, as there is no additional objection. To the extent that there has been no objection and there is no objection, then these exhibits are admitted without objection. So P-TR-2520, 2521, 2620 through 2628 inclusive, 3041 through 3043 inclusive, and 3045 are all admitted and may all be published.
Was his body x-rayed as you've done with the others?
Yes.
Could I have 2520, please? Is this an overall x-ray of all of the parts of his body? Or some of them, rather?
It is, and again, goes from the head to the abdomen, and you can see various, for example, a pair of glasses is evident here on the head x-ray, and a necklace here about the neck. But for the most part, we see a lot of foreign material. These are projectile pieces, and they're present in the chest and the abdomen as well.
2521, please. What does this depict?
These are the lower extremities, and it's difficult to see, and this was kind of a difficult case. You can see some projectiles here. Here's one, for example, on the left leg, and also you can see here on the right leg there's a fracture of the fibula, which I have the pointer next to.
2620. What do you observe in this photograph of the x-ray?
Well, this is an x-ray of the head, and there's really no projectiles that are noted here. There was a gunshot wound to the neck, but it's not visible here, and it was only associated with a few projectiles.
2621. So was there anything that you observed in this photograph?
Well, here, right at the center, near the spine, I have the pointer on it, is a bullet fragment, a conical-shaped, a cone-shaped bullet fragment. And then over the shoulder, you can see a few other projectiles, and these were all recovered at the autopsy.
2622.
Again, very similar, just projectiles here in the right chest cavity. Also, you can see evidence of of some soft tissue injury here along the right arm. Or I'm sorry, this is actually the left arm. Some of these are turned around, but you can see the soft tissue injury here on the right arm.
2623.
This is the same.
2624.
This is the left arm, and you can see the humerus has been fractured, and it's associated with a lot of projectile fragments.
2625.
This is an x-ray of the abdomen, and once again, projectiles that were recovered. All in all, there were 9 gunshot wounds that Mr. McQuinn sustained.
2626.
This is the same.
2627.
And these are the lower extremities. You could see the areas of the knee at the top. Once again, he sustained 5 gunshot wounds to the lower extremities. Some were through and through, and some were associated with projectiles.
2628.
This is the fracture of the fibula that I've mentioned before. It's the right leg.
Did you do an external exam?
I did.
What did you observe on the external exam?
As I mentioned before, all in all, there were at least 9 gunshot wounds that he sustained. The most severe was a gunshot wound to the neck. It entered on the left side, went through the neck, and was associated with transections or injuries of all of the major blood vessels in the neck. The other wound that was very severe was a wound to the chest, and that entered at the right upper chest and came out the left side of the chest. It also injured the left arm, and this was associated with with very severe injuries to the internal organs, both lungs and the aorta, which is the major artery of the chest.
And were there photos taken of his body prior to the beginning of the internal autopsy as well?
Yes.
Could I have 3041, please? Do you see injuries in this photograph?
You do, and you can see on the right side of the neck, this is actually the exit wound for the wound that I just described. It enters the left side of the neck, exits the right side. It's associated with, again, very severe injuries.
3042.
This is the exit wound to the gunshot wound to the chest that I just described. It does traverse the chest, comes out here in the left armpit region, and then it also enters the left arm. And this was also associated with the fracture of the left humerus, which I'm roughly pointing to.
3043.
This is our wounds to his right lower extremities. Actually, both lower extremities had them, but these are gunshot-associated injuries to his right thigh.
3045.
This, I believe, we talked about.
You can take that down. Now, you discussed somewhat some of your findings on the internal exam. Were there other findings that you made when you did the internal exam of Mr. McQuinn?
Only injuries related to the gunshot wounds that I just described.
Were you able to determine what kind of firearm caused all of his injuries?
I believe all of the injuries were attributable to a rifle.
And if you could approach the mannequin and describe the path of the injuries, please.
I'll just describe, because there were so many wounds, I'll just describe the main one again.
Why don't we have him use the microphone?
Oh, I'm sorry. The most severe wounds, there were two of them. One was to the neck again, and the entrance wound is on the left side of the neck. The exit is on the right. The other wound to the chest, the entrance wound was here on the right side of the chest. It traverses the chest, comes out the left side of the chest, and was also associated with an injury to the left arm. There were other wounds, at least 5 wounds to his lower extremities, and one wound to his back, and several to the abdomen. And 9 altogether, 2 of them being the cause of death.
What did you determine the cause of death was for Matthew McQuinn?
In this case, severe internal injuries due to gunshot wounds to the neck and chest.
And the manner of death?
Homicide.
Did you do any other autopsies on July 20th of 2012?
No.
Did you continue to conduct autopsies on July 21st of 2012?
We did, yes.
Whose was the first autopsy that you did on July 21st?
The first one was Rebecca Wingo, and that was done at 9:50 a.m. on July 21st.
I'm going to hand you what have been marked as People's Exhibits 25, 27, 26, 39, 26, 40, 26, 41, 26, 42, 48, 71, 48, 72, 48, 73, 30, 46, 30, 47, 3048, and 3049. Do you recognize those photographs as being photographs taken during the autopsy of Rebecca Wingo?
I do.
Your Honor, I'd move for the admittance of People's Exhibits 2527, 2639 through 2642, 4871 through 4873, 3046 through 3049.
Ms. Brady?
No additional objection.
To the extent that some of these exhibits have been objected to before, I stand by my rulings in amended order D98B. And so they are admitted for those reasons. To the extent that some of these exhibits were not objected to in the past, and they are admitted without objection. So P-TR-2527, 2639 through 2642 inclusive, 4871 through 4873 inclusive, and 3046 through 3049 inclusive are all admitted and may be published.
Could I have 2527, please? What is this a photograph of?
Well, these are all photographs of the taken before the autopsy of Rebecca Wingo, going from the head to the upper extremities and the chest.
2639, please.
Well, this is a radiograph of the head, and as you can see, it's a relatively complex situation. We have at least two different projectiles here. We have projectiles that I'm pointing to here on the side of the head that are consistent with the shotgun injuries we've described previously. Also, towards the front of the face, we can see very irregularly shaped projectiles, which are likely from a rifle. So there were two different weapons that impacted Ms. Wingo.
2640.
These were x-rays taken of the chest, and actually what you see here for the most part is an underwire bra. These curved structures are the underwire for the bra. There was a gunshot wound to the chest that was actually where the bullet was actually embedded in the left underwire of the bra, and that's seen right here, right at the pointer. And just, it might be confusing, but this area on the back is simply the clips on the back of the bra.
2641.
It's the same.
2642.
This is just a radiograph of the abdomen, and there are no projectiles that were found.
4871.
This is just a partial x-ray, it looks like, of one of the upper extremities, and it does not show any projectiles.
4872.
Same.
4873.
And this is simply an x-ray, once again showing similar features that we've seen before.
Did you do you can take that down. Did you do an external exam on Miss Wingo?
Yes.
What did you observe during the external exam?
Overall, she sustained 4 gunshot wounds. 3 of them were gunshot wounds, likely from a rifle, and the other one was a shotgun wound, as you could tell. 2 of the wounds were to the head, and there were also 2 to the abdomen.
Were photographs also taken of her?
Yes.
Could I have 3046, please? Is this a photograph of her face?
Yes.
And are there any injuries that you can see on this photograph?
Not very well, but again, on the right side of the face and head are shotgun-type wounds.
3047, please.
This is a photograph of the right side of her abdomen. Her head is to the left, her feet are to the right, and here you can see the entrance wound. Actually, there were 2 wounds to the abdomen, and none of them were really serious. They didn't enter the peritoneal cavity or the chest cavity. They were very superficial.
3048.
And I believe we're looking at her back, and it's just difficult to see that there's some foreign material here, but I believe this really doesn't show anything.
3049.
And these are shotgun-associated injuries to her right shoulder. As I mentioned, the blast was to the right side of her head. There were also some shot that entered her right shoulder.
You take that down. Did you do an internal exam as well?
Yes.
And during the internal exam, did you make any other observations?
Well, as far as what I've described before, the 2 wounds to the abdomen were very superficial, no internal injuries. The 2 wounds that were the most severe that caused her death was the shotgun wound to the right side of her head. There was also a rifle-type wound to the right side of the back of her head. I don't believe that was depicted in the pictures, but that's the source of the fragments that we saw in the X-ray of her head.
Did you recover fragments and projectiles from her body?
We did.
And could you describe the path that you observed on the mannequin, please? And the microphone you'll need to.
Yes. Again, as I just described, there were 2 gunshot wounds to the abdomen. They essentially went from right to left and didn't cause any internal injuries. The 2 most serious wounds were the wound from the shotgun to the right side of the head. There was also an entrance wound from the rifle wound that went to the right head as well. Both directions were from right to left, and there were severe injuries to the brain associated with one.
Ladies and gentlemen, we appreciate your patience as we adjust our signals. We're using a microwave transmitter, but due to lightning in our area and some severe storms headed our way, we are switching to a cellular signal. We'll have that restored for you momentarily. Thank you for your patience.
I'd move for the admittance of People's Exhibits 2517, 2698, 2599, 2600, and 3050 to 3053 inclusive.
No additional objection.
Ms. Pearson, are you sure it's 2698, not 2598?
I think it is, and I'll ask Dr. Doberson to check.
I have 2598.
Okay, then that would be the correct number. So it'd be 2517, 2598, 2599, and 2600.
All right. To the extent that there has been an objection to any of these exhibits, I stand by my rulings in order amended order D98B. To the extent that there has been no objection to these exhibits, then they are admitted without objection. So P-TR-2517, 2598 through 2600 inclusive, and 3050 through 3053 inclusive are admitted and may be published.
Was his body x-rayed as part of the autopsy?
It was.
Could I have 2517, please?
There was, in this particular case, there was only one gunshot wound, and it was to the chest. So these are just 3 different x-rays, and none of them show any projectiles.
2598.
Again, the same thing. This is an x-ray of the chest. There do appear to be some particles here, but I don't believe they were within the body. The gunshot wound mainly went from the right armpit to the left. And so this is just extraneous material, but it was a perforating wound, which means it went in and exited.
2599.
And again, this pretty much the same thing.
2600.
Same.
Did you do both internal, you can take that down, please. Did you do both an external exam and an internal exam for Mr. Cowden?
I did.
Could I have 3050, please? Is this Mr. Cowden?
This is Mr. Cowden, yes.
3051.
I'm not sure, well, this picture shows the entrance wound, and I'm trying to move the pointer to, this is the right armpit, essentially, and that is the entrance wound at the end of the pointer. The other injuries are just a bruise and scratch that he sustained, very minor.
3052.
And this is the left armpit, the back of the left armpit, and you could see the exit wound right here at the end of the pointer.
3053.
And this is another photograph of the entrance wound in the right armpit.
You can take that down. What did you discover during the internal exam of Mr. Cowden?
Well, this is, again, a single perforating gunshot wound, and it traversed the chest. It caused injuries to both lungs, the heart, and the aorta, again, the major artery of the chest.
Were you able to determine, based on the observations of his injuries, whether a rifle, a shotgun, or a handgun caused his injuries?
Because of the appearance of the x-ray and the internal examination, it looked like this was a handgun.
Can you describe the path that the bullet took, and did you only find one gunshot wound to him?
We only found one gunshot wound, and essentially it was from right to left, slightly upward.
Did you recover any kind of projectiles or fragments in his body?
No.
Did you determine a cause and manner of death for Mr. Cowden?
Yes. Severe internal injuries due to a gunshot wound to the chest.
Is that the cause of death?
That's the cause
And the
of
manner
death.
of death?
Homicide.
Did you do a third autopsy on July 21st of 2012?
I did.
And who was that?
And that was Alexander Teves, and that was done at 2 p.m. in the afternoon.
I'm going to hand you what have been marked as People's Exhibits 2526, 2603, 3054, 3055, and 3056. Are these photographs of the x-rays and of Mr. Teave's body that were taken during his autopsy on July 21st of 2012?
They are.
Your Honor, I'd move for the admittance of People's Exhibits 2526, 2603, 3054, 3055, and 3056.
Approach.
Yes. All right. The objection is partially sustained and partially overruled. Folks, I know there's a different kind of smell in here. Apparently, they were using a sealant upstairs. Perfect timing, right? But apparently, they're finished now, so hopefully it'll get better. All right, Ms. Pearson, you may proceed. I guess I need to, I don't think I ruled on the rest of them, so let me do that now. Based on my ruling, Exhibit P-TR-2526 and P-TR-3054 are excluded. They are not admitted based on the ruling I made at the bench. With respect to the other exhibits, they are admitted either based on my ruling at the bench or based on my previous rulings in amended order D98B. All right, you may proceed.
Was Mr. Teves' body x-rayed?
Yes, it was.
If I could have 2603, please. Could you explain what you see in this photograph?
Well, we can see a lot of fracturing of his skull, and within the calvarium or the head, you can see a number of irregular projectile fragments.
Did you? You can take that down. Did you do both an external exam and an internal exam of Mr. Teves?
I did.
On the external exam, what did you observe?
In this case, there was also only one gunshot wound, and it was sustained to the head, as you could see from the X-ray. It was on the right side of the head, near the top of the head, and it was directed essentially downwards and front to back.
Were photographs taken?
Yes.
Could I have 3055, please? Does that show the wound to his head?
It does. You could see here, again, on the left side of the head is a large wound.
And 3056, please. And was this Mr. Teves?
It is.
You can take that down. Did you recover projectiles during his autopsy?
We did.
Based on the injury that you observed, could you tell what kind of a firearm caused this injury, whether it was a rifle, a shotgun, or a handgun?
It was caused by a rifle.
Did you determine a cause and manner of death for Mr. Teves?
I did.
What was the cause of death?
It's severe head injuries due to a gunshot wound to the head.
And what was the manner of death?
Homicide.
Thank you, Dr. Doberson. I don't have any more questions.
Ms. Brady, do you have any cross-examination?
No, sir, thank you.
And the jury does not appear to have any questions for Dr. Doberson. May Dr. Doberson be released from his subpoena?
He may.
Is there any objection?
No, sir.
Dr. Doberson, thank you.
Thank you.
Call your next witness, please.
People call Gargi Datta.
Good afternoon. Could I have you raise your right hand for me, please, so that I can administer an oath? You solemnly swear or affirm under penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
All right, please be seated. Okay, yes. Could you remove the mannequin, please? Thank you. Could you please tell us your full name and spell your first, middle, and last names?
My name is Gargi Datta, Gargi Datta.
Mr. Brockler, you may proceed.
Thank you, Your Honor. And would you please tell us what you do for a living?
I'm a graduate student in computational biology at University of Colorado.
Do you know this guy right over here, seated in between these two women with the beard and the mustache? And the
Yes.
glasses? How do you know him?
I knew him from school. He went to school with me at University of Colorado.
I want to talk to you about the time that you met him all the way through when you last spoke with him, okay? First off, are you nervous?
Yes.
I understand. First, tell me when you first met the defendant.
I first met the defendant at orientation in August 2011.
And was that at the Anschutz campus of the University of Colorado?
Yes, it was.
What was that interaction like?
I do not remember really having an interaction with him. He sat at the same table as us at orientation, but I do not remember talking to him.
When you say us, who is us?
I know Ben Garcia was there. I don't remember anyone else who was there on that table.
Did you make any observations of the defendant in August of 2011?
Just that he was wearing bright blue sunglasses.
Okay.
Really bright blue sunglasses, yeah.
When was the next time you remember having any more significant contact with the defendant?
Sometime in September 2011, in classes together, we all graduate students at Anschutz Medical Campus take this core biology class together, and we were in the same class.
And what was the period of time that you were in class together?
We were in the core class from September to December 2011, and another neuroscience class from January to May 2012.
What was that second class you mentioned?
I believe it's called Biological Basis of Neurological Disorders, something of that sort.
And that lasted pretty much that entire second semester, if I'm using the right term?
Yes.
Now, at the time that you guys first had that class together back in September of 2011, how did you end up getting to know him any better than you had at the orientation in August?
The defendant sat behind us in class, so you usually in that class interact with people around you, and he sat behind us, so we got to talking. I don't remember the specific instance, though.
By the time that you had started talking to the defendant, had you already made some other relationships or friends at the Anschutz campus?
Yes.
Were they also in that class?
Yes.
Tell us who they are.
So the people who sat together were Ben Garcia, Tim Tapscott, and Charlotte Siska sometimes sat with us, and sometimes Emily Busta sat with us.
That last name, Charlotte, what was the last name?
Siska.
Can you spell that? Do you know?
Siska.
Okay, Siska. Okay, thank you. And do you remember the setting when you first started having a conversation with the defendant? And my question is going to be after that is, who started talking to whom first?
I do not remember who started talking to whom first, yeah.
Okay, and what was that like? What other observations did you make of the defendant in those early days of your class together in September?
He seemed shy and quiet. He seemed to take notes in class. Before I started talking to him, those were the observations I made.
Mm-hmm.
Yeah.
And when you started talking, was it about anything in particular or just the class that you were in?
The first conversation I remember having with him is talking about a study session that a big group of people in that class used to go to, and inviting him to the study session.
Did he seem open to it?
Yes.
Your Honor, may I approach the witness?
Yes.
With what has been marked as People's Exhibit 1243. Ma'am, take a look at that. And if you recognize what that is, would you tell us what it is?
Yes. I believe to invite him to the study sessions which we used to have at different places, different coffee shops around Denver. To tell him where it was going to be next, I took his number and gave him a missed call. And apparently it did not go through, so he found my email address and emailed me, giving me his number again so I could tell him where the study session was.
This People's Exhibit 1243, is this that email that you recall receiving?
Yes.
And this is a fair and accurate copy of the email that you received from the defendant on September 23rd, 2011?
Yes.
Doesn't look like it's been changed in any way?
No.
Your Honor, I'm going to move for the admission of 1243 into evidence, please.
Any objection?
I don't have an objection. If we could perhaps have her put her name on there so that later we know who this was sent to, since it doesn't have any to information.
Do you have any objection, Mr. Brucker, to
Not
her
at all,
putting
sir.
her name on there?
I think it's a good idea.
Okay, let's do that. With that then, P-TR-12, is it 1243?
Yes, sir.
All right, 1243 is admitted.
Can you, using your best print, write your name at the top of that, just so that we... Do you have a pen? I can get one for you.
There's one here.
Okay. And you know what? Do me a favor. Why don't you add today's date under there, just so that we remember when you testify? Do you know what it is?
Today is the 10th, right?
Yes, ma'am.
Done.
Thank you. Your Honor, I'm going to move for publication of 1243. It'll obviously be without the name and the date on it.
That request is granted.
Now, other ma'am, can you blow up the part next to subject? No, not that. After you see says, oh, that's not it. Ma'am, look at subject, and it says 2117. When it gets to all next to whatever that is, begins with, hey girl, can you put that up for us? Is this what he typed to you in the subject?
Apparently.
Okay.
Yeah.
And then can you give us just the rest of the text, the body of it? Now this right here, it says that, and he gives you his cell phone number. Is that the cell phone number you came to know belonging to the defendant?
I believe so. I don't remember his cell phone number, but I had only one, so.
And would you have put it in your phone so you didn't have to look it up ever again?
Yes.
Okay. And did he ever tell you the best ever world's greatest knock-knock joke?
I do not remember him telling me that.
Is this writing style and sort of the way he injects humor into it, is this consistent with how he communicated with you in writing throughout the time that you communicated with him in writing?
For the most part.
Thank you. Thank you. Now, after you guys had ended up exchanging cell phone numbers, did he end up going to that study session with you?
I believe, I don't exactly remember, but as far as I remember, he did.
Tell us the progression of how it went from we're two people in class doing study sessions together to something more.
So we started interacting more, and he and Ben Garcia became friends too. So the three of us started hanging out more, and I believe he asked me out on a date. I don't remember who asked whom out on a date, but yeah.
Would it be out of character for you to have asked him?
No.
But you just can't remember?
I just can't remember.
Do you remember what that first date was?
We went to a film festival in Denver.
What kind of film festival?
A horror film festival.
That's romantic. Did you do anything else before or after?
We grabbed dinner at some point. I do not remember if it was before or after.
Do you remember what period of time that was in terms of September, October?
Sometime in October.
After that, did you begin to see each other, and I'm going to use the term romantically, you tell me if that's wrong, romantically more often?
Yes. We would hang out together once or twice a week, maybe.
And when you hung out, what does that mean to us?
So we would go out or stay in and watch a movie and grab dinner, etc.
When you'd watch a movie, something that you would rent or something off of Netflix?
Netflix mostly, I would say.
Okay. And when you went out to dinner, any place in particular?
No particular place jogs my memory. There were, yeah.
Did you continue to hang out as a group with, you told us he became friends with a man named Ben Garcia. You'd also previously mentioned Tim Tapscott. Did you guys continue to do things together?
Yes, the four of us did things together often.
Tell us about them.
So we went on a hike to Dinosaur Ridge once. We used to play board games together often, the four of us, and also went for movies and stuff together.
You said you played board games together. Tell us what kind of board games you played.
Judge, I'm going to object to relevance.
Overruled?
Go ahead.
So I know we played Dominion, which is almost a card game kind of board game.
What is it? A strategy game? Is it a luck
So
game?
if you know Magic cards, it's pretty similar but much faster. It's a strategy card game almost. So they have their own custom cards, and it's a strategy card game. Yes.
Where would you guys play?
We would rotate between different people's places. Yeah.
Now, during this time, it sounds like you had the opportunity to observe him both at school and in places with just you and places with this group of a couple other people. Is that fair?
Yes.
I want to ask you to describe how the defendant's demeanor or presentation was in each of those. First, at school. How was he at school?
He was pretty shy and closed off at school. He wouldn't go interact with other people by himself at school.
And by interact, did you ever see him go up to someone and initiate a conversation with them?
Not that I remember.
Would he respond if someone approached him with a conversation?
Yes.
How was he in terms of interacting in that smaller group of, it sounds like, better friends, Ben and Tim and you?
I would say he was more forthcoming than he was in school, but he still wasn't extremely interactive.
How about when it was just you and he?
He would talk a decent amount then, yeah.
And was that a marked difference between what you saw when you were with him by yourself versus how you saw him in the classroom and at school?
A marked difference between those two, yes.
In each of those three settings, did you ever see him show a wide range of emotion, or was it pretty flat still?
He never had highs and lows of emotion ever, no. He was pretty calm for the most part and friendly if people interacted with him.
Now, did you get a sense of his sense of humor? And we saw some of it in the very first communication he had with you in an email.
In person, his sense of humor was, sometimes his jokes fell flat in person, and yeah.
What does that mean, his jokes sometimes fell flat?
So, I guess the best way I can describe it, sometimes in person when he made a joke, other people wouldn't laugh at it, or there would be forced laughs.
Did you perceive why that was? Was it the substance of the joke or just the delivery?
I don't exactly remember, but I'd say both maybe.
Now, did you discern a difference between how he was in person with a sense of humor and how he was in writing?
Yeah, his sense of humor in writing was mostly pretty funny.
Did he seem quick-witted to you?
In writing, yes.
Now, during this time now, we've started to talk about October and we're moving forward and you spent more time together. Is it still just the 1 to 2 times per week?
Yes, we had a pretty stressful class together 5 days a week and 8 a.m., so it was really hard to hang out during the week, really.
How did he seem to do in those classes?
From what he told me, it was about average back then, yeah.
Tough classes?
Very tough classes.
Okay. How big were these classes that you were in?
All the graduate students were in there, so I want to say around 60, 70 people, but I'm not sure.
Now, one thing that might happen as you become closer to someone romantically is you start hanging out on holidays together. Did you start doing that?
I don't remember anything about Thanksgiving. On Christmas, I was out of town.
Okay. Now, during the period between and Halloween, nothing?
I don't remember. I'm sorry.
That's all right. Yeah. Between October and the end of that first portion of your first graduate year, did you grow closer together?
We grew closer in November and December, I would say. Somewhat closer, yes.
What sort of things would you talk about when you would share?
We mostly talked about school. In December, he talked a bit about his family.
Okay. And I'm sorry, I don't mean to be indelicate here, but did you ever get to the point where you began to have a physically intimate relationship with the defendant?
Yes.
Okay. Did he, ever express to you that that was his first physically intimate relationship?
No.
In fact, did he tell you something different than that?
Yes. He told me that he had grown intimate with someone in camp. I believe in undergraduate, but I don't exactly remember.
And did he tell you where he went to undergraduate school?
I think UC Riverside. Not sure.
Okay. During this time also, did you begin to communicate other than just in person with each other?
On chat, Google Chat, and sometimes to make plans on text messaging.
All right, text messaging you mean by using your cell phones?
Yes.
And was that frequent or infrequent?
Not that frequent.
What was the second most frequent form of communication other than talking face-to-face?
Google Chat, so IMing each other, instant messaging each other on Google.
Okay. And did that, once that started, did that continue pretty regularly through the time that you were together?
Yeah.
Was there any other way that did you ever talk on the phone much?
Not much, no.
All right. As you approached the Christmas break, did you get some time off that you got to leave the school?
Yes.
Him too?
Yes.
Did you guys stay in touch over that break?
Yes.
And you didn't spend New Year's together?
No. I was out of town.
Do you remember about when you came back?
It would have been early January sometime.
Him too?
Yes.
And did you start back up again kind of where you'd left off in December?
Yes.
Was it different at all?
I was getting distant from him.
Why?
I had already told him in the start it would be a casual relationship, and I did not really feel much closer with him, so I wanted to break up with him.
Did you have a sense of how he felt towards you?
I think he liked me more than I liked him, but we didn't talk about it. So.
When he came back from, did you know where he went, by the way?
California to visit his family.
When he came back, did you spend time again together as you had before?
I don't remember exactly, but I might have reduced spending time with him a bit.
Do you ever remember him telling you that he had gotten mononucleosis?
No.
Given the status of your relationship, do you think you'd remember if he'd had
Definitely.
Kissing disease?
Definitely, yeah.
Okay, and never mentioned that to you?
He never mentioned that to me.
Did you observe any signs in him that he was suffering from some sort of illness, sickness, disease?
I mean, he might have gotten a cold once in a while, but everyone does, yeah.
Okay. So we're moving now through January. Has he talked to you at all about where he is with his rotations and his studies?
I believe what he said was his first rotation went well, and he was thinking of joining that lab. His second rotation wasn't going so well. So that's what he told me.
Okay. And this continues on until, how long do you guys continue to see each other before things change?
We kept dating until mid to end of February. I don't remember the exact date.
Did you say mid to end of February?
Yes.
Okay. And do you remember how it ended?
Yes, I don't remember if I texted him or called him, but I told him that I needed to talk to him. I went over and told him that I don't see a future with him, and thus I'm breaking up with him.
You went over to his place?
Yes.
Now, let me ask you some questions about that. How often would you go over to the defendant's apartment?
Maybe once a week.
Okay, and if you guys spent the night together, would it be there or your place or both?
I think both.
Describe for us the cleanliness level of the defendant's apartment.
His living room and his kitchen were extremely clean. He didn't like leaving dishes in the sink at all. His bedroom had clothes all around, so it was pretty messy.
Okay, in the times that you spent together, did you ever notice anything negative or different about his hygiene or the way he dressed or any of those issues?
No.
And was he consistent in that from the first time you saw him till the last time you saw him?
Yes.
At his apartment, when you two would sleep, since you would know, did you have trouble sleeping during this stressful graduate school year?
Yes.
Did he too?
I believe so.
Okay. Now you talked about these G chats, And have you had a chance to look at them, by the way?
Yes.
All right. Now, Your Honor, with the court's permission, I'd like to approach with what's been marked as 649.
You may.
Ma'am, I'm handing you what's been marked as 649, and you know we were just talking about the G chats, the Gmail chats. Have you had a chance previously to look at this exhibit?
Yes.
And does this contain the Gmail chats between you and the defendant over the period of time that you had a relationship?
Yes.
In fact, does it actually go a little bit past when you had a relationship?
Yes.
Now, you've had a chance to go through there. Is that a fair and accurate representation of and let me just ask, what's the right way to call it? Is it G-chat, Gmail chat, Google chat?
G-chat or Google chat, both work.
Okay, G-chat. Are these the fair and accurate copy of the G-chats that you had with the defendant?
Yes.
Do these G-chats also give us a glimpse into the communication style that the defendant had over the period of time that's covered here from roughly October through the end of March?
Yes.
Your Honor, I'm going to move for the admission of People's Exhibit 649 into evidence.
Any additional objection?
No additional objection, and again, I would request that she put her name on there.
Okay.
Thank
Any
you.
objection to that?
No, I was going to do that, but
Okay.
you should beat me to it.
All right. Please put your name on there. All right.
The date
And-
as well?
Yes, ma'am?
Yes, thank you. And based on my prior ruling, P-TR-649 is admitted.
Your Honor, can we approach?
Yes. All right, members of the jury, given the time, we're going to go ahead and adjourn at this time. It's almost 5 till 5, so we'll adjourn 5 minutes early. Big break there, right? All right, I want to remind you that you can't talk about the case with each other. You can't talk about the case with anyone else. You can't talk to any witnesses, parties, or attorneys about anything. You can't talk to any members of the media about anything. You must wear your juror badges at all time when you're on the courthouse grounds. You must avoid reading, viewing, or listening to any news or media reports about the case. You cannot visit any locations mentioned in the trial. You cannot start forming any opinions about the case and must keep an open mind. You must remember that neither sympathy nor prejudice for the prosecution or the defendant may affect any of your decisions in this case. All your decisions in this case must be based solely on the evidence and information presented in the courtroom and the instructions of law that I provide to you. And you must always keep in mind that the attorneys have a job to do, and sometimes that requires them to make objections or ask to approach for a bench conference. Please don't hold it against them when they do that. And similarly, don't infer that I'm for one side or the other based on my rulings. I'm simply doing my best to apply the rules of evidence and other applicable rules of law. And then remember what I said yesterday. I added yesterday that you're not to have any contact at all with any of the jurors who are no longer part of this trial. So if any of them contacts you, you must avoid the contact and just simply say, I'm not allowed to talk to you. And delete whatever message any of them may send without reading the message, obviously. You must avoid all contact. with that, get some rest tonight, and I'll see you tomorrow morning. This is a short week, so tomorrow is our Friday, if you will. So I'll see you tomorrow morning. Thank you, folks. Ms. Datta, you can leave as well. We'll see you tomorrow. Your subpoena's continued until tomorrow. You can leave that there. Thank you. All right. Please be seated, everyone. The record should reflect that the jury has exited the courtroom now. I think when I ruled on Exhibit P-TR-649 earlier, I think I kept referring to it as Gmail chat. So to the extent that I was referring to it as that, obviously I was referring to this exhibit, and I think other people have referred to it as that. But if it's Google Chat or G-Chat, the record should reflect that it's the same exhibit. Is there anything we need to talk about at this time on behalf of the prosecution? Mr. Proctor, do you have anything?
I do, Your Your Honor, I need to mark two photographs as, I guess the next numbers are going to be C-T.
Why don't you state for the record what each one of them is marked as right now in terms of your exhibit, and then how each one will be marked as in terms of a court trial exhibit as a result of having been offered but not admitted?
Your Honor, People's Exhibit 2526 will be marked as C-TR-53, and People's Exhibit 3054 will be marked as C-TR-54.
Okay, thank you. Anything on behalf of the defense, Mr. King?
I do.
Ms. Spengler?
Actually, Judge.
All right.
I know the court's already reviewed the crime scene video from the theater, and I just wanted to draw the court's attention to the fact that I expect that the prosecution will attempt to introduce that video tomorrow. The defense maintains its original objection. We would add a cumulative objection, and I can be more specific with where I believe the cumulative testimony lies with the witnesses. And I didn't want to know if the court wanted to re-review the video, so I'm just drawing the court's attention to it now.
I was just going to ask if I could review it again in light of the evidence that has been admitted. But if you have any specific arguments, I would like to hear them.
Sure, Judge. The defense, again, maintains its objection, and we would rely on the original arguments made in the pleading. But because we do need to supplement the record now that we're a number of weeks into trial, we do believe that it is now also cumulative to the testimony of Detective Matt Ingui, to the testimony of both APD investigators Nick Carroll and Maria Petalina. They would both testify about the evidence and the location of the physical evidence that was collected. Obviously, Detective Matt Ingui testified as to the location of the victims' bodies in the theater. And then we had a number of first responders who testified to the environment and to the scene within the theater, as well as the testimony from the victims and witnesses themselves from Theater 9.
Okay, thank you. Ms. Pearson?
Your Honor, and for the record, the crime scene video is People's Exhibit 1000. The crime scene video gives a unique picture of the theater because it begins on the outside of the theater, walking through the lobby into the theater, and gives you a different sense of how the theater looked at a time prior to it being processed, prior to the bodies of the deceased being removed, that you don't get from still photographs. It has a different kind of purpose because of that, because you get a different sense of context from it than you do from a still photograph, and especially given how early in the process it was done. Ms. Petalina and Mr. Carroll did not talk about the victims in the theater at all. The only person who did and placed them in the theater was Detective Ingui, and did that with still photographs. But to have a video that essentially walks you into the theater from outside, through the lobby, through the entrances that we've discussed, where you actually have to turn the corner to go around to get into the seats and enter into to the theater itself and up through the stadium seating, is an entirely different kind of picture. Again, it is not cumulative because it is different in some respects than other evidence that we've already seen in this case. And I would respectfully ask that we be able to admit it and have it published to the jury. It's about 45 minutes in length. I do have an extra copy here, which I'm happy to provide to the court.
Please. Thank you. I have reviewed it before, but I will review it again. I know I reviewed it before issuing amended order D98B, and I know that I ruled on it in that order, but I will review it again in light of the evidence that has been admitted and in light of the arguments presented today. I meant to ask the defense if counsel is asking me to give any kind of instruction with respect to Google Chat exhibit P-TR-649 in terms of any statements by Ms. Datta, so that the jury knows that those statements are being admitted only for the limited purpose of placing the defendant's statements in context and to allow those statements to be intelligible. Is the defense requesting such an instruction?
Yes, sir.
All right. I will give that instruction. Please remind me tomorrow if I forget. And then same request or same question with respect to exhibit P-TR-1227. Is the defense making a request for a similar instruction in terms of the statements in those emails, in that exhibit, that are not made by the defendant or that were not made by the defendant? Ms. Bedwick?
Yes, Your Honor.
Okay. I will give it as well. Please remind me about that if I forget. By the way, I indicated yesterday when I denied Mr. King's request to poll the jurors one by one, all 24 or 21 jurors one by one, in terms of whether they had heard any statements from any other juror about the case. I denied that request, but I said that I would include in my advisements at the end of the day that they have to tell me if they hear a statement about the case, even if it's from another juror. And I said that I would include that they should tell me even if that's happened before. And I did include that, so I wanted to make a record of that. I know that that doesn't, in the defense's view, that's not the same as what they were requesting me to do, and it doesn't cure the concern that they have, or it doesn't address the concern they have. But I stand by my ruling. I just wanted to make a record that I included within my advisements, specifically yesterday, that if anyone hears somebody else talking about the case, even if that somebody who's talking about the case is a juror, they need to tell my staff so that my staff can then tell me about they need to tell my staff that they want to talk to me. And then I said, even if that's happened in the past, you need to tell my staff so that my staff will let me know that you want to talk to me. So just wanted to make a record about that. Is there anything else that we need to talk about? Anyone? No. Okay. See you tomorrow. Thank you. The court will be in
Well, good afternoon. Welcome back to our 7 News newsroom. We certainly got very excited there. This is one of the most anticipated witnesses of the entire trial. And of course, when we get to the piece of evidence that we know we are going to spend time on, the piece of evidence that we've heard arguments about for several days, that we've been anticipating probably for several weeks, that's when the judge decides it's time to take a recess and start fresh in the morning. So after that, you heard a couple of bits of court business. There is a piece of 45 minutes or so video from inside the theater itself that is being considered as evidence, the judge making some records about his rules for the jurors, especially after yesterday's dismissal of 3 of those jurors. But let's go back to Gargi Datta, who was on the stand as we concluded the day, someone we've been waiting for all day, hearing now that we've got her explaining her course of the relationship with the defendant, James Holmes, how they went from being classmates in the neuroscience program to dating and then eventually breaking up during February of 2012, of course, just about 5 months prior to the shooting and just a couple months prior to the beginning of the formulation of the plan and all the purchases that we've heard about throughout the course of the testimony in this trial. Because this was so highly anticipated and because all of those details will matter. You heard George Brockler asking questions like, was the apartment in shambles? Was it dirty? Was his hygiene bad? Things that might typically be associated with the mental health. And of course, mental health is at center issue in this trial. And she spent so much time with him. Her opinions here are going to be, I think, important in the course of this trial. So what we'd like to do is we'd like to replay for you those 10 key minutes of her testimony, explaining their relationship. We'll come back and say goodbye on the other end, but tomorrow morning we'll hear the conversations, the documented chats and emails that she shared with the gunman. In the meantime, let's hear her explanation of their relationship.
Do you remember what that first date was?
We went to a film festival in Denver.
What kind of film festival?
A horror film festival.
That's romantic. Did you do anything else before or after?
We grabbed dinner at some point. I do not remember if it was before or after.
Do you remember what period of time that was in terms of September, October?
Sometime in October.
After that, did you begin to see each other, and I'm going to use the term romantically, you tell me if that's wrong, romantically more often?
Yes. We would hang out together once or twice a week, maybe.
And when you hung out, what does that mean to us?
So we would go out or stay in and watch a movie and grab dinner, etc.
When you'd watch a movie, something that you would rent or something off of Netflix?
Netflix mostly, I would say.
Okay. And when you went out to dinner, any place in particular?
No particular place jogs my memory. There were, yeah.
Did you continue to hang out as a group with, you told us he became friends with a man named Ben Garcia. You'd also previously mentioned Tim Tapscott. Did you guys continue to do things together?
Yes, the 4 of us did things together often.
Tell us about them.
So we went on a hike to Dinosaur Ridge once. We used to play board games together often, the 4 of us, and also went for movies and stuff together.
You said you played board games together. Tell us what kind of board games you played.
Judge, I'm going to object to relevance.
Overruled?
Go ahead.
So I know we played Dominion, which is almost a card game kind of board game.
What is it, a strategy game? Is it a luck
So
game?
if you know Magic cards, it's pretty similar but much faster. It's a strategy card game almost. So they have their own custom cards and it's a strategy card game, yes.
Where would you guys play?
We would rotate between different people's places, yeah.
Now, during this time, it sounds like you had the opportunity to observe him both at school and in places with just you and places with this group of a couple other people. Is that fair?
Yes.
I want to ask you to describe how the defendant's demeanor or presentation was in each of those. First, at school. How was he at school?
He was pretty shy and closed off at school. He wouldn't go interact with other people by himself at school.
And by interact, did you ever see him go up to someone and initiate a conversation with them?
Not that I remember.
Would he respond if someone approached him with a conversation?
Yes.
How was he in terms of interacting in that smaller group of, it sounds like better friends, Ben and Tim and you?
I would say he was more forthcoming than he was in school, but he still wasn't extremely interactive.
How about when it was just you and he?
He would talk a decent amount then, yeah.
And was that a marked difference between what you saw when you were with him by yourself versus how you saw him in the classroom and at school?
A marked difference between those two, yes.
In each of those three settings, did you ever see him show a wide range of emotion, or was it pretty flat still?
He never had highs and lows of emotion ever, no. He was pretty calm for the most part and friendly if people interacted with him.
Now, did you get a sense of his sense of humor? And we saw some of it in the very first communication he had with you in an email.
In person, his sense of humor was, sometimes his jokes fell flat in person, and yeah.
What does that mean, his jokes sometimes fell flat?
So, I guess the best way I can describe it is sometimes in person when he made a joke, other people wouldn't laugh at it, or there would be forced laughs.
Did you perceive why that was? Was it the substance of the joke or just the delivery?
I don't exactly remember,
Okay.
but say both maybe.
Now, did you discern a difference between how he was in person with a sense of humor and how he was in writing?
Yeah, his sense of humor in writing was mostly pretty funny.
Did he seem quick-witted to you?
In writing, yes.
Now, during this time now, we've started to talk about October and we're moving forward and you spent more time together. Is it still just the 1 to 2 times per week?
Yes, we had a pretty stressful class together 5 days a week and 8 a.m., so it was really hard to hang out during the week, really.
How did he seem to do in those classes?
From what he told me, it was about average back then, yeah.
Tough classes?
Very tough classes.
Okay. How big were these classes that you were in?
All the graduate students were in there, so I want to say around 60, 70 people, but I'm not sure.
Now, one thing that might happen as you become closer to someone romantically is you start hanging out on holidays together. Did you start doing that?
I don't remember anything about Thanksgiving. On Christmas, I was out of town.
Okay. Now, during the period between and Halloween, nothing?
I don't remember. I'm sorry.
That's all right. Yeah. Between October and the end of that first portion of your first graduate year, did you grow closer together?
We grew closer in November and December, I would say. Somewhat closer, yes.
What sort of things would you talk about when you would share?
We mostly talked about school. In December, he talked a bit about his family.
Okay. And I'm sorry, I don't mean to be indelicate here, but did you ever get to the point where you began to have a physically intimate relationship with the defendant?
Yes.
Okay. Did he ever express to you that that was his first physically intimate relationship?
No.
In fact, did he tell you something different than that?
Yes. He told me that he had grown intimate with someone in camp. I believe in undergraduate, but I don't exactly remember.
And did he tell you where he went to undergraduate school?
I think UC Riverside. Not sure.
Okay. During this time also, did you begin to communicate other than just in person with each other?
On chat, Google Chat, and sometimes to make plans on text messaging.
All right, text messaging you mean by using your cell phones?
Yes.
And was that frequent or infrequent?
Not that frequent.
What was the second most frequent form of communication other than talking face-to-face?
Google Chat, so IMing each other, instant messaging each other on Google.
Okay. And did that, once that started, did that continue pretty regularly through the time that you were together?
Yeah.
Was there any other way that did you ever talk on the phone much?
Not much, no.
All right. As you approached the Christmas break, did you get some time off that you got to leave the school?
Yes.
Him too?
Yes.
Did you guys stay in touch over that break?
Yes.
And you didn't spend New Year's together?
No. I was out of town.
Do you remember about when you came back?
I would have been early January sometime.
Him too?
Yes.
And did you start back up again kind of where you'd left off in December?
Yes.
Was it different at all?
I was getting distant from him.
Why?
I had already told him in the start it would be a casual relationship, and I did not really feel much closer with him, so I wanted to break up with him.
Did you have a sense of how he felt towards you?
I think he liked me more than I liked him, but we didn't talk about it. So.
When he came back from, did you know where he went, by the way?
California to visit his family.
When he came back, did you spend time again together as you had before?
I don't remember exactly, but I might have reduced spending time with him a bit.
Do you ever remember him telling you that he had gotten mononucleosis?
No.
Given the status of your relationship, do you think you'd remember if he'd had
Definitely.
the kissing disease?
Definitely, yeah.
Okay, and never mentioned that to you?
He never mentioned that to me.
Did you observe any signs in him that he was suffering from some sort of illness, sickness, disease?
I mean, he might have gotten a cold once in a while, but everyone does, yeah.
Okay. So we're moving now through January. Has he talked to you at all about where he is with his rotations and his studies?
I believe what he said was his first rotation went well, and he was thinking of joining that lab. His second rotation wasn't going so well. So that's what he told me.
Okay. And this continues on until, how long do you guys continue to see each other before things change?
We kept dating until mid to end of February. I don't remember the exact date.
Did you say mid to end of February?
Yes.
Okay. And do you remember how it ended?
Yes, I don't remember if I texted him or called him, but I told him that I needed to talk to him. I went over and told him that I don't see a future with him, and thus I'm breaking up with him.
You went over to his place?
Yes.
So we left off with Ms. Datta still on the stand and George Brockler, the district attorney, admitting the first section, I guess, of Google chats, conversations that she and the gunman had during their relationship and prior to the shooting. Tonight, we are not able to bring our legal analysts into the discussion, but that's actually kind of a good thing in a way, because we used that signal receiver to keep our signal online during the rain and lightning that blew through the area. And that's why the signal had been rerouted, and we can't pull Dan Recht in for his expert opinion, unfortunately, but it did keep our signal going, and that earlier in the day was why we had a momentary lapse in the signal during the second to last bit of testimony. So we do apologize for that. We certainly have things to talk with Dan about tomorrow, and once we begin to hear these emails and these chat conversations, I'm sure we'll have a lot more. So Dan and his colleagues will be back with us tomorrow. We just had to temporarily co-opt that signal receiver in order to remain with the trial. That said, today we are going to wrap up. I'm here obviously on behalf of Marshall, who's helping out with our television coverage of this same trial and the same testimony. And then of course the expert help of Erica Tinsley and Brian Hernandez. We thank you all for joining us. We will see you tomorrow morning at 8:30, and at 8:40 when court resumes, we'll start to hear about those Google chats. So we'll see you then.